Hey, what's up, guys? Welcome to Law Splaining the Interwebs. I am your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. And with me today already are two wonderful guests, both by the name of Andrew.
Andrew squared.
Well, it is a superior name to Nick, so I mean, I can't blame anybody.
Oh, that's weird. Legal Mindset's having technical difficulties. Oh, okay. Oh man. So how are you guys doing? We had a nice weekend break, and now we're back.
Back at it. It's nonstop, right, Andrew? Right, Andrew? I mean, it's nonstop right now with all the cases.
It's yeah, I mean, I basically took the weekend off, but it's dreading this another plodding day of prosecutorial nothing. They're gonna start bringing in like the courthouse cleaning staff.
Did you witness Kim Potter come in through the doors of the courthouse? Objection leading, Your Honor. I'll allow it. Overruled. Come on. Oh my gosh. How does PBS? Oh, okay, here we go. Who should I stream from today?
Court TV?
Question. I haven't even seen Court TV stream of it.
Oh man, they're slacking.
Yeah, they're the ones I think who won the lottery to provide the feed in general, but I haven't seen a Court TV feed. I got to figure out how they get the direct feed, that like how Law and Crime gets the direct feed from the courtroom or whatever. But anyway,
it would be crazy if you could actually like submit a petition to get the direct feed and then win.
Yeah. Well,
you might. I mean, listen, you go to YouTube and you Google Kim Potter trial, and Ricada's up there before Court TV.
Yeah,
that's what I'm saying.
Yep.
It's the way they did it this time was they put all the petitioners into a pool and they lottoed it, and that's how they got the direct feed for the camera in the courtroom. But yeah, I need
they basically have to share it with everybody, right? I mean,
yeah,
so it hardly matters.
That's the way it works out. I don't know what the big deal of winning it was, other than like having their name in a motion document. Yay, congratulations. You get to do all the work while everybody else watches your stuff.
And complains when the feed goes down.
Get grifted, bro.
Yeah. Fox 9 again. Okay, we'll do Fox 9. They when they actually put it up, I guess.
Wait, the Ocho isn't available?
Yes. Law LSPN or wait, it's ELPN or right, like
it might be
Entertainment
more
Law Production Networks.
It would be interesting every time there's an objection. Oh, objection!
Yeah. I wish I could speak Spanish enough to make it funnier. God,
I'm not even gonna try.
It's time to go back to college. Dun dun dun. Okay, here's the Fox 9.
You'll come out so woke, Nick.
Yeah, right. I'll come out expelled is what I'll come out of.
Well, after you go to ASU with Rittenhouse.
Yeah, there you go. That'd be fun.
Do you think he's actually going to get into like the in-person classes? Because that's what he's saying now, right? Is that he's going to go in person to ASU?
The ASU president. Oh, excuse me. The ASU president, I think, when the controversy kind of first came up, like he is going, he isn't going, or whatever. Basically, from what I understand, said, well, he never actually completed the application process, and if he had, he would be in. So then I guess maybe that's it. I have no idea. You never know with these places. They're weird. I don't know why you wouldn't want them at your school. It'd cut down on rioting by 10% at least. But you hope that's the only thing that I worry about. He's talked about now he kind of wants to be a defense attorney or whatever. Maybe it's a fluff statement. Maybe it's a real statement. But if he wants to be a defense attorney, the big thing is, are they going to let you into the school? Because they don't have to. They don't have to give you a reason. They don't have, they have enough reason to say, no, We don't want you in because it'll be too controversial.
Mhm.
Here, I'm just getting this guy off the screen.
Shit, he doesn't have to be admitted to the bar.
Right. He doesn't have to be admitted to the bar. And they could really hose him over that way. So hopefully they don't. Hopefully this all just kind of weirdly blows past him. But it's in the way our climate's charged right now. You wonder if it can.
But there must be some state that would admit him. I mean, go to Montana, be the 5th attorney in the state or something.
Of the trial.
Here's the thing, though. I don't know about his with you guys, but even in states like even in Florida, like I noticed the bar association specifically is getting more and more left leaning. The association, the people who are part of the apparatus, right? Not the state in general, but the apparatus.
Well, I lecture at law schools from time to time, and they're completely 100%, 150% woke. I mean, the loose pamphlets on the floor in the corridors, everything is critical. This, justice, that.
Yep, it's
even in Texas. I see people saying Texas. Even in Texas, guys, like go to University of Texas Austin. Like,
okay, is counsel?
Oh
ready
God,
for
never
the
tell
vote?
anybody to do that again.
Here we go.
Thank you, Deputy.
Oh, thank you, Judge. I'm not tired enough. Thank you, Deputy. All right. And by the way, guys, my panelists right now are also linked in the description. Their YouTube channels, so you can go there and check them out in case you haven't already. And if you haven't, what is wrong with you? But if panelists pop in during the day, I'll be adding them there as well. So anybody can be found quite simply by clicking on their names, and it'll take you right to their channel. What's up, Hanged Fox? Do people call you Hanged Fox? That's wrong. That's disgusting to me. Oh God. A pox upon the American education system. Let me see. Look at how Earl's standing. That's the Chad move. I don't button
Wow.
this jacket.
Is he wearing it as a chin diaper? He's
Kind
chin
of.
diapering it.
It's below the nose. But I just love that he's like, I'm not going to button my... Oh, no. He must have the feed on.
Is that the earbud in? Just a slight
Okay.
delay there.
Please be seated. Welcome back, members of the jury. I hope you had a good weekend.
Only 3 of them
And
showed up.
we're going to get started again here. The state may call its next witness.
Oh, God.
If Your Honor, the state calls Dr. Lauren Jackson.
Ooh, a doctor.
A doctor. And a lady doctor.
Wolfgang Deo says, bro, Balin Wonderworld is the game you've been waiting for, desiring, and would totally fall in love with. Best game ever, bro. Balin Wonderworld, huh?
Doctor, will you please come forward?
Angry Baneling says, Balin Wonderworld is mediocre
And
AF.
stand behind the witness chair just next to me.
Billy Witch Doctor says, Your Honor, who is this Miles Morales? It was my understanding that Peter Parker is Spider-Man.
I can't believe I fell for that.
And then state your
Everybody
full
did.
name and spell it.
My name is Lauren, L-O-R-R.
Not a
Oh,
lady doctor.
please remove your mask.
Not a lady doctor. No.
Oh.
First name Lauren.
The chat is very
L-O-R-R-E-N.
disappointed. It cannot simp.
Wilson, W-I-L-S-O-N. Jackson, J-A-C-K-S-O-N.
All right, doctor, things to keep in mind when you're testifying. The court reporter is taking down everything that's being said. So you have to answer with a yes or a no instead of shaking your head. Please no uh-huh or uh-uhs. We can't be talking over each other, so wait until the question's finished before you answer. If an objection is made, stop talking immediately and don't answer the question unless I tell you to, okay? If you don't understand a question, let the lawyer know. All right. Okay, counsel.
Thank you, Your Honor. Good morning, Dr. Jackson.
Good morning.
Where do you work, sir?
I work at the Hennepin County Medical Examiner's Office.
What's your job title there?
I'm an assistant medical examiner there.
How long have you been an assistant medical examiner?
I've been an assistant medical examiner for 12 years.
And are you a licensed physician?
I am.
And do you have a particular specialty that's associated with the work that you do?
I do. I have a specialty in forensic pathology.
What's your educational background?
Beginning in medical school, I graduated from the University of Arizona College of Medicine in 2002. That included a year as a post-sophomore research fellow in pathology. I then proceeded to the University of California at San Francisco, where I completed a pathology residency there that included a surgical pathology fellowship and a year as a clinical instructor at San Francisco General Hospital. Upon that completion in 2008, I went to the University of New Mexico in the Office of the Medical Examiner in Albuquerque and completed a year as a forensic pathology fellow. And upon completion of that in 2009, I came to Minnesota and I've practiced here ever since.
Do you have any board certifications?
I do.
And describe those for the jury, please.
Yes, I am board certified in
I'm on board right
anatomic
now.
pathology and forensic pathology.
Certified
Are
board.
you up to date with all of the requirements for being board certified?
I am.
Getting back to your role as an assistant Hennepin County
Does the jury
medical
know what
examiner, could
board
you describe for the
certification
jury what your job
entails
duties
in
are?
any way?
My job duties revolve around
I went to build the board.
establishing cause and manner of death and
I'm just
medical
glad
death
we finally get to
investigation,
find out who
particularly in
killed
cases
Dante
of
Wright and how
unnatural,
today.
unexpected, or violent deaths.
And does that include some investigation as well as some physical exams?
Yes, it includes quite a number of things: investigation, autopsies. We do a bunch of outreach activities in terms of education, but again, primarily it revolves around identification of remains and establishing cause and manner of death.
And is the purpose of an autopsy to establish cause and manner of death?
That's one of the major goals, yes.
Could you describe for the jury the method and procedure that you follow generally when it comes to the autopsy process?
We looked
The
at the
autopsy
whole.
itself or the whole approach?
The approach.
So the approach starts with information gathering. We have medical investigators that work for us that collect information pertaining to an individual's medical history, events that may have unfolded that pertain or might impact the cause and manner of death, the interpretation of that. Meaning we'll get reports from first responders or from law enforcement agents or from next of kin or other witnesses. And we'll collect that information as we proceed. Once we get that information, or as we collect that information, we'll proceed on to the autopsy portion, which is an examination that is external, then internal. And I can detail those if that's what you're asking for.
Sure, you mentioned
The
that there's an
external's
autopsy
on the
process
outside.
that involves an external and an internal exam.
Just
There are
once
also
I'd like one of these Emmys to show up wearing like
components of
a
that as well.
Star Trek original series Bones
Yes,
outfit.
so the external portion of our examination
And your
They're gonna-
conclusion?
includes
He's dead,
viewing
Jim.
the body in an as-is state, noting any kind of clothing or medical interventions that might be present on the body.
Are we going to get a surprise on the talk
collecting
screen
hair
that he
and
wasn't
fingernails,
on
depending
weed?
on
That'd
the
be
type of
interesting.
case.
It was actually
And
PCP.
also performing x-rays, depending on the type of case, potentially to look for injuries or retained projectiles that might be present. Once we complete that portion of the as-is examination, we will remove the medical interventions, survey the body again looking for injury or natural disease,
And none of this.
take photographs as we go
This is just more
to
filler.
document any findings. Once we complete that portion, we will clean the body, repeat
Again,
the exam.
What kind of
This is-
soap do you use to
Again,
clean the bodies? Like
scrutinizing
Dove?
for any forms of injury.
Well,
Well,
whatsoever.
actually, it's a
Natural
surgical
disease,
grade
things that
soap
might
that we
help
source
us
from
determine cause
3M
of
right here in the state.
And
3M
that
has
is the,
been working with
external portion
Ecolab
of
in
the
a
exam.
partnership also
Upon
within
completion
the
of that, we'll
state.
proceed to the
I could tell you
internal
about the
portion of
chemical
the exam,
process used to
which
create the
is,
soap.
More what people think of when they think of autopsies.
Can you purge
So
my
we will
memories with the
examine
same soap?
the tissues of the body from head to toe internally. We'll go organ by organ, looking for injury, evidence of disease.
So
or
first we
findings.
looked at the
We
big
will
toe on the
collect
right
tissues
foot.
for microscopic work. We'll collect tissues.
And it's not against the rules to just stipulate the
potential
fact that these guys are experts, right?
toxicologist
Just be like, yeah, we'll stipulate this
Sometimes
guy's an
we
expert.
perform, depending on the case, specialty
Yeah.
examinations.
I mean,
looking
yeah,
at,
if the prosecution will
dissecting the
stipulate.
wrists or the back or the neck, looking for injuries that might be hard to see externally.
But this is obviously just their
And you
trial
indicated
strategy,
that
right?
you
To
documented this
offer
process with
such an
photographs as
enormous
you go?
volume of
Yes, all the
nothing
way through the process.
that it looks like something.
And then do you ultimately draft a report as well?
I mean,
That is our goal.
there's
And are
no
there certain
mystery
types
here
of
as to how
cases within your
how
office that
he's
go
dead
through a
and who killed
secondary
him.
review
So
process with another
you could do this
pathologist?
quickly. You could
Yes,
truncate
all
this
children under
testimony.
6 and all homicides are reviewed by a second pathologist.
And throughout the course of your career, approximately how many autopsies have you conducted?
I've conducted myself over 1,800 autopsies, and I've assisted or trained other individuals on hundreds more.
Dr. Jackson, I'm going to direct your attention to April 11th of this year. Did you respond to a scene with respect to a death investigation on that date?
I did.
And how did you come to be involved in that case?
So yes, that was a weekend. It was a Sunday, and I was en route to home after work, and I was the doctor on call. And it happened that sometime after about 5 o'clock, I received a call from one of our investigators that there had been an officer-involved shooting in one of our areas that we cover. An officer-involved shooting is the type of case where a doctor does respond with the medical investigator. So we arranged a meeting point and carpooled to the scene, and
To reduce
when
our
we got there,
carbon
we,
emissions.
met up with one of the investigators from the BCA who had jurisdiction in the case.
So where approximately did you respond?
The site was in Brooklyn Center, and it was on 63rd Avenue North, I believe, at the corner of Catherine Drive.
And you indicated that you responded with someone else from your office. Who was that?
That was Stephanie Erickson, one of our investigators.
I'm sure we'll hear from her
And-
too.
Approximately what time of day was it when you arrived on scene?
What model
So I
car
got the
was it?
call after 5. The placard, which we fill out when we arrive at the site of the body, was.
Turns
the
out
time on that
Dante
was
Wright
6:11
actually
p.m.
died the same way all of us will, waiting for this
And
guy
you
to get to the
indicated
point.
Photos are typically taken by your office. Does that include also photos of your arrival on scene and observations on scene?
Yes, part of our field examination includes
Taking a
photography of the
shitload of
substance
photos.
of the body and things around the body.
In addition to the photographs during the
Couple
autopsy
TikToks.
process?
Correct, and separate from.
Your Honor, at this time, the state would offer exhibits.
Dr. Jackson,
99,
have you ever twerked over a
102,
body in a TikTok video?
105, 107.
It was slow during COVID.
108, 110, 114, 116, 118, 119
Here, I'm gonna
through
I'm going to turn the volume up on the
125,
stream a little bit because we're apparently a little
127,
loud.
141, 143, 145, 146 for demonstrative purposes, 147 through 149, 152, 155, 157, 158, and 160.
Every photo
Is there
ever
an
taken
objection
in the
to those
20th century.
exhibits? Yes, okay. And I ruled on those objections. Those exhibits will be admitted.
Thank you, Your Honor.
I'm going to read the instruction on demonstrative evidence. The state is about to introduce a computer-generated animation. This does not serve as proof of any facts in itself. It is
It'll be Kim
presented
Potter in a
only to
KKK
aid your
outfit.
understanding
Pinch and
of
zoom,
a
pinch and
witness's
zoom.
testimony or other evidence here in court. If the animation is not consistent with your evaluation of the testimony or other evidence, you should disregard the animation and determine the facts from the underlying testimony or other evidence.
Is it going to be a
Thank you, Your Honor. Just to be clear, for the
Confederate
record,
flag
all of the
labeled
exhibits
bullet piercing
are
through
offered
3D
substantively with the
organs?
exception of 146, which is offered for demonstrative purposes.
Boy.
At this time, I would ask that we put Exhibit 99 on screen, please.
Anti-BLM rounds.
What if
All right,
you
Dr. Jackson,
introduce
do you see a
demonstrative
photograph in front of
anime?
you?
I do.
Well,
And
that's
looking
pretty
at
much
that
half the
photograph, could you
YouTubers right now.
describe what you observed when you arrived on scene on April 11th?
Yes, we came in from the west. This is a view looking east, And what we see here as we approach the scene were 2 damaged vehicles, some debris in the middle of the roadway, a number of squad cars. Off in the distance, there are police tape markers there. We did notice media present and a large crowd gathered beyond the barrier.
And then if we could put exhibit 102 on the
I hope
screen,
those
please.
vehicles got counseling.
You described observing vehicles. Was there also a tent location that was set up behind one of those vehicles?
Yes, adjacent to this white vehicle, which was reportedly the decedent's vehicle, is a greenish color tent that was erected over the body for privacy purposes.
And did you ultimately enter the tent?
We did.
And what information did you have at that time when you arrived on scene and went into the tent to look at the body?
We were briefed by a special agent from the Minnesota Bureau of Criminal Apprehension and got a little bit more information, namely that a short distance down the road from here, the decedent had been pulled over at a traffic stop and was injured, shot, and managed to drive his vehicle a short distance, and it crashed here at this point where you see it. The individual was unresponsive in the car, removed from the car by law enforcement, if I recall, and pulled a short distance to the grassy yard.
He's testifying to
tent
facts
was
he didn't
erected
witness.
sometime
This is
later.
great.
And did you
For
learn
no
the identity
reason
of
also.
the individual who had passed away?
We had a
This is
tentative
hearsay.
identity.
Right? The
Of,
BCA
Dante
agent
Wright.
told me this.
And was that identity
He already
later
testified to
confirmed?
this.
And
It
and
was
he's
later by
saying it
fingerprint.
in such a mind-numbingly boring way.
If we could put exhibit 103 on the screen, please.
It'll be another foot further down the sidewalk.
It's like
You
playing
indicated that
Miss.
you
Like-
entered
like a
the
flip
tent.
chart.
What was the condition of Dante Wright's body at that time?
This is the view we saw, less the placard that we put on the body, but the body was lying
Yeah,
in the grass, covered by a sheet. As
They won't be
depicted here. You
showing
can see some
any of the
clothing
body
emerging
pictures.
from the sheet. There were
At the
some medical
request of the
interventions
family.
and other wrappers on the ground.
Wait, is that
If we
real?
could put exhibit
Yeah.
105 on the screen, please. Could you describe what you did after observing the body with
Won't
the
be
sheet?
broadcasting.
Yes,
I should say.
after
Broadcasting.
the field examination portion of our work. And we removed the sheet, exposed the body as you see it here. Again, looking at different medical interventions that are present, the clothing that is somewhat disturbed, likely due to medical intervention, the process of medical intervention there. And we've placed our placard with pertinent information known at the time over the body
How do
for
you
this
spell
identification photo.
Pertinent?
And then you indicated that the placard had a time. Is that the 1811 that's noted there?
Yes,
And would that be 6:11 p.m.?
correct.
And the ME staff noted there as Erickson. Is that Stephanie Erickson from your office?
That is correct.
Could we put exhibit 107 on the screen, please? Did you make some closer observations of the body on the scene?
Yes, we did. We've taken a number of photos. This particular photo is a close-up of the left side of the decedent's body. And what's depicted here are a number of medical interventions. The one centered in the photo is a clear adhesive patch and occlusive dressing that's placed over a gunshot wound. There's some dark discoloration that you can see there in this image, and that is dried blood, essentially.
And after observing the body on scene, what did you do next? If we could put up exhibit 108 so you could describe.
So after we complete our field examination, which entails, again, looking at the body and the items surrounding it and on it, we'll gently roll the body and examine the back, again, searching for potential injury.
Gently.
Once we have completed our field exam, we will bag the hands, which means putting paper bags over the hands to potentially preserve any trace evidence that might be there. Then we'll carefully put the body in a body pouch and seal it with a zip-locking tag, which is pictured here. This is the yellow tag going through the zipper pulls.
So this is
And that's
just an
labeled with the
opportunity for the
decedent's
state to
medical
show the
or
jury
the
1,000
decedent's
pictures
ME
of
number,
the
which
dead
we've
Dante
established.
Wright.
The date
Even
and
though
time
it's
of the bag
cumulative,
seal,
even though
additional
it's-
witnesses.
Uncontested.
And when you
Yeah.
describe
No, it was
the date
contested.
and
They
time
objected
of
to all
the
this
seal and
on
initial by
Friday.
witnesses,
No, I mean,
is
no one's
this here
contesting the
that seal
cause
that
and
you're
manner of death.
describing?
Oh,
Yes,
okay,
yes.
yeah.
and it indicates 4/11/21, 18:35. Would that be 6:35 p.m.?
Yes.
It's far
What
more
does that time
prejudicial than
indicate?
probative to
That is the time
repeatedly
that
show
I filled out
pictures of
that
this
bag
body
tag
to
and sealed
prove
it
what?
on the pouch.
So would that have been the approximate time you would
Remember,
bagged
they
the
get
body?
to use spark of
Yes,
life evidence to
directly.
show that this
It
is
would
a
be
person.
1
They
minute before
don't
that we
need
put
the
the body in the
autopsy
bag.
photos to
And then
show
the initials
to
noted
show
there,
that
whose
this is
initials
a
are
dead
those?
person.
Those are Stephanie Erickson, the investigator, and LJ, my initials.
And after you sealed up the body, what was done with the body?
So in the field, this is a picture of the bag as we saw it the following morning. But after we seal the bag in the field, the body is transported to our office. And we have a transport company that actually effected this move, and they arrived shortly after we did at the scene.
That's capitalism, a
And was
third-party
it the
company
next
that
day
moves dead
on
bodies.
April 12th
That's when your city has
you
arrived.
began the autopsy process?
It's actually a very
Yes.
high-paying job.
Did you start with x-rays on the morning of April 12th?
Yes, in cases of gunshot wounds, we identify potential sites of injury and get x-rays of those so we can identify potential locations of bullets to make recovery easier the following day. So that did occur the morning of the 12th.
And if we could put Exhibit 110 on the screen, please. Could you describe for the jury what's shown here?
Yes, these are side-by-side images of Dante Wright's chest. And you can see there's a number of things going on here. On the left-hand image, which is an anterior, posterior, or front-facing view, you can see a number of wires of medical interventions.
You say an anterior, posterior?
Decedent's right side, which is the left side in this view, we're looking at the images. If we're looking at the patient, you can see a bright white object, and that is a retained projectile.
And if you could use, there's either a stylus like this or your finger to circle the item that you're describing on that image, please.
No, Angry
There,
Baneling,
circle
none of
the
the images of
retained
the body are
projectile.
being shown at the request of the family.
And then after
No streams have it.
taking these x-rays, did you slightly later in the morning start the full autopsy exam process?
Yes.
And did that include, as you described earlier, examining the body as it was before cleaning and doing additional further examination?
Yes, that's standard procedure.
Could we put Exhibit 114 on the screen, please?
Britt Kormeyer says, why are we still on this accident after the shooting? This is part of the reason trials cost so much because the state
Could you
is running up
describe
the
what's shown
clock
here,
on the
please, in
defense's
Exhibit
budget.
114?
Yes, we take pictures of the body as is.
Nailed
so this
it.
is after I have broken the seal on the body bag, and without disturbing the body or any of the contents, we take the as is photograph. So this is a view of the lower half of the decedent's body. You can see jeans there. There's a single shoe on the left foot, a sock on the right.
Because that's relevant.
And the condition of the clothing and body as it is depicted here, was that as it was on scene when you had observed the body the day before?
Yes.
Could we put Exhibit 116
Are we talking about his
on the
toenails
screen,
now?
please? What's shown here?
No, this
So this
isn't
is a
Darbury.
photograph that is one image more superior or towards the head relative to the picture we just saw. I've placed a privacy towel over the decedent's privates. And what we're seeing here, again, is a view of the body similar to that as we saw in the field. You can see medical interventions, clothing as we saw it in the field, and particularly medical interventions overlying gunshot wounds of the chest here.
So at this point, all of those medical interventions are still attached to the body. Is that right?
Yes, this is the very as is photograph, so we haven't manipulated those interventions in any way.
If we could put Exhibit 118 on the screen, please. Did you do some further examination of those seals that you had described and sort of continue to look in those areas?
Yeah, so as I alluded to earlier, we take photographs and document what we see initially, and then we remove in a stepwise fashion the various clothing articles and interventions. What we're looking at here is the injury on the lower
Ooh,
left
I'm
side
gonna
of
use
the
that
chest,
next time.
and I've peeled away the occlusive dressing that was placed.
Hot time with Lady
in the
Rackets.
field.
I'm going to remove your clothing in a
And could you
stepwise
please, for
fashion.
the jury, just describe the difference between an entrance wound and an exit wound?
I think you just turned off
General,
everybody
and
west
then
of the
as applied
Mississippi.
to the images that we see.
Yes. In general, entrance wounds, entrance gunshot wounds have a circular or oval appearance. There's usually some missing tissue in the center of the wound. There can be abrasions around the edge of the wound. This particular image that we're looking at here does show
Hollow
a
point.
wound that has those features. We will see a cleaned up version of this in subsequent images.
It is hard
And when you say those features, is what you observe here consistent with?
Surprised they
an
didn't
entrance
use
wound?
like a
They are.
orthoscopy scope to go
And if we could
through
put
the
exhibit
bullet
119
wound
on the screen,
live
please.
in real time.
Could you describe what's shown here, please?
So this is the picture of the right side of the chest, again with the occlusive dressing peeled back, showing an area of injury. It's difficult to see here due to the presence of blood, but this is the opposite injury.
And when you say opposite injury, would you characterize that as, how would you characterize that?
Yes, we will see that the injury on the left side of the chest is an entrance wound, and this will be shown to show features of an exit gunshot wound. It happened when we peeled back this dressing that you could actually palpate or feel the bullet directly below the skin adjacent to this wound. So that was a definite clue that this was the exit side.
And then after removing the item, removing the medical interventions, removing the seals, documenting that process as you went along, did you ultimately clean the body and then continue to do further
I would object to leading.
investigation or examination?
Yes.
Just to be a jerk.
If we could
Objection,
put exhibit
tiresome.
120 on the screen, please. Could you describe what's shown here, please?
So this is a view of Mr. Wright's chest from the front, and pictured here are the entrance and exit wounds. May I mark
Yes, you may.
these areas? So again, on the left side,
I'm asking the
here,
questions
on the
here,
right
doctor.
side here are the gunshot wounds in question that we've looked at initially.
And what, if anything, is significant to you about the positioning of these two injuries?
Other than the fact that they are on the front side of the chest, the anterior side of the chest, and there's a little swelling around these wounds beneath the skin, suggestive of hemorrhage. Those are the major findings.
They form a
And-
swastika.
I'll ask you some more about this as we go on to your internal examination, but looking at the body externally, did this give you any indication with respect to trajectory or a bullet path?
It would have blown up his heart.
Yes, again, given the fact that there was a bullet present on
I
the
can
right
tell
side
that
of
she
the
hated
deceased's
him
body,
from the angle of the
and
shot.
an entrance defect
The
on the
shot
left
had
side,
extra
it
malice
suggested,
behind it.
Rightward
With a side of
progression the
recklessness.
bullet through the body.
And if you could just indicate with your finger the direction of travel that you're
on
describing.
the side.
Yes, so a bullet entering approximately near this red dot, but below it would have traveled. In
When you
this
say the
general
bullet
direction
entering
here,
near this
as I
red dot,
indicated.
you mean the dot from the laser sight on Miss Potter's
And then if we
gun.
could put exhibits 121 and
I hope they show the animation, because that's not the body, right?
122
Yeah.
on the screen next to each other.
Have they showed the whole video yet?
If Your Honor, if you could clear the screen, please.
Yeah.
End to
Thank
end?
you.
I mean, it's yeah. They've showed the
Could
video
you please
several
describe for the
times
jury what's shown in
Okay.
exhibits 121
from
and
different
122?
angles, different cameras.
Yes, so this is a left side view of the body in the left hand.
Two dash
photograph.
cams and 3 body cams
We've
worth
looked
of
at this
video have
from
been
the
shown
front
of the
and
same
with
incident.
The occlusive dress
Oh, we've
peeled
got at least
partly
7
off,
more then.
dressing peeled partly off. What we're seeing here is the clean version.
You got to show it in
On the right hand
CPM.
side is a zoomed in image of the
IMAX.
wound on that left side of the body.
And as part of your autopsy process, when it comes to gunshot wounds, do you typically look for things like soot or stippling on the body?
Absolutely.
bringing the
In
Rittenhouse
addition to
imaging
trying to
expert to the
assess what
state.
an entrance
Yeah, I
and
don't know
exit
how
wound
this
might
stuff
be,
works.
we try to assess.
We just
for
enhanced it.
clues as to
And
range
click
of
the
fire.
enhance button.
And sometimes these are present, sometimes they are not. When we have, for instance, evidence of a muzzle abrasion, so markings on the skin suggestive of contact. with
Shensi Bo
a-
says, but maybe there's still
a gun,
FBI
then
drone
we
footage
know
to
it's
show.
a contact range. If we fire, if we find evidence of soot or gunpowder deposition or gunpowder stippling, which is a punctate or dot-like abrasions on the
All
skin
stuff that didn't happen.
that occur based on the impact of gunpowder, we can say that
he was
a intermediate
wearing
range of fire, so
clothing.
between
Of
contact
course,
and
his shirt
2
was
or 3
pulled up a
feet
bit,
at
so
most.
maybe.
In this case, we found none of those identifiers, none on the skin and none on the clothing. So we settled on indeterminate range of fire, given the lack of specific evidence.
And just to
Our helpful
clarify, when you
conclusion,
say you saw none
indeterminate.
of those, you did not see soot or stippling, is that correct?
Correct.
And when you say indeterminate,
Everyone
maybe
knows
just describe
stippling
to
now
Drake,
because of the
what does it
Rittenhouse
mean to
trial,
have an
though. I will
indeterminate
say.
range of fire?
So
I
indeterminate
just love
range
that
of
they've
fire
gone through the whole
simply means
explanation
that
about
we don't have
stippling when there
specific
wasn't any
clues
to
as
talk about
a
at
definite
all.
range of fire. So
I wonder why.
the possibility of interpretation.
We did not have sufficient evidence to make a
If we
determination
could put exhibits
about
123 and
the
124
range
on
of
the
the gun.
screen,
But
please,
thank God
next to each
there's
other.
27 videos of it.
I mean, this could have been a 2-day trial from beginning to end, from opening statement to closing to deliberations and verdict.
Dr.
2 days.
Jackson, exhibits
you
123
wish.
and 124 are on the screen. Could you please describe what's shown here?
Yes, the image on the left shows a gunshot-related defect.
There's no
on the
stippling
right side
because
of
the
body.
Potter used a
And
taser.
the image on the right is a close-up photograph of that same injury.
And how would you describe this? I know you had initially used the term maybe partial exit wound. Do you have another way of describing this injury as well?
Yes, let me just explain what a partial exit wound is. If the bullet goes in and out of the body, you have a classic exit wound. And in this instance, because the bullet made a defect, made a hole in the skin, but did not leave the body, we call this a partial exit. And this occurs when there's not enough velocity for the bullet to escape the body. We see this on occasion. Other features of this injury that we see are areas of red-brown abrasion and that are present on the edges of the wound. And this is something that is consistent with what we call a shored exit. And this can occur when the skin is pinched between the bullet, which is pushing outward on the skin, and rubbing against some other object. In this case, it's likely the clothing, the decedent's clothing, such that the skin gets pinched there and a rub spot occurs and an abrasion is formed.
Now, Dr. Jackson, before we get to your internal exam,
so you
I'd
guys
like
know,
to ask about the rest of the
This
body.
is how
Did you
this
also
would go,
examine the rest of the
even if
body
this wasn't
for injury?
politicized. The
Yes.
state would waste the
And
time
if we
on
could
this.
put exhibit
If it were you
125 on
and
the
not
screen,
political,
please.
the state would be burning your money instead of Potter's money.
This is why reform is something that I
Can you
hope
describe
more
what's
people
shown in
are
exhibit 125,
savvy
please?
to.
Yes, this exhibit shows a close-up of the decedent's face and neck area. And on this image, which is a cleaned image, we can see areas of abrasion on the right nostril region and what is a laceration with some abrasion below the right
You're
lip.
showing pictures of his face and neck, non-fatal injuries. I
And
wonder
if we could put
why.
exhibit 127 on the screen, please.
It's not like they totally would be prejudicial.
Could you describe what's shown here?
Yes, this is a picture of the decedent's lower lip. And on that right aspect of the lower lip, you can see a laceration. This actually communicated with the.
Well, they'll argue
abraded
that Potter should have foreseen the car
lesion
crash,
on
right?
the
So this is
prior
all her
image.
responsibility too.
Yes.
And how would you characterize these
But he wasn't wearing a
injuries
seatbelt.
to the face that you saw in exhibits
In his
125 and
high-speed flight
127
from the-
on the
in the
lip
Verizon-
and the nose?
From the cops.
So we call
yes.
these superficial blunt force injuries.
And when you say superficial,
Well, if Potter hadn't shot
what
him,
does
it would
that
have been a moderately
I would
speeded
say
flight.
that these injuries are non-life threatening,
At the speed limit.
particularly in with respect to comparison with the gunshot wound.
are they consistent with the circumstances that you were aware of surrounding the time of death, including a potential vehicle collision?
Yes,
Were these injuries significant in any way with respect to your finding of cause and manner of death?
no, the blunt force injuries that we identified on the body did not contribute to the cause of death.
And did you also examine the rest of the body for other injuries as well?
Yes,
We stopped.
Did you
at the
find
face.
some other superficial injuries?
yes, there were other superficial abrasions and some bruises or contusions.
Bruises and contusions, were those on things like the arms and legs?
Yes,
Could you just provide sort of a general overview of the types of things that you saw?
Yes, so small abrasions were found on the arm and forearm on the left side. For instance, these appeared much like rug burns in terms of their degree of depth. So again, superficial injuries. There were some minor abrasions on the right and left sides of the back, very much like simple scratches. And there were some contusions or bruises on the lower extremities as well, around the knees and the thigh on the left side.
Were any of those injuries that you observed that you described as superficial, were any of them significant with respect to your findings of cause and manner of death in this case?
No.
Would they all be consistent with the circumstances surrounding death, including a vehicle collision?
Certainly the collision or the process of extrication and resuscitation.
And when you discuss extrication, did you also observe some dirt or grass on the body as well before it was cleaned?
Yes, there were a few streaks, linear marks, as if someone had been pulled across dirt. Yes.
And by grass,
Were
we
those
do not mean
consistent
marijuana.
with what you understood to be the circumstances surrounding the collision and the extrication from the car?
Yes.
All right, getting back to what was the most significant injury with respect to your exam?
Far and away, the gunshot wound to the chest was the most significant injury.
Now, getting back to that gunshot wound, you told the jury a little bit about your external exam and your observations there. Was the trajectory in that bullet path further evidenced by the internal exam that you conducted?
Yes.
And then with respect to that internal exam, did you follow that same protocol, that same procedure that you described earlier?
Yes, it was just bloodier.
And did that include examining the inside of the body and the organs as well?
Yes.
And conducting that part of the exam, were you also able to determine what organs had been struck by the projectile inside Dante Wright's body?
Yes.
Was
and then
there an
did you
exploded
ultimately
heart?
recover a projectile as well?
I did, yes.
And where was that projectile recovered from approximately?
Yes, so that projectile was recovered from the skin or below the skin on the right side of the chest wall near the fourth intercostal muscle. And that's between the level of the fourth and fifth ribs approximately.
If we could put exhibit 141 on the screen, please. Could you describe what's shown there, please?
Yes, so this is an image. We've progressed to the internal portion of the examination, and this is a view.
Could you imagine if the
Mr.
medical
Wright's
examiner
chest with
sounded
the
like
skin
Axl
reflected.
Rose?
So what we're looking at are the ribs
Weird.
and the breastbone, and you can see areas of hemorrhage on the left and right side of the body that are consistent with the points of entry and exit of the bullet through the chest wall.
And could you just indicate on the screen where those areas of hemorrhage are, please?
Yes, so these are the dark areas present here and on the right side in this vicinity.
Okay. And then was there could you indicate the approximate area where the projectile was recovered as well?
Yes, the projectile would have been recovered. So the defect in the muscle on the right side is approximately here. So the projectile was recovered near where I made an attempted asterisk.
And then if we could put, just a moment.
Oh yeah, actually,
We could
this
put
would be
exhibit
way
143 on the
worse
screen, please.
if it was if this guy had the cadence of the ballistics
Can you describe
expert
what's
from
shown here?
Rittenhouse.
Oh God.
Yes, so this might be a little bit disorienting. This is a view of the chest plate that we've removed.
What I want to know is if
And it's
Dante
viewed
Wright
from the
tested
inside.
positive for COVID.
So,
'cause then it would really
what
be a
we're
COVID
seeing
death.
here are the ribs, and we're seeing the
Did you receive COVID
perforations
funding
through
for his death?
muscle
He was put on a
on
ventilator.
on the
He was
left-hand
the first
side.
Omicron variant death.
And there's a probe that's inserted to demonstrate the approximate path of the bullet. And again, this is inside the chest. So the left side is the decedent's left side, and the right side is the decedent's right side.
And do you, through the course of your work, sometimes use rods or probes like this to help you establish trajectory or a bullet path?
We do.
And if we could put exhibit 145 on the screen, please.
Oh God!
Could you
Now they're
describe
showing
what's
a
shown here,
trajectory
please?
rod going clear
Yes, this is
through
a
Dante
review
Wright's body.
or the exhibit that shows
If he
the
wasn't
damage
dead,
to the
he
front
is
of the
now.
heart, and
As we
there is
stab a metal rod into
gap
his
in the
corpse.
tissue covering the right ventricle, the left ventricle, and
The chat has
muscular
been
septum
asking,
that
did you
divides
poke
the
it
two
with a
ventricles.
stick? So yes, chat.
When you say gap
The
in
question
the tissue,
has
maybe
been
you
answered.
could
They
just
did.
describe what you
I mean,
mean
the
by
stick
that.
was called a probe,
Yes,
but you
there,
know,
there is normally, instead of being able to see inside of the heart, there's tissue and blood vessels that would span this gap, this defect that we're seeing in the heart wall. And they're
So-
missing here in this image.
And in a normal heart, a healthy heart, would that all be covered up?
Correct. It would look more like the surfaces that you're seeing at the very top of the image.
We could put exhibit 146 on the screen, please.
I
Virtual
mean, if
loaner
this was the
system.
1970s, Kim Potter would just be like the
Now,
newest
using
member of
this
the A
image,
team.
could you please
Yeah.
describe what organs were impacted and what you observed on the inside of the body with respect to the trajectory?
Yes, I selected this diagram, and I would point out that it is a diagram in 2 dimensions, so it doesn't capture exactly the orientation in the body, but it does show the general pattern of injury. So
This is the
there is an
demonstration
arrow
purposes.
superimposed over the heart, and depicted in this diagram. The
this
entrance
is like
point
local
Look
news
how
quality.
big
was
hearted
somewhere
he
near
was.
the base of the arrow, and the bullet was recovered somewhere near the tip
His
of the
heart
arrow.
was 10 times
So
the
you can see,
size of a
even though that
normal boy.
the wound
Well,
direction
didn't
was
they make
shallow
that
through
argument
the,
in
through the
Chauvin?
chest, as we saw in the previous image,
I think
it did
so.
They're like, he had a big
cross
heart.
areas of the left lung, the heart, and the right lung.
It's called myocarditis. Oh my gosh.
This is demonstrative.
Clearly, you've had your booster.
evidence. It will not go back to the jury room with you.
Thanks, Judge.
Dr. Jackson, I know I didn't show you photographs of the lungs, but could you describe for the jury the damage to the organs in the body that you observed consistent with this demonstrative exhibit?
Yes, both the left lung and the right lung, the anterior portions, or the portions abutting the chest wall in the front, were damaged, almost a graze wound, but very superficially injured by the bullet. The majority of the injury was to the heart.
Did you also recover a substantial amount of blood from inside Mr. Wright's body during this process?
Yes.
Approximately how much blood did you recover?
So the combined volume from both sides of the chest, so around the right and left lungs and the heart, were over 3 liters of blood.
And 3 liters, why is that significant?
That's significant because an individual of Mr. Wright's size would have approximately 4.5 to 5.5 liters of blood in his entire body. And when you lose half of that rapidly, your condition becomes critical.
Are doctors worse than lawyers at math?
And when
That
you
wasn't
say
half.
critical, what does that mean?
It's a life-threatening situation.
You're muted.
You're muted, Andrew.
Andrew,
With
you're
respect
muted.
to timing, was this gunshot
Still
wound,
muted.
the injuries that you
Oh,
observed
now you're back.
through the heart and the lungs, was that a survivable injury?
Went offline.
As a
Everything's
forensic
fine on my
pathologist, I
end.
would say no.
How long does it take for someone to die after being shot through the lungs and heart like this?
Injuries like this, we refer to survival times in terms of seconds to minutes in these types of injuries.
And with respect to loss of consciousness, how long does it take for someone to lose consciousness after an injury like this?
Well, one can lose consciousness within 10 to 15 seconds after blood supply is cut off to the brain.
Now, Dr. Jackson,
I think we can
Do you
pinpoint the
have,
moment
throughout
that
your
he lost
experience
consciousness
as
is when the
an
car
assistant medical
swerved
examiner,
across into the other
um,
lane.
experience with a variety of different types of ammunition of different calibers.
Yes, that's part of our training.
And have you observed
Is this the optimal
and
murder
recovered
caliber, would you say?
projectiles of both large and small caliber?
Just a full
Yes.
metal jacket through the heart would have been fine.
If we could
Just
put
buff that out.
exhibits 147 and 148 on the
Isn't
screen
it
next
true
to each
that
other,
the police
please?
have ammunition that will dodge the heart intentionally to prevent death?
You indicated that you recovered a projectile. Could you just describe what's shown here, please?
Yes, so this is the image on the left and right show front and back views of the projectile that I've recovered. It's a clean view. What we're seeing here is a projectile with an expanded tip. It's a copper-colored jacketed
Did they say there
projectile
what the round
with
is
a
on
lead
that piece
color
of paper?
core. And the image on the
Nope.
left shows the base view of the projectile, which had
Not
a
to come
measured
across as
diameter of 9
cold-hearted, but that's pretty
millimeters.
textbook expansion right there.
And with respect to your measurements, would that be
No, it
consistent
is.
with the
Yeah,
9
it's a-
millimeter round?
Basic.
Certainly would. And,
And
those are measurements
After
I
that
made
bullet,
at the
you're
time
not
of
the only
autopsy.
cold-hearted one.
And when you describe the expansion or the condition of the bullet, maybe you can contrast that with other bullets that you've seen.
Well, I think what we're seeing here is a bullet that does show an expanded tip, and some people call this mushrooming, the appearance that we're seeing here. Others see a petal-like arrangement, and this can happen in certain types of ammunition.
And would that be consistent with a hollow point round?
Yes, hollow points often look like this.
And what, if anything, in your experience as an assistant Hennepin County medical examiner, is significant about a round of ammunition that displays this type of effect, this petaling or mushrooming?
I think the main thing is these bullets oftentimes stop within the body, which is consistent with what we found here.
And again, is the condition of this bullet and the injuries that you saw, is the condition of the bullet consistent with the injuries that you saw,
Yes.
including the damage to the heart and lungs?
Yes, a bullet like this could cause the injuries that we've observed.
You also described an examination of clothing. Did you examine Mr. Wright's clothing in this case as well?
Yes, I did.
If we could put exhibits 149 and 152 on the screen next to each other, please.
Virtual Loner says, hopefully with more and more people watching trials like this, we can help force changes in how prosecution is allowed
Could
to
you
waste
describe
time and
what's
money in
shown here,
cases
please?
like this.
Yes, this
I hope
is
so.
Mr. Wright's shirt, the shirt that he wore, presumably under his jacket. I put it in place on a mannequin so that we could photograph
Oh,
it.
thank God.
And,
With the like
there are
bag
defects
thing,
on the
I
left
thought
and
they
right
stood
sides
up like
depicted
Yeah,
very
I-
small,
It
but
was
they're-
awful.
I don't know what was going on
When you
there.
say defects, could you circle them or indicate them, please, on the screen?
Yes, so on the left-hand image, I'm going to circle an area on
that
the
is
front left
Quagmire's
side of the shirt.
Jiggity.
Family Guy.
I put a piece of white gauze
All right.
behind the hole, the defect, to illustrate where that is. And on the image on the right, which is the right-hand side of the shirt, I will circle this image here. That is an area of a defect in the fabric or a hole in the fabric.
So when you say defect, does that mean hole in this case?
Yes, they're interchangeable.
And were those holes consistent with the trajectory and the injuries that you observed?
Yes, they approximately recapitulate the injuries that we saw on the body.
And then if we could put exhibits just put exhibit 155 alone on the screen, please. Did you also examine a jacket as well that Mr. Wright was wearing?
Yes, this is the jacket as placed again on the mannequin.
And with respect to the red substance on the clothing, was that consistent with blood?
Yes.
And then if we
It was
could
ketchup.
put exhibits
No, come on.
157 and 158 next to each other on the screen, please.
Mr. Nemmer says, seriously, did the state not revise their questions after the judge stated she would
Did
determine
you
the
also
Blakely
examine the
factors?
jacket for defects?
Half
or
of these
holes?
are irrelevant.
Yes,
Focus on the
and,
gunshot wound. The other stuff muddy.
Holes
things
were
for the jury.
found near
yeah.
the pockets on both sides of the front of this jacket.
And if you could indicate them on the screen.
Yes, so on the left, circled here, is a hole with frayed margins that is present near the front left pocket. And on the right image is a defect that I found in the lining of the pocket, the right pocket. And again, I put white gauze behind that to make it photo worthy.
So he would have sewed it
Now,
differently.
obviously,
Like,
Dr.
what is he
Jackson, the
talking about
pocket line of someone's clothing might not be typically where you would expect to find the heart. Could you describe if these defects or holes would be consistent with clothing being bunched up or raised up on the body?
Yes, certainly. Depending
if they were
on
fighting in a
where
race.
the clothing was positioned, they could be consistent with
Watch the
the
videos.
pattern. And we do have them on the left and right sides of the garment. And again, that, like we saw in the shirt, it is similar and supports the same pattern we saw on the body.
Now, during your autopsy examination, did you collect a number of samples as well?
I did.
Things like blood and hair, nail clippings, and fingerprints? Is that
Yes.
right? And you indicated that you also collected these, this projectile as well as the clothing. Is that right?
Correct.
And were those items all provided to the Bureau of Criminal Apprehension?
Yes, they were.
And then with respect to the toxicology testing in this case, did you also collect femoral blood and urine for toxicology testing in the afternoon of April 12th?
Yes, during the course of the autopsy.
And then did you order testing on those samples as well?
I did.
And what screens were done on the blood?
So we did a comprehensive screen on the blood, and that includes an expanded panel and additional studies. And our aim was to potentially survey for as many possible drugs as possible in this case.
Did that include looking for hundreds of drugs?
Yes, hundreds of drugs were sought out.
That's a weird question.
And what
As many as possible.
Did you get
Does
the
that
results
include
of those
hundreds?
tests?
We did.
It was like
what if any
EDM.
compounds were found from
EDC.
the testing of the femoral blood?
Cannabinoids were the only thing found in the decedent's system.
Cannabinoids.
When you say
Ah.
cannabinoids, is that THC and its metabolites?
Exactly that, yes.
And are those related to marijuana?
They are.
Were those toxicology results that you received in any way significant with respect to your determination of cause and manner of death?
No, they were not.
Oh, the state was
And then,
going to pull
Alexander,
or
did you
the
find any natural
defense is going to pull a
disease or natural
surprise. He died
defect
from weed
that would
overdose.
have caused Mr. Wright's death?
Well,
No, the only thing we
George
found
Floyd, that's
were
for sure.
injury-related changes associated with the gunshot wound.
He wasn't too high.
And now, Dr. Jackson, based on your training and experience, did you ultimately determine a cause of death for Dante Wright in this
Here we go.
case?
Yes.
And what was the cause of death?
The cause of death in this case was gunshot wound of the chest.
And did you also
That's it.
determine
It's over.
a manner
It's
of
over,
death
guys.
for Dante Wright?
Yes.
Resisting
this
arrest?
is certified as a homicide.
And what is
She's
the
going to jail
definition of
now.
homicide with respect to your work?
R.I.P.
Homicide is death at the hands of another.
And how did you make the determination that Dante Wright died
It was
by
death
homicide?
at the bullet of another, to be fair.
The examination of the wound and the history provided supported.
They really should have to
that
change
he
that
was
language,
shot by
though,
another individual and succumbed to
because
his
of their
injuries.
ability to enter it into evidence.
And
and
if we
because
could put
people
Exhibit
may-
160 on the screen,
Yeah.
please.
regardless of what they say.
Dr. Jackson, is this a copy of your office's final ME report for Dante Wright?
Yes.
And that's based on your findings, but signed by the chief medical examiner in your office?
That's correct. That's routine policy. Yeah.
And with respect to manner of death, focusing on this area here, what is indicated as the manner of death?
Manner of death is homicide.
And what's the immediate cause that's indicated?
Gunshot.
I object to this. He's gone over this 3 times now.
Thank
Cause
you.
and manner of death.
The objection is overruled. You may answer.
Oh, come
Can you
on.
answer, Dr. Jackson?
Immediate cause of death is gunshot wound of the chest.
And then did you also indicate how the injury occurred?
Yes.
And how was that?
Was it a homicide?
And we've listed here, decedent was shot by another person, and in parentheses, law enforcement officer.
Nothing further, Your Honor.
So we can't do cause and manner one more time?
Counsel, you may cross. You may cross.
Okay.
They fell asleep.
All right, Earl,
Good morning, Doctor.
wake me up.
Good morning.
With respect to the homicide,
It's going to evanescence
cause and
you.
manner of death, that has nothing to do with criminal statutes. Is that right?
That is correct. Our manner is a medical opinion.
Okay. Yeah, and it's quite obvious that that the cause of death in this case was a gunshot wound to the chest. Correct.
Agreed.
No further questions.
And I notice in your autopsy your final autopsy, excuse me, you wrote 20-year-old man who was shot by a police officer after a traffic stop and subsequently drove his car a short distance before colliding with another vehicle. Is that the information you received when you came on the scene?
That's correct.
And the marijuana found in the system, did you send that to a lab or some other place to determine how much marijuana was in the system?
Well, as a part of the normal toxicology studies, they do quantify those numbers, the numbers of marijuana or anything they do find, yes.
And do you know what we quantify what the result was?
How high
They're in
was
my
he?
report.
Okay, and what are they?
If I may refer to my report.
Sure.
Yeah, go ahead. You wouldn't want to lie on stand, would you?
So in the femoral blood, we found 11-hydroxy delta 9 THC, which is a metabolite.
He wasn't
The
even
level
doing Delta
present
8.
was 6.9 nanograms per milliliter. There was delta 9 carboxy THC, which is an inactive metabolite. This was present at a concentration of 120 nanograms per milliliter. And delta 9 THC, which is the active ingredient in marijuana, the level was 43 nanograms per milliliter.
And the active ingredient, what you mean by that is that's what affects you when you take the marijuana?
Yes.
And is 43 a high reading?
43 is a number within the normal range of individuals reported that use marijuana.
Okay.
So
Use
wasn't space elves
marijuana
high?
regularly or right before the death?
That's difficult to ascertain based on just the numbers alone.
What good are you even then?
I don't know if you answered my question. Is that a high reading based on your experience, toxicology wise?
It's on the high end of numbers that I see. Yes.
Thanks.
So
And,
yes, in your experience, it's on the high end.
He's got the munchies at that point.
and you testified that Mr. Wright could be, was conscious for seconds after he was shot. Fair statement?
No, I said the injury he sustained, he could survive for minutes, seconds to minutes. And then if blood supply is cut off to the brain, then one can be rendered unconscious in a short time, matter of seconds.
Yes, that's what I meant. You do know in this case, from what you were briefed on, that Mr. Wright said you shot me. Did you know that?
No, I'm not aware of that.
Pardon me?
I'm not aware of statements uttered by the
In
decedent.
any event, as you reported, he drove off after the shot. Is that what you learned?
That was reported, yes.
And he could have driven off like that for up to a minute. Fair statement? He's the expert judge.
He's
The
expert.
objection is overruled.
Yeah,
So
good
he could
question.
have driven off like that and been alive for up to a minute. Fair statement.
I would say that's possible.
Thank you, sir. That's all I have.
Is there any redirect?
Yes, Your Honor.
Of course.
What? Redirect for what?
Why?
It's a 3-minute cross.
Dr. Jackson, you were asked about what might possibly happen to a body under these circumstances. If you could just describe to the jury
What
what
did
physiologically
happen?
happens to the body when a heart is shot with a gunshot.
Why is that?
In my profession, we don't see
dies.
directly what happens to individuals. We are called in after the fact. But from my medical training, when an individual loses significant blood, they tend to become unconscious, or they could exhibit altered mental status.
And when you say loses significant blood, did you recover a significant amount of blood from inside Dante Wright's body?
Yes.
consistent with blood loss that you're describing.
I was going to say that question
And when you
didn't
see
make sense.
someone lose blood in the amount of 3 liters, what do you expect to happen to them physiologically?
You didn't
I
lose
expect
3 liters of blood.
physiologically for the heart to be unable to pump blood to the organs, and I expect to see organs that shut down and loss of function occurring.
All of which could have happened
And
after the crash.
when you expect to see that the
During CPR.
heart isn't pumping blood and the organs are not functioning, what does that look like from the outside?
Gross.
Could you clarify what you're asking?
Sure. If the heart is not able to pump blood to the organs and the body is losing blood, what happens to an observer? What does the observer see is happening to the body?
I think the person observing might see someone that appears unconscious or unresponsive, if that's what you're asking.
Yes. So you'd expect someone that was shot through the heart to be unconscious within a matter of seconds. Is that fair?
What the
Check that bleeding, Your Honor. Also repetitious.
Objection is sustained.
Thank you.
Thank
Hold on,
you.
Your Honor.
Jeez.
With respect to marijuana or the THC levels that you saw, you indicated that those were potentially on high levels of what you've seen. Is that right?
Yes.
In the course of your career of doing 1,800 plus autopsies, have you ever
And
ruled
5,000
a death,
bong rips.
an overdose as a result of marijuana use?
I have not.
So when you say that these levels are
straw manning here.
insignificant with respect to your cause and manner of death finding, what does that mean?
That means relative to the injury sustained during the gunshot wound, there is no significant importance to the level of THC found in the decedent's system.
Nothing further, Your Honor.
Anything further?
You understood, did you not, doctor, that when I was asking about the marijuana, I was not implying that this was a cause of death. I was just asking what was in his blood, correct?
Okay, yes.
Thank you.
Right. You may step down. Thank you.
Thank you.
Britt Carmeyer says, I wonder how many of these cases would go to trial if the state had to cover the defense cost of up to $1 million in murder trials. I bet some of these small cases would go faster, get pushed off.
Or even if they had a budget.
A proportional budget to the defense.
Yep.
I'm pro se. Screw you, state. My budget is $8. Try and convict me.
The state may call its next witness.
Sock says, love the stream / panelists. Increase the lure of law school, unfortunately. I know some of the panelists noted how law school is not what it used to be. Would love content from any panelist on how to find a law school that doesn't avoid sensitive topics.
I'm literally going to cover that. I'm literally going to cover that on my stream after this evening on law school because I've gotten too many questions on it.
Truthfully testify in this case. Please have a seat. Remove your mask. I'm going to give you some rules for testifying. The court reporter is taking down everything being said.
Chat,
so you
stop
have to
it.
answer with a yes or no instead of shaking your head.
Oh shit!
No,
We're in trouble.
Because that's
sim
not
time.
a clear record. If you don't understand a question, let the lawyer know. Only one person can speak at a time, so wait until the question's finished before you answer. And finally, if an objection is made, stop talking. Don't answer the question unless I tell you to.
Yes, Your Honor.
Okay. Counsel?
Ms. Lauren, could you state your occupation for the record?
I work at the Minnesota Bureau of Criminal Apprehension in the Forensic Science Lab, and I am the technical leader of our crime scene team.
How long have you been employed by the BCA?
I've worked there just over 11 years.
Could you please tell the jury about your education and training?
My education, I have a Bachelor of Science degree in biology from the University of Minnesota Twin
You
Cities.
say continuing education?
And my training in forensics, most of it has come from my employment at the BCA. I have training in mitochondrial DNA, which is part of our missing persons group, nuclear DNA, forensic
part of our
hair
Hiroshima group.
comparisons, which I obtained out at Quantico, the FBI lab. and a lot of crime scene training. My training is to be a team leader, is in evidence collection, processing, and report writing.
I just want to take a step back for a moment. Can you discuss the duties of the BCA Crime Lab generally?
Yes, our crime lab is made up mostly of scientists. They examine items of evidence to assist in investigations of criminal cases. And we have multiple different sections. So we have a biology section that focuses on DNA and body fluid identification. We also have a latent print section, firearms and tool marks, trace evidence, drug chemistry, toxicology, and then our crime scene team is also part of the forensic lab.
Is the crime scene lab an accredited lab?
Yes, we are.
And does the crime lab go through an evaluation process to maintain that accreditation?
Yes, we do.
And as part of that evaluation or audit process, is your work or proficiency or competency also evaluated?
Yes, it is.
And how often is that done?
Disavow this chat.
We have a full accreditation audit every 4 years, and then a surveillance visit every year. And then we also do an internal audit every year.
Okay. As a crime scene team leader, could you describe your present duties?
Sure. As a team leader, I lead a team of scientists out at crime scenes. I lead them in everything from documentation of the crime scene. So that would be photography, video, also note-taking about our observations and diagramming. And then I lead them in crime scene processing. So things like latent prints, collection of samples for DNA, things like that. And then also evidence collection and packaging.
And overall, would you agree that personally in forensic science?
Yes, I have.
And that would include the subject matter of collecting and handling evidence and collecting DNA, testing DNA.
Yes.
Would you also agree that you're trained in bloodstain pattern analysis?
Yes, I am.
All right. Now, you've testified in court as an expert before.
Yes, I have.
All right. Now, on what sort of cases does the crime scene team respond to?
Our team responds to homicides, death investigations, missing persons cases, officer-involved shootings or use of force cases, and also clandestine grave recoveries.
When you respond to a scene, what duties does that typically entail?
Responding to a scene, the duties I have are
expert
again
on
leading the
this?
team, making sure that everything is documented appropriately. So overall photographs and video are taken, items of evidence are identified and marked as items of evidence, and those are also photographed. I lead the team in the processing of anything that we need to process depending on the scene circumstances, and then the collection of the evidence, the packaging of the evidence. I'm also responsible for ensuring that evidence is sealed appropriately, brought back to our laboratory for secure storage, and then I coordinate with our agents on the forensic testing of those items.
Okay. I want to talk about one more topic generally before we get into the April 11th, and this is just about the process by which you collect an item and keep track of it. Could you describe how that work is done?
Sure. So when an item is identified at a scene and we decide that we're going to collect it, we put an item number next to it and have a photo taken of that item with that item number. That item number stays with that item from the crime scene through the forensic testing in the lab and all the way to court. Those items are marked on the packaging. We barcode those packages so that they can be tracked throughout the laboratory. And that's pretty much it.
Okay. Why don't we move on to April 11th of 2021? Were you on duty that day?
I was on call that day, yes.
Okay. And what
on to the day now.
did you respond
That's nice.
to a communication that afternoon?
Yes, I did.
What did that communication pertain to?
I received a phone call and was told that there had been an officer-involved shooting in Brooklyn Center.
What did you do in response to that call?
I notified my team that's on call that we were going to be responding to a scene. I do that by sending out a text message, basically. And then we met at the BCA laboratory.
Why do you go to the BCA lab first? Pardon me, the BCA lab, that's in St. Paul, right?
Correct.
Why do you go to the BCA lab first?
We go to the BCA lab so I can get a laboratory case number for the case. And then we also take our crime scene response vehicle out to the scene. That vehicle has everything inside of it that we need for packaging and evidence processing.
Okay. And did you ultimately respond to the scene of the shooting in Brooklyn Center?
Yes, I did.
And was that at the intersection of 63rd Avenue and Catherine Drive?
Yes.
Do you recall when you arrived at the scene?
We arrived at 4:45 p.m.
Okay. And how many people were on your team when you arrived?
It was myself. I had my team member, a technician, an additional team member that I was mentoring for crime scene team leader training, and our photographer.
What did you do when you first arrived?
When we first arrived, we had a briefing with Special Agent MAXWELL.
And as you came to the scene, did you
See that weird
based on
smile
your
he
training
did?
experience, sort of define
He's
what the
creepy,
scene
man.
actually
This
was
guy
going to be for you?
looks weird. I just can't.
Yes.
And what was that?
MAXWELL gave us information about.
Thank you. Yeah, you can't bring on her to talk about what the other dude said. The funny thing is I was getting that. That's why he had that pause. He looked down at his notes and he saw that his next question was going to get objected to as hearsay because the defense hasn't been asleep on it the whole time.
And then he guffaws. Hearsay.
How could it possibly be hearsay to have her ask what she heard and then say it back to me? You're already calling every witness who has ever breathed in this case. You don't need to have cumulative testimony from.
We're going to get this chick's hairdresser next.
This judge is just allowing it, though, right? I mean, this is like, she seems very, very permissive.
She's stopped a couple of the hearsay objections. There haven't been many hearsay objections, but it's like we'll see on this one. I mean, his argument is going
it's just so lazy and unnecessary. I mean, Phil testified. If there was stuff that Phil was going to say, that's kind of the time to have him say it.
Yeah. What did you tell the BCA team when they showed up? It's simple answer, but they want more people saying as much as possible. That's what they want to do. They just want to.
The objection is overruled. You may continue.
Wow.
I believe when we left off, the question was, how did you define the crime scene based on the information you obtained?
The briefing information I was given gave us the overall location of where to focus on to look for items of evidence. And we were told that there had been a traffic incident and an officer had fired their firearm. After that, there had been a vehicle collision and the driver of one of the vehicles was deceased on scene.
After you observed the general appearance of the scene, what did you begin to do?
So the first thing that I did was have a walkthrough of the scene so I could observe everything before we started any type of processing or documentation. Then I had overall photographs and video taken of the area. And then I started to identify items of evidence and mark those items so that they could be placed into a diagram. And we started collecting those items at that time.
At some point, were there items located at the scene that you did document and mark?
Yes.
Okay. Is there a specific area where you directed your attention at the scene?
We directed our attention around the Buick vehicle that Mr. Wright was said to have been driving, and also the area where we were told that the traffic stop had occurred.
And did you look for any evidence that you believe to be pertinent to the investigation inside the vehicle?
Yes, I did.
Did you locate something that attracted your attention at that time?
Yes, I did.
And what was that?
A bullet
I found
casing.
a cartridge case on the front driver's seat of the vehicle.
And are you familiar with the terminology of discharge cartridge casing, or DCC?
Yes, I am.
Is the item that you found frequently referred to as a discharge cartridge casing, or DCC?
Yes.
Could you unpack for the jury what a discharge cartridge casing is?
Sure. When you load a pistol with ammunition, the ammunition itself is actually called a cartridge. The cartridge is a cartridge case that's holding the projectile or the bullet. So when the firearm is fired, the bullet dislodges from the cartridge case and the bullet goes down the barrel of the gun. And the cartridge case is typically ejected out of the chamber of the gun.
Not that
and
it
they can
matters,
found it
but
shooting
they actually
scenes.
didn't lay any foundation
And
for her
you
being an
noted the
expert
location
on
of this
bullets.
DCC?
Yes, I did.
And did you mark its location with an evidence marker?
Yes.
Am I correct that you assigned it evidence marker 7?
Yes.
And did you eventually collect the discharge cartridge casing?
Yes, I did.
Janet Morgan says
And
the
that was
coroner.
retained by the BCA throughout this investigation?
Yes.
And that maintained and retained that item number 7 throughout the investigation, correct?
Yes, it did.
The coroner in
Following your
Louisiana.
on-scene
damn it.
examination of the vehicle, what
I'll
was
read it in a
done with
second.
that white Buick?
The white Buick was tape sealed and then towed to our BCA headquarters processing garage for further examination.
Okay. Was there another damaged vehicle on the scene?
Yes, there was.
What was done with that vehicle?
That vehicle was documented on scene and then was also towed, but not to our processing garage.
In addition to the discharge cartridge casing, were there other items that you collected from the scene?
Yes, we collected various items that we found along 63rd Avenue North.
Okay. And you documented and recovered those items as well?
Yes.
In addition to the physical items, did your investigation lead to an examination of Mr. Wright?
Yes, it did.
Okay. And at that time, when you arrived, he was placed under a tent?
Yes.
And are you aware that the Hannah County Medical Examiner came to the scene?
Yes, he did.
And were you present when they were examining the body at the scene?
Yes.
And ultimately, Mr. Wright's body was transported away from the scene, correct?
Mr. Body.
Do you recall what time that?
What?
PM.
The hell just happened there?
Now,
That's
did you
weird.
create a scene map which shows the location of items that you recovered?
Yes, I did.
And does that also include the location of where you located item number 7, the discharge cartridge casing?
Yes.
Okay. At this time, the state offers Exhibit 161, scene map.
Janet Morgan says
Objection to 161.
a coroner in
161
Louisiana
will be
has ruled
admitted and
marijuana a
published.
cause of death for someone within the last 10 years. Lol.
Really?
Wow.
Ms. Lauren, the jury has seen a couple of maps without markings on them throughout this trial. But could you describe the location depicted on this
Actually,
image at this time?
Not true. Every map they've seen has
Sure.
had
This
markings
is
on it.
a top-down view of 63rd Avenue North running east and west. And at this location here is Catherine Drive.
Okay. And then I just want to direct your attention
It's a
to
real urban area.
Avenue and Catherine Drive. Would you agree that there's a red number 7 at that intersection?
Yes, there is.
Okay. Could you just testify as to where that was located?
Yes, so the white rectangle in the diagram is depicting the location where the Buick sedan was. And the 7 is where our discharge cartridge case item number 7 was collected from the front driver's seat of that car.
Thank you. You can take that, Mr. Miller. I now want to go through a few photographs from the scene. In preparation for trial, did you review with me and recognize a series of photographs?
Yes, I did.
Your Honor, at this time, the state offers exhibits 162 to 174, noting that 166 and 167 are already admitted.
Okay, any objection to those exhibits?
It would appear 169 and 170 are redundant. Otherwise, no objection.
Those exhibits will be admitted subject to over the objection of defense counsel. Any republished counsel?
Thank you, Your Honor. At this time, Ms. Lauren, I will show you exhibit 162.
Projects.
And what I'll do, Ms. Lauren, is ask you to describe what's shown on the screen.
I mean, this is going to be another whole day of testimony that has nothing to do with recklessness.
This first one, exhibit 162.
Or even the gunshot.
Could you describe what you see on the screen?
This is a photo taken from 63rd Avenue North facing east. We're facing the area where you can see the white Buick sedan on the northwest corner of Catherine Drive. On the right, you can see our BCA crime scene response vehicle is on scene. And in the center median there, you can see, it's kind of hard to see, but there is a traffic sign that's down in that area.
Let's move to exhibit 163 to see if that assists.
Project Son Poorly says, screw this crap. There's leaked
What is
footage
shown here
of
in exhibit
Jussie's
163?
trial on Idris
This is that
TV
center
YouTube
median
channel.
on 63rd Avenue North with the down traffic sign.
I'll have to check
And
that
could
out
you
later.
assist the jury and
It's
with
a
your
comedy.
pen or finger circle where you see
Oh,
the
is
down
it?
traffic sign?
Yeah.
Okay.
Here is the broken metal and here is the sign.
Thank you. And I'm showing you to, you're identifying the sign right center in the middle of the picture, sort of toward the top third of the image, correct?
Yes, correct.
Thank you.
Is that
now
relevant
to
because they drove
164.
over it?
You'd agree this is just, again, looking east down 63rd at the damaged vehicles?
Correct, yes.
Exhibit 165.
He agreed it was
Would you agree this
redundant.
is also looking east down 63rd at the damaged vehicles, but a bit closer up to see both of them on the screen?
But a bit closer.
Thank you. Exhibit 166.
Can we proceed frame by frame now, like my colleague Binger?
What is shown here?
Cool.
This is the front end of the Buick sedan showing some front end damage and the driver door was open upon our arrival.
There appears to be some black equipment on the ground in front of the vehicle. Can you identify what that is?
I had a cop
It
friend
appears
tell
to
me that
be
every
a
Buick he's ever
police
been
shield.
he's ever pulled over that was driven by someone
Exhibit
under the age of 30 is
167,
full of
now,
weed.
Mr. What is shown here?
It's my dad's
This is
weed.
the passenger front side of the Buick showing a defect in the passenger windshield.
168.
defect.
What is shown here?
Well, we haven't seen these photos
This is
before.
the front driver's side of the Buick showing the front driver's side seat.
Okay. Exhibit 169. Would you
Right, I
agree
had
this
to do
is
the
just a,
obligatory.
image
I just
down,
realized that.
down at the ground of the front driver's seat?
Yes.
We're going to see a close-up in a minute, but in this image, can you see the discharge cartridge casing?
Yes, I can.
And now showing exhibit 171.
Seriously, like playing those old click video games where it moves just to,
Oh, like King's Quest, where you're just like going
Could you tell
step
the
by
jury what you
step.
see in exhibit
yeah,
171?
like Mist or.
This is
Yeah.
the discharge cartridge case on the front driver's seat marked as item number 7.
Exhibit 172.
Would you say there's a half liter of blood on the seat?
Would you agree that 172 is just an image of the top of the discharge cartridge casing after it was recovered?
Yes.
Okay. Exhibit 173. What is this shown?
This is a photo of a backpack that was outside of the front driver's door that we were told had been in the vehicle at some point in time.
And what did you do with that bag when you saw it?
We documented the bag and I looked inside of it quickly to see if there was anything significant inside. And then I put it on the front driver floor to be towed back to the BCA with the vehicle and its contents.
Okay. And then exhibit 174. And we agree this is just the tent that was placed around Mr. Wright's body when you were present at the scene?
Yes, it is.
Okay, thank you. You can take that down, Mr.
Potter is responsible
Now,
for the ugly
You
tent being
reported that
erected
you
in the
collected that
community,
single,
violating HSA
discharge cartridge
standards.
casing from the scene, and you eventually
It'll be a
inventoried
lesser
that?
included offense.
Yes, I did.
Your Honor, the state offers Exhibit 200, which I'm going to retrieve in a moment, the discharge cartridge casing.
Over under,
Okay,
we
200
hit 4
will be
digits in the
admitted
number of
into
exhibits.
God.
Ms. Lauren, I'm going to show you a few things today. Going to try to walk close up to you, probably not hand you anything, just so that you have an opportunity to see it, okay?
It's the only time
Ew.
he's ever been able to walk close up to her without getting slapped.
Oh god.
She's got a restraining order against him.
Ms. Lauren, I've just shown you Exhibit 200. Do you recognize
Yes,
what
you
that
can
is?
walk up to me, but
Yes, I
only
do.
because of the
What is
plexiglass.
That is our BCA lab item number 7, the discharge cartridge case from the front driver's seat.
Thank you. How long did you remain at the scene?
We were there for just under 3 hours.
Prior to your departure, did you receive several additional physical items from another BCA agent?
Yes, I did.
And what agent was that?
Special Agent Sam McGinnis.
And what did you receive?
Oh God, we're gonna
I
have to hear from him
received
too.
a toxicology kit from Officer Potter and 2 firearms, one from Officer Johnson and one from Officer Potter.
Okay. And when you received the 2 firearms, did you get information as to how to differentiate them?
Yes, the boxes had markings on them as to which firearm was which, and then there was also a receipt that had information on it that matched each firearm.
Okay. The condition of Sergeant Johnson's firearm, was it loaded, unloaded, or something else?
Sergeant Johnson's firearm was unloaded.
Into the
Did
victim.
it have a magazine inserted in it?
No, it did not.
And Officer Potter's gun?
Officer Potter's gun contained the firearm and the magazine that had ammunition in it and a 1 cartridge in the box.
Okay. Now, did you assign those firearms evidence numbers as well?
Yes, I did.
And what was Johnson's gun identified as?
Item number 12.
And Potter's gun was identified as?
Item number 13.
Okay. And after you documented and identified those with crime lab numbers, did those leave the scene with you?
Yes, they did.
And were they later inventoried at the BCA?
Yes,
You
they
know,
were.
not everything
And
a
did you
crime
follow
lab
your
documents
typical
and
protocol
inventories is relevant to
of
the case.
Photographing and documenting.
I'm getting so
those
tired of that
items
little head
prior
check
to,
she does every time she answers a
actually
question. The
putting
glance
them
at
in
the jury.
Evidence vault.
Yes.
Yes, I did.
Yes.
If I showed you 2
Yes.
photographs you took of Sergeant
I do.
Johnson's firearm, BCA item number 12, would you recognize them?
Yes.
The state offers exhibits 167 and 177, photographs of Sergeant Johnson's firearm.
Any objections?
Mo says
167
the
and
next witness is going to be a
177 will
local
be
garbage
admitted into
man.
Evidence.
Yes, please, first 176.
It's gonna be like the sign repair guy.
Yeah, Gage Groskowitz did the same.
To clarify, I may have misspoke. It's 176 and 177. Everyone's head nodding. I just didn't hear myself.
Thank you.
176.
Everyone's head nodded because you're boring.
I'm showing you
You're all
exhibit
bored.
176 at this time. What is shown on the screen?
This is Sergeant Johnson's firearm,
Okay.
item 12.
And the Post-it note may be heavily washed out on certain screens. Can you see a Post-it note on the top of this image which has a number on it?
Yes, I do.
And what number is identified there?
12.
12. Okay. The next exhibit 177, Mr. Miller. What is shown here?
This is the serial number of Sergeant Johnson's firearm.
Okay, thank you. Okay, let's now move on to Officer Potter's firearm. If I showed you a series of photographs you took of that firearm, would you recognize them?
Yes, I would.
The state at this time offers exhibits 178 to 183, photographs of Potter's gun and ammo.
Okay, those exhibits will be admitted into evidence and you may publish the photos.
Thank you. Let's start with exhibit 178. What do you see in Exhibit 178, Ms. Lauren?
Thank God they're doing this.
This is Officer Potter's firearm and the loose cartridge that's in the box, as well as the magazine that was loaded.
Okay. And
A different
Exhibit
person
179.
wrote that post-it note.
What's shown here?
This is the serial number of Officer Potter's firearm.
180? Is this just an image sort of the loaded magazine, which you can see has live ammunition in it?
Objection
Yes.
leading.
Exhibit 181?
Hollow point ammunition.
Is this the live round which is taken from the chamber of the firearm?
Yes, it is.
Exhibit 182? Is this just a close-up view of the magazine which shows that it's loaded with ammunition?
Yes.
And then Exhibit 183.
We all know 9 is the evilest millimeter.
Could you explain to the jury what is shown in Exhibit 183?
When I received the firearm and did this documentation, I removed all of the cartridges out of the magazine for photo documentation to inventory how many rounds were in the magazine.
And that's what's shown in this image.
Yes.
Okay. And Ms. Thorne, if I showed you the actual firearm, Potter's firearm, would you recognize it?
Yes.
At this time, the state offers Exhibit 199, Your Honor.
199 will be admitted.
Maybe you can point it at the jury.
Members of the jury, I've already advised you that the gun has been secured and cannot be discharged. Okay.
Ms. Lauren, I'm approaching with Exhibit 199. You can see the sticker there on the top of this box. What do you see in front of you?
Ah,
I see
Ah.
Officer Potter's firearm.
Sorry.
It is a Glock 9mm semi-automatic pistol and the magazine.
when he did that, I went to that Justin Timberlake song they did on SNL. Dick in a box.
If I showed you the ammunition which was removed from Officer Potter's firearm, would you recognize it?
Yes.
State offers Exhibit.
That's the only way this guy would get her to want to see it.
202 will be admitted.
Now, this might take a second for you to describe this, how this is set up, Ms. Lauren. You agree there's an evidence sticker 202 on there, right?
Yes.
And then here, there's an individual live round.
What is shown on this part of the exhibit?
This is the cartridge that was said to be taken out of the chamber of the gun.
Okay. And then there's a collection of live firearms in another part of this exhibit. Would you agree this is the live ammo that was taken from the magazine?
Yes.
Okay. Moving on to another topic.
Really?
You previously testified that Mr. Wright's white Buick was towed, right?
Yes.
Did you ever examine that vehicle again?
Yes, I did.
And when was that?
The following morning on April 12th at around 10 o'clock in the morning.
And where did that search occur?
That occurred at the BCA headquarters processing garage in St. Paul.
And when you began to search the vehicle, was it still secured with the tape that you placed on it the day before?
Yes, it was.
We're
Who
all
was present
yelling
when you
here.
searched the vehicle?
It was myself. I had the same people that were on my team at the scene, except for the technician. So I had a team member that was in team leader training, and also an agent to do the photographs.
What actions were taken beyond photographs when you conducted the search?
So I marked items of evidence inside of the vehicle that I could see clearly and had photos taken of those. And then I also removed all of the contents of the vehicle and separated them out by the area they were found in, and then took photos of those areas and then marked additional items of evidence.
You generated a report documenting the search?
Yes.
Okay. And when you searched the vehicle, you did take a substantial number of photographs, correct?
Our photographer did, yes.
And you've reviewed a set
Chat,
of
we're almost to
7
2,000
photographs,
likes. At
prior
2,000
to
likes, I'll drink this
Yes.
whiskey.
Your Honor, the state offers exhibits 184 to
You
190.
guys gonna give him some likes for
photographs of the
enduring this.
inside of Wright's vehicle at the time of the search warrant.
Just
There's no
enduring it.
objection to 184 to 190.
Reject 184 to 180.
Oh, okay.
That's redundant.
All right. I've already made rulings on that. I'm going
Oh,
to
dang.
admit
Whoa.
184
Almost to
to
3,000 likes.
190 over the defense objections.
Cheers, chat.
And you may publish.
Thank you, Your Honor. Prior to showing Exhibit 184, what is the value of taking photographs in the crime lab facility rather than on the scene?
The lighting.
When it's possible, which is usually with vehicles, we just have a more controlled environment in our processing garage. We have better lighting. Plus, we don't have anyone from the general public around. to
And it's not a
see the
violent
contents
neighborhood.
When we put them out.
Okay, thank you. 184, Mr. Miller. Could you describe what's shown here?
This is the front driver's seat of the Buick.
Exhibit 185. What's shown here?
This is the front driver floor of the Buick showing a shoe.
186.
Care to comment on how those aren't
What is shown on
Jordans?
Exhibit 186?
This is a photo of the Buick taken from the rear driver's side showing the center console area.
So you agree this photograph is essentially taken as someone would be standing outside next to the rear driver's side door, looking past the front driver's seat into the front area of the vehicle, correct?
Yes.
187.
187 on the
What is
mother-
shown in Exhibit 187?
Sorry.
This is a photo of the
Go back to my
interior
Snoop
of the
days.
vehicle taken from the perspective of the front passenger side.
Exhibit 188. What is shown here?
This is the front passenger side of the vehicle showing the defect in the passenger side window.
Did you more closely examine the defect in the front passenger side window?
Yes,
Did you recover any physical evidence from that interior of the window?
yes, I did.
And what was that?
I recovered apparent hair from the interior of the defect.
By the way,
Um,
what a
Exhibit
shitty
189,
Buick.
Mr. Miller?
Airbags didn't deploy on a head-on collision?
Are you surprised?
This is the front passenger headliner area from the perspective of the driver's side.
Okay. And without, that was a very clear description to me, but I've seen this image, so I want to be clear. Would it be accurate to say the perspective of this image is perhaps someone who is maybe even seated in the driver's seat or in that area of the driver's seat, looking up at what I call like the ceiling of the vehicle above the passenger seat?
Yes, that's correct.
All right, Council, we're going to take a break, a 20-minute break.
Oh,
All
Holy
right,
sh!
members of the jury, 20 minutes.
Buick should be suing them for showing these photos of their completely useless airbag restraint system.
Well, usually that's what they skimp on in repairs, right? Is the airbags.
Wow. Mark Gee says, am I a racist if I think all service issue
Hey,
Glocks
step
look
down.
the same and there isn't really a great way to recognize
Hey,
specific
Council.
service Glock
Break.
without referring to the serial number?
That's
that
why
made-
they did it.
That makes you a racist. Oh God, the Fox guy's gonna start talking. We gotta shut that off. Ugh. Marky says also, Mr. Bronca, can you lose the tie? I want some uncaged witty humor with Andrew. Mrs. Bronca, your husband is doing good work and needs to stay up late to enlighten us viewers. I came for ASMR Judge, but stayed for Bronca.
I'll pass
Brock is
it on
getting
to her.
Sims.
This is man, this is I mean, this has been evident that this is their strategy, but you would hope after they got shut down for some of the cumulative stuff earlier that they would change up a little bit, like just a hair, just like, please just give us something that isn't so boring. But no.
It's just a argument by volume of words.
Yeah, and that's the argument in of itself, is that, hey, we have so much evidence because of pure volume, right? It's quantity that matters, not the fact that there's any quality or really substance to it at all. We just have a ton, right? And therefore you should convict them because there's so much evidence.
Hey, what's up, Kurt?
Hey, I'm just gonna be here through the break because I have actual day job work to do. But I figured I'd stop in for just a minute to say hi. No, I'm serious, very serious. Actually behind, but I figured I'd stop in at least to say hi.
Yeah, well, appreciate it, man. You've been watching along a little bit. I saw you in chat earlier.
A little bit, yeah. I've been a little bit in chat, and I was like, when they were going through the photos, is like photo whatever. And one part I just chimed in, "What is this photo?" And I'm just commenting in the chat. This is the photo where the soul is slowly leaving my body as we go through this medium. It's like,
I mean, it's like, why are we looking at photos of the crash scene from a block away, and then from a half block away, and then from a quarter block away? It's like as the distance approaches zero, we photos go to infinity. Like, what the hell is this?
You see Kim Potter's racism up close.
Yeah.
Maybe this is one of the reasons I do more transactional work than litigation, is because this is the part of law that I just find a little bit irritating, because I was like, I know this stuff already. I know all these things. I was like, can I just take all this as given and just move on with the legal analysis? I like the legal analysis. That's why I do like court of appeal cases. So maybe I should just do appellate law or something. But it's like, do we need to really see the photo again? It's like, we know he's dead. We know he bled out. We know he was shot.
Yeah.
It's like, just take it all as a given. Let's move on with the analysis.
I've seen his bloody car chair, like literally in 6 different photos.
Yeah. Yeah.
And the defense, I mean, to their credit, this is cute. We're objecting to this as cumulative, Your Honor. And she's like, yeah, overruled. It's okay. You can bring in that cumulative evidence. It'll be
bring
fine.
it all to mommy. Bring it all to
jury.
mommy.
Yeah.
It's fine.
The jury won't do anything.
Well, it's like, yeah, I mean, strictly speaking, I almost want to object to it as irrelevant, because it's nothing for the jury to decide. It's like, yes, he's dead. The cop shot him. She yelled, "Taser, taser, taser!" She pulled the trigger. The other cop was this close away. He bled out. Here's the car was damaged. What more do you want? I got it. Let's move on.
And to the chat, as a cool, like, post facto exercise, you can measure the relevance of a particular witness's testimony by the duration of the cross exam.
Right.
Like, because the cross exam is concerned with dealing with issues that are for the jury to decide. If you notice, the medical examiner's like 40-minute testimony. Cross exam, Andrew, you said 3 minutes.
Yeah,
3 minute
I mean,
cross.
I've noticed this from the first day of the state's case in chief. The ratio between direct and cross is in excess of 6 or 8 to 1.
Yeah.
In terms of actual time duration. I mean, it's unbelievable what the disparity is.
This isn't Chauvin, Floyd, where I need a medical examiner to tell me about the nature of substances in the body and then have a discussion the degree to which that may or may not have influenced the cause of death. Even then, I'm like a little bit irrelevant, because all I need to determine is that Chauvin is a substantial factor. So I don't really care how many drugs he had in his body, but still it was something. It's like, I don't need a medical degree to know what I need to know. Bullet goes in body. Bullet goes through lungs and heart. Person dies.
Dead.
It's like, how much medical knowledge do I need? Not that much to realize, yep, got it. I'm on board.
Yeah. What happens? Yeah, it was like, what happens to a heart when it gets penetrated by a bullet? It's like, well, no shit, Sherlock. You know what I mean?
Yeah.
It don't work anymore. No, the toxicology here was very mildly relevant for Kim Potter's state of mind, I think, because the one officer indicated he smelled marijuana coming out of the car. We can confirm now from toxicology that he was under the influence of marijuana to some level. So cool. You get to the state of mind of that's actually kind of relevant for the defendant here, because it was information that she had at the time. We've now confirmed it with evidence.
If she could smell it, then yes, that would be fine.
Well, he told her.
Okay, then okay, fine. Then it's relevant. All right, I'm on board then.
Yeah. So, I mean, but it's not something that needs to be belabored. And of course, the prosecution wants to get past that uncomfortable fact very quickly that this guy is driving on streets under illegal drugs. And there is justification for pulling him over and then further justification for the stop. But
There was a warrant at the time, right?
yeah.
Well, that'd also be basis alone. So,
Right.
Yeah.
Yeah.
What else?
But I mean, you don't need it, but it's.
I mean,
at
they didn't
least-
know about the warrant till they pulled him over and ran him, right?
Right.
And found open paper on him.
But this is all mildly relevant, at least. But everything at the subsequent scene, everything at the crash scene is completely pointless.
Yeah, I'll just stipulate there is reasonable articulable suspicion to pull the guy over, because all we need him to do is do something suspicious or even probable cause, all of which we need is for him to violate a traffic regulation of any kind.
Right.
Frankly,
what is the maximum distance that a person can drive without violating any traffic regulation?
No, there's
always 2, maybe tops.
There's always probable cause if you're in a vehicle.
Yeah. Oh, you swerved a little. You went too fast. You went too slow. You crossed the lines. You didn't signal enough space distance.
He signaled a right turn from the left-hand turn lane and then turn left. Like, now, not every cop is going to pull people over every time for that, but it is justification. I mean, that's enough for a cop to say, whoa, this guy could be drunk. He could be high. He could be having some sort of distress. It could be an older person who's confused and they just want to check it out.
Right.
Not every pullover is nefarious or anything like that. So like they clearly have all the justification they need. But the state is they're prosecuting by cumulative nonsense, not even cumulative evidence, by cumulative information.
I like that nonsense.
I'm glad the judge put a stop to it eventually with the body cam footage. You know, maybe it's me. I would have acted a little bit sooner than that, or maybe it's just my personality. Because again, I just wanted to skip ahead. It's like let's just keep moving. It's like we've seen it twice. We've seen it enough. Let's move on.
I mean, I would have taken all the body cam footage of the shooting that they want to introduce the whole time.
Put in a little compilation, put it little something. I don't care.
But like,
the body cam of the subsequent scene is just like they're trying to show that the cops were heartless while this man was dying. By
the way, did you do 2 shots? Because you hit 2, then 3. Did you do 2?
I'm still on my first one. I'm not doing a shot every 1,000 likes. I'll die.
You're not?
No.
I'll unlike your video then.
Okay. But I'll probably do a second one at 4,000, which is we're 3665.
I'm at 45.8 for subscribers, man. It's going really well over there on
Nice, bro.
Awesome.
I know.
Oh yeah. While I'm thinking about it, let me add you to the description.
Yes.
Guys,
go to
check out
Uncivil Law. We've got wonderful content coming up as always. We did a wonderful analysis with Legal Mindset this past Friday on the Supreme Court oral argument. It was fantastic, where we did whole women's health and we read the decision there. Great stuff. We've got lots of interesting stuff coming out. More stuff with the Daybell case, because the stupid never ends. Now they're going to bar complaints and filing before the bar, because I don't even know why. It's just so petty. And we got one for the boys to make up for the girls. So last week we covered the woman who decided to please herself and shot herself in her own vagina. Apparently, and I can't even believe this is a thing, but apparently there is a Facebook group devoted to men who get their rocks off by knowingly and purposefully pointing a loaded firearm at their junk. And for one guy, this didn't go well. The title of this video will be 45 ACP D's Nuts.
I like it. And I'm not surprised. There's some degens out there, guys.
Here we go.
Please do not knowingly point a loaded firearm at your balls. This is good gun advice, medical advice, legal advice.
I was told in my hunter safety course that a lot of people, when they would try to do the twirl thing with a revolver, would accidentally shoot themselves in the junk. That was what I learned at age 8.
Here, let me read this super chat real quick, because I think it could be interesting. Elizabeth Stoddard says, I actually got a degree in forensics and investigative sciences. We were taught never to show bias to one side or another. What is the weirdest expert testimony you've had? Gentlemen, any weird expert testimony that you've been witness to? in particular?
Not necessarily testimony, but I get it every literal damn day in expert declarations dealing with my field, which is just all experts. I mean, patent law is about as experty as you get. And so sometimes I deal with the stupid.
I had to deal with a gopher tortoise expert. I mean, that was pretty interesting. Ooh. If you guys know anything about Florida wildlife, you're allowed to toss one tortoise. If you toss more than one, that's a state crime, baby.
Wait, you could throw a tortoise?
Is there a time interval between?
Okay, gently place it with a forward momentum that will not grievously injure the said tortoise. All right.
Frisbee the tortoise, then.
Yeah, gently, like high frisbee. We're not talking about Dante Wright level of high. Like a little bit less than that.
Most of the stuff I've done has not required expert testimony. It's basic petty crime stuff. But yeah, again, I'll go back to the same story that I've had. It was the entire earth was on fire. It was a house fire, total loss, 115-year-old dry tinderbox house. The foliage was on fire, the ground was on fire, everything's on fire, and the cops took the time to go over to a pile of garbage, which was also on fire, burning plastic, burning aluminum. And the cop wanted to search it, asked for consent from my client, and my client said, "Nah, don't worry about it because it's just burning garbage." And the cop kicked open the bag of garbage and found leafy marijuana inside of it. And he said later on stand that he smelled a strong odor of marijuana, and he testified that he was an expert in smelling marijuana. So he was able to discern marijuana smell from burning plastic, burning aluminum, burning ground, burning house, and burning. I mean, hell, the sky was on fire. Like the crime scene photos are amazing. It's just orange. The whole earth is orange. And I was like, really? Really? You smelled it, did you? Okay, sure. Gotcha. Because your 1 week training class that makes you a drug expert in Minnesota allows you to smell marijuana.
Well, it wasn't the 1 week training class so much as my youth, but whatever.
That's years at Woodstock.
And then the judge subsequently wrote one of the, because I moved to exclude that, and the judge wrote one of the most ridiculous opinions I've ever seen, which incorporated the plain smell doctrine based on 3 cases, 2 of which were dogs smelling cases, and the third of them was we're in the 8th Circuit. The third was from the 4th Circuit on a marijuana barge that had 500 bales of marijuana on it. That justified plain smell. And in that case, they didn't even rely on the smell because there was a rip in the tarp covering the weed and they could see it. And so the judge is like, "Oh yeah, plain smell doctrine." I'm like, it doesn't exist in this state, judge. Anyway.
It does now.
Yeah, you could actually use that opinion as persuasive.
Why don't we just break out a marijuana divining rod? It will be faster and just as reliable.
Oh God, that was frustrating. Billy Witch Doctor 99 says, "What are the odds Judge Chu got a call from Keith Ellison's office over the weekend?" Pretty low. Like the DOJ or the Minnesota Attorney General's office has no authority over a judge in Minnesota. Like not even.
Oh no, there's zero chance. If that happens, I mean that's ethics violations up the ass.
Yeah, and the like a judicial. Remember, these are 2 different branches of government, and as funny as it is to make fun of all government at once, the branches actually they are wary of the other branches' influences and power. So, no,
why would he call to say thanks?
Yeah,
I mean, thanks for us wasting a week of testimony and cumulative evidence, and we appreciate it. If we can make this trial last for 6 months,
you got problems up the ass.
Yeah,
if you become attorney general someday, please do not call random judges. It's a bad plan.
Yeah, the judges will go ahead and rat you out. They don't.
Of course they will.
They'll get another attorney general. They don't care about you at all.
Yeah,
I put that shit on the record. Yeah, I put that shit on the record. Yeah, I got this call from the attorney general. Seemed vaguely threatening. Let me just put it on the record of the recollection of the call, so the defense can now object to this ex-party conversation and get a mistrial. Which I will obviously grant in about 5 seconds.
I checked my voicemail over the weekend, and I did have a voicemail from Attorney General Keith Ellison, and it was really nice for him to call and check up, but I thought it was maybe a little improper during the pendency of a trial. And so I'm going to go ahead and overrule my own objection, though. The voicemail wasn't.
I'll
long
allow
enough.
it.
Yeah, I'll allow it.
I'll allow it.
Yeah. Oh my God. This cumulative evidence is just, it's torturous, but I get the impression that this judge is fine with torturously slow things, right? Like,
yes.
if you,
I mean,
if
there's
you,
always slow spots in the evidence, right? There's technical things that have to be covered for technical reasons, but this
Yeah.
is just unending. I mean, it doesn't usually take days.
Just don't
Yeah.
forget to establish venue.
Oh, somebody just gave me $5 in the super chat. Thanks, guys. I'm sure Nick will forward that right on to
I'll
me.
be sure to send it.
Submit the invoice.
I'm still waiting I'm still waiting for my cut. I do have PayPal. Just a reminder, Nick, that you can send money to.
You do? I keep losing it. It's weird.
Okay.
It's,
PayPal.com on civil law.
I only accept my payment in Doge.
PayPal.com/Arcade Law. Okay, got it. I'll make sure and send it there. Andrew, by the way, that was a question I had that I didn't get to ask you the other day. If I want to buy 25 copies of one book and send it to one particular address in Kenosha, Wisconsin, can I do that through the website? Is there a bulk shipping option, or do you ship?
I don't know if we have that on the website, but I think I sent you an email address for the person you would want to contact for that.
Okay.
We do bulk sales all the time, but I don't know if it's like preset on the web page or if you have
Still
to
waiting
talk
for
to
my
them.
book, Andrew. Still waiting for my book.
It might be a little while, man. It's I think we've put up on our website now. We're not promising books by Christmas anymore because well, we're just out of time, really.
I really I have not decided if I want to ship it to them directly or if I want to ship it to me and drive to Kenosha myself and have someone film me dropping off the books at the prosecutor's
content.
office.
Now that's content.
Live stream it with text to speech on.
I think you should put it in Christmas wrapping, even if it's post Christmas. Make it for Orthodox Christmas. That's early January.
It will be post Christmas at this point.
Yeah, no, make it an Orthodox
Happy
Christmas
Boxing
gift.
Day, motherfucker.
And yeah, there you go. And just don't drop it off and I want to hand it to you. Merry Christmas. Here's what you need to know.
Yes, I'll wear a Santa suit and then a suit over the Santa suit. I'll just borrow it from Kraus so it'll fit, and then that way I'll look like a lawyer Santa.
Let's see if we can get a Stag Arms or something to give him free gift certificates for a free AR to the entire prosecutor's office. That'd be good.
No, just an AR safety class.
Yes. Don't chicken wing. Keep your finger off the trigger.
Basic rifle instructor. Yeah. Keep your finger off the boom switch.
Video titled "Crossing State Lines."
Yes, very good.
Oh my gosh, that would be good. Ugh.
That Bigner interview though is something to behold. It's hard to believe he believes it, but he seems to believe it.
He drank the Kool-Aid on himself. He drank his own Kool-Aid, which is not recommended.
Yeah, that is the problem. The con man who cons himself. Yeah, that is a problem.
And Miranda was just fluffing him, and he parroted. It's funny how so many people parrot this state lines thing, and also said automatic weapon. I was like,
yeah,
what are you smoking right now, dude? Did you watch the trial?
I refuse to give the head of the New York Bar Association a pass if he's an IP attorney. I'm an IP attorney. I understand criminal law. We're not talking about super complicated stuff. It's kind of some basics with these softball questions. So I don't care if he's an IP attorney or not. I'm an IP attorney and I can pick this shit apart. What's the problem, guy?
I was trying to be nice to him. Okay. I was just trying to be nice to him. He didn't deserve it, but I'm a giver at the end of the day. Sometimes I give nicety. Other times I give insult.
Did you forget your rules of evidence? Did you forget that stuff from law school?
Like 1L year?
We all took the same basic courses, man. I mean, come on.
Yeah, the real interview should have been him saying, if you were in New York, these are all the things that the Bar Association would be looking into you for right now. Including these contemporaneous comments about the judge on behalf of your entire office, apparently, who all hates him.
I did like the part that was so revealing. It was like, well, I'm just so used to the bark, and it just rolls off the top, and it doesn't matter to me anymore. And I'm like, oh man, Lord.
In one ear, out the other.
If I'm the judge at that point, I'm like, oh, okay, so this is not having any impact anymore. I guess we got to escalate, so maybe you'll get the hint. Maybe if I start finding you personally and see if that helps. We'll start with $500 and see if that helps teach. And if not, we'll go up from there.
I mean, joke, Binger, judges throwing money at him, pole dancing.
Oh, by the way,
make it up yourself. It's fine.
He said chaos way too many times in that interview. He's got to be quoting the chaos as a ladder from Game of Thrones and Littlefinger. Like it's he's leaning into it way too hard. He said it like 5 times.
Let's see. There are 2 chats. The judge should be back soon here, but Steve C says gas money for Kenosha trip. Oh, thank you. And Barry Soitoro says, what does Juicy and Binger have in common? They're both communists that double down on their lies. Exactly what communists do.
Miranda asked Binger if he could appeal. Did Miranda really ask that? Miranda? Someone in chat, just super chat.
Apparently at the end. I haven't gotten there yet. I'm going to probably finish it tonight.
Are you kidding me?
But yeah, he asked Binger if he planned to appeal the ruling.
I got halfway through and I was
the head of the New York Bar Association asked a criminal prosecutor after a acquittal if he plans to appeal. My faith in my fellow practitioners has reached an all-time low.
Lawyers aren't smart just because they're lawyers. Many of them are just as stupid as you think. That's my song for that group that did Conjunction Junction and the
What's
bill
Your Function?
on Capitol Hill. Yeah, that's my proposal to them.
you would oh god, you would make more money making those show tunes than you would as some of these lawyers.
I'm gonna have to find that part of the interview and just do a rant on it on my stream and just yell at old man yell at cloud style.
I feel bad for Binger. I made twice as much during his trial that he makes in a year. What an idiot.
Oh god. Hey, look, he invests wisely in appreciating assets such as lapel pens.
The lapel pin, his dress actually wasn't that offensive. I kind of liked it personally. I like the lapel pins. I like the dress. I thought it was pretty sharp. I had no problems with that. I had many problems with many other things, but it was fine.
Oh yeah, and did you catch his laugh during the interview? Like he had this laugh, and then it's like hee, and it was the most weird laugh ever. It was like a rat that was kind of like that.
Oh yes. God! Oh, blah. Blah. Gross.
And someone in chat says I normally say most prosecutors are good guys, and I stand by that. They said 99.9. I'm sure I didn't say that number, but I'll stick by that opinion that most prosecutors are good people. Most defense lawyers, most lawyers are good people. Most professionals of any field are good people. There are people who become corrupt through a whole bunch of reasons. Some of them, sometimes it's the good reasons that pave the path to hell. It's like the prosecutor knows in their heart and that this guy is guilty, and maybe he really is guilty, and for some reason they can't get him, and so they start to get.
The problem is all
the
action is at the ends of the bell curve.
Yeah, of course,
yes.
Yeah. All the interesting stuff is at the end of the bell curve, as always. So that's absolutely true.
Epic Ninja Shiro says those that can't do teach. Those that can't teach work for the State Bar Association.
The head of the damn bar asked about appeal from a criminal defense. Okay.
So the Vallow Daybell case starts in January.
Yeah, and that's what they say.
10 weeks. 10 weeks of trial.
Don't cover it, or maybe do. I don't know. It might be a total nightmare.
Just the tip.
All right, guys. I'm gonna bail and do some work. It's been fun.
Yeah, I'm gonna get some sleep too, guys. I'm gonna try to check back in, but
sure.
Thank
2
you.
a.m. So I'll see you guys.
Later.
Prior to the break, Ms. Lauren, I think we were on our last image that had been admitted. That would be Exhibit 190. And you'd agree that is a photograph of the back seat from the driver's side?
Yes.
What?
Okay, thank you. Now, in addition to searching and photographing the vehicle, did you spend any time examining the apparent blood evidence in the vehicle?
Yes, I did.
Can leather be made out of human skin?
We have a chemical test that we use on stains that are visually consistent with blood. We take a small sample of the stain, add some chemicals to it, And if it turns pink, it indicates that blood is present. If it doesn't turn colors, we conclude that blood was not detected.
Did you identify certain locations and then swab them to obtain samples of that?
Yes, I did.
And could you explain what you do with those swabs once you collect them?
Once the swabs are collected, we package them in manila envelopes, seal them, put a barcode on them as an inventory, and then securely store them until they can go up to the DNA section.
When you collect a DNA, a swab of blood, do you assign the location where you collected that from with another specific number?
Yes, we use item numbers for that as well.
Okay. And do you take photographs that mark those locations so we can look back at images you took to identify specifically where you took samples of the blood in the car?
Yes.
Okay. At this time, Your Honor, the state office exhibits 191 to 198 photographs of blood samples taken from the vehicle.
Any objection to 191 to 198? Those exhibits will be admitted into evidence and you may publish.
Okay. Now, Ms. Lauren, you'd agree that essentially these 8 exhibits are in pairs. There are 2 photographs per 4 blood samples that you collected, correct?
Yes.
Okay.
You kept going
Let's
back
look at the
to that.
first blood sample. This would be starting with exhibit 191. Could you describe the location of this blood sample?
This is on the front driver's seat,
Right.
item 22.
Now that I notice that
And you
little
can
head
see that
move
it's
she
item
does with
number
every
22 in
answer,
the
I
front
can't not
driver's
see it.
seat. Yes.
Yeah,
Yes.
Okay, let's just look at exhibit
Yes.
192 now.
it's okay. I'll do it every time you talk to me.
And you agree that is just a close-up
I'll go like
image
this.
of that item, that blood item number 22.
Yes.
Okay. Now exhibit 193. What is shown here in exhibit 193?
These are blood stains on the front passenger dashboard marked as area A.
Okay. Let us look now at exhibit 194. Now you said that was area A, but is there a specific item number identified, a specific blood sample identified with a particular BCA lab item number?
Yes, one stain was collected from this area as item 25.
Exhibit 195. Okay, what area of the vehicle is shown here?
This is that passenger side headliner or ceiling of the vehicle marked as area B.
Okay, now this image is from a slightly different perspective than we saw the headliner from the last image, correct?
Correct.
So is that
Would you agree that
blood
this image perhaps could have been
Dante's?
taken by
or
someone
is it
leaning
the
down outside the
girlfriend?
passenger side door, looking up at the ceiling of the car?
Yes, that is correct.
Okay. Exhibit 198.
I need Dexter to tell me where that blood came from.
Strike that. 196. What is shown here, Ms. Lauren?
This is a blood stain that was collected from that passenger side headliner as our item number 26.
Now exhibit 197, Mr. Miller. You'd agree this is an image looking into the rear of the vehicle?
Correct.
Okay, let's go to exhibit 198. This is zooming in on a particular blood sample, correct?
Yes.
And what item number is this?
This is our item number 27.
It is crazy interesting where blood goes. Like it goes everywhere.
Yeah.
It's all
Speaking
over.
of your lab generally, would you agree that the crime lab conducted some forensic testing of certain items as part of this investigation?
I
Yes,
did
they
a
did.
consult on a murder
And
case
some
where a guy
DNA
got
testing,
stabbed
did
once
take
in the
place.
heart with a little
Yes.
2.5-inch blade
And
knife.
the item
And it
numbers
looked like someone
assigned
took
by
a
you
fire
of
hose of
those
blood
blood
through the
samples
whole
stayed
room.
with the
Yeah.
swabs of those blood samples throughout the investigation.
Yes,
And the DNA testing was performed by your colleague, forensic scientist Eric Copen.
that is correct.
In addition to the DNA testing, am I correct that further testing at the BCA included examination and analysis of the firearm that we looked at today?
Yes,
And that examination was performed by another scientist in your lab, Travis Millard?
correct.
Okay.
Oh, another.
Oh, I hope we get to hear from him.
Mr. Copeland and Mr. Milan would be in a position to describe their work specifically, correct?
Yes.
Okay.
Oh, damn it.
That
means we're gonna- Hey, Paul. How's it going, buddy?
Good morning, Ms. Len.
Good morning,
It's Loren, do I have that right?
Lauren.
Lauren. Paul Lang is my name. I'm one of the lawyers for
Well, now you know he
former
only
Officer
buys
Potter.
Ralph
Earl Gray's
Lauren.
with me, and Amanda Montgomery. I have a couple questions for you.
Okay.
You were at the scene and you've described a collection of a lot of evidence, which was your responsibility, correct?
Yes.
And you made a list of all the evidence that you collected, and they are reflected in reports that you authored, correct?
Is
Yes.
there any evidence of recklessness?
And one of the pieces of evidence that you collected is labeled number 21 on your report. And it's denoted as, quotes, one plastic bag containing evidence classified as plant material. You remember collecting that, don't you?
Yes, I do.
And the plant material was taken from the driver's floor and the center console. Is that
What
correct?
did you do with that evidence?
Correct.
I
You
burned
did
it.
that, I assume, or one of your techs did that, right?
Yes.
And you
And some
found
rolling
that the
papers.
plant material was familiar in terms of its appearance, was it not?
Yes.
It was marijuana, at least visually, correct?
It appeared to be consistent with that. Yes.
How much experience do you have
And then you
visually
also
identifying
found another
marijuana?
piece of evidence, number 24. And the type and packages, the type and packaging, according to your report, is one plastic bag containing evidence classified as an item of evidence. And you described number 24 as a, quotes, digital scale from the center console. Is that correct?
Objection, Your Honor.
Just for mailing letters.
Objection sidebar. Oh yeah, now the state doesn't want to hear something. Holy goodness.
I thought poor Dante Wright was unemployed. Apparently not. Apparently he weighed things.
This is why I love cross exam and why I love cross exam from these two guys. They're like, what were you going to cross exam this random BCA person who just walked around taking pictures of blood on? Oh, by the way, there is actually a bunch of weed leftovers on the console and a scale for measuring it.
Enough that he had to weigh it.
I didn't even see it coming. That's great. The state is asking about all sorts of evidence that they captured that's completely irrelevant to what happened. And now they're gonna object and say, "Ooh, this scale is it's very irrelevant. Dante was a good boy." Our entire theory of the case relies on him being a good father and family man, not a drug dealer.
It was there to weigh his son, his newborn son.
That would be the best in
Couldn't a
closing
scale like
argument.
that on redirect, right? Couldn't a scale like that be used to weigh your newborn loved son? Yes, it
We
could.
heard testimony
I'll allow
from
it.
the Bureau of Criminal Apprehension that this scale was sufficient for weighing his newborn son.
That's how small his son was. Weighed him on a drug scale. What's the son's name? THC?
Your Honor, this scale was in the car that was registered to a different person. Oh my goodness. And again, I go
No
back
driver's
to my,
license, no registration, no insurance, but he's got a weed scale. And that's the formula for success at every traffic stop.
you gotta go back to this theory, or I go back to this theory. Dante Wright, obviously, they had to explain the phone calls to his mom just in case they came up. But Dante Wright wasn't calling about a car wash. He was calling about drugs because, of course, he was. Like, not that there's anything that would say that he would be doing it other than all of the evidence being pointing to it, right? And this is why every cop I've talked to and I bitch about being pulled over for something petty, he goes, you know what? Like we're just looking for drugs.
Yeah,
that's all we're looking for, because we know when a taillight's out, we're going to find drugs.
right.
And
Exactly.
it's
They do the traffic
crazy.
stops because they are so productive.
Yeah. It's crazy how accurate that is. A broken headlight is going to have drugs. A broken taillight's going to have drugs. That little light out over your license plate, it means you don't maintain the car. It means you don't maintain your life. It means you have drugs. And they're right so often that they'll do it forever.
Yeah. No, I hear stories like that from my cop friends all the time. They've never seen a Buick with like the license plate light out that doesn't have drugs in it. I mean,
yep.
Every single time they pull over a Buick that has some kind of light out, they find drugs.
And it's also why if you don't have drugs in your car and you're not a teenager or really young adult, they don't ticket you. Like I stopped getting tickets when I got slightly, like I drive I have a Ford Fusion or whatever, and it's slightly nicely appointed. And so once I got that car, I never got a ticket again. That was it. Like that's all it took. It was a slightly nicer than entry level car and not being 21. Cops no longer give you tickets because there's no reason to. If you don't have drugs, they don't care. And if you're not a kid, they don't need to teach you a lesson. So they just let you go, or they let me go. I don't know. I also say no to everything they ask, but yeah, Don Gamer Guy. Yes, he says gonna go replace all my bulbs on my Buick. Thanks, Andrew. No, seriously, yeah. And if you drive a beater, you're more likely to get pulled over. If you look like a teenager, you're more likely to get pulled over, because they think you have drugs.
Man, this sidebar is going on forever over this drug scale. Holy cow! I thought we were on another break. I looked at the screen. I was like, oh no, they're still in sidebar.
These prosecutors don't want evidence that this guy was just a piece of shit. Like he doesn't deserve to die.
The objection is sustained.
Wow.
The jury will disregard the question that was just asked. You may continue, Mr. Lane.
Ms. Lauren, did you test the plant matter as a part of your lab process?
No, I did not.
Do you have any reason to believe that, given your experience with the BCA, that it was not marijuana?
Objection calls for speculation.
I'll let you answer. Go ahead.
I don't perform drug testing, but the visual appearance made me decide to collect it. Yes.
Based on my personal experience.
Because you thought it was contraband.
It was plant material that looked familiar to me.
If it was basil, would you have cataloged it as evidence?
BCA process, you also took a blood sample from Officer Potter that evening, or had someone from a hospital.
What was her level of THC?
A toxicology sample was submitted to me, yes.
And that was tested as well by the BCA, right?
By a different scientist, yes.
And nothing was found in her blood, is that correct?
I actually didn't review the toxicology results.
No further questions.
Is there anything further from the state?
State has no redirect.
No.
State has no redirect.
Okay. All right.
Even she's surprised that the state doesn't have more inane questions.
The state may call its next witness.
Your Honor, this time the state calls Agent Fred Peterson.
All right, another BCA guy. We get another 20 minutes of introductory questions before they get to the 3 relevant ones.
Hey, Agent, will you please come forward? Stand behind the witness chair and raise your right hand.
I mean, we're 2.5 hours into the day, and all we've learned is that Wright was shot in his car through the heart and drove a block down the street and crashed.
But we also learned that Dante
remove
Wright
your mask.
had a
Thank
scale for dealing
State your
drugs that
full
we're supposed to
name and
disregard.
spell it.
My first name is Brent, Brent. Last name is Peterson, Petersen.
All right, couple things to keep in mind. When testifying, the court reporter is taking everything down. Only one person can talk at a time. Wait till the question's finished before you answer. Yes or no questions instead of shaking your head. No or uh-huhs.
Lisa Chat
If
can
an
stop crushing
objection
on
is
the
made,
witness.
stop talking immediately.
I mean, or you could
Don't
start if
answer
you're
the
into this
question
salt and
unless I
pepper
tell
kind of
you
guy.
to.
Go for it.
And if you don't understand the question, please ask for clarification.
Yes, Your Honor. Thank you.
Counsel?
Could you state your occupation for the record?
I'm a special agent for the Minnesota Bureau of Criminal Apprehension, the BCA.
How long have you been with the BCA?
5.5 years. I started in June of 2016.
What unit are you currently serving in?
I'm in our force investigations unit.
Now you're a licensed peace officer, correct?
Yes.
And you take continuing education courses to maintain that license?
Yes.
Prior to working for the BCA, did you have other law enforcement experience?
Yes.
Could you explain that experience to the jury?
From 2001 until 2005, I was a police officer for the University of Minnesota Police Department here in Minneapolis. And then from 2005 until 2016, I worked for the Rochester Police Department in Rochester, Minnesota, where I was a patrol officer, investigator, and a sergeant, a patrol supervisor.
You were promoted to a detective level as early as 2008, correct?
Correct.
In regard to the BCA, you arrived in 2016. Could you describe the roles that you've had working with the BCA?
Sure. Initially, I was hired to work in what's known as our predatory crimes section, which dealt with primarily child pornography, predatory offenders.
Joseph
human
Rosenbaum.
In November of approximately of 2016, I transferred to our homicide unit or homicide section, excuse me, here in the metro area.
In all of that experience, dating back to 2008 with Rochester, through all of your time in the BCA, that's all been investigative?
With the exception of 2 years, 2014 to June of 2016, where I was back on patrol as a sergeant with the Rochester Police Department.
Okay. Now, as part of your work in the Force Investigations Unit, you'd agree that you work on officer-involved shooting cases?
Yes.
Agent Phil has told the jury about your unit. I just want to know a little bit about your experience in that unit. In the 6 years you have been with the BCA, how many officer-involved shooting cases have you worked on?
I'm right up around 73 use of force investigations.
Okay, so use of force investigations, do all of those include fatalities?
No,
How many of
Should
those
they,
included
though?
fatalities?
I don't know.
Okay. How many of those cases have you been the lead agent on?
13.
And is there a role other than lead case agent which you have served in?
Yes.
And what is that?
Sometimes we have co-agents, co-lead agents. Other times it'll be something as simple as my only role will be to attend an autopsy or something like that.
Okay. In support in various ways?
In support, correct.
Okay. For example, in the case involving Kim Potter, what was your role?
In support of the case agent.
All right. I now want to talk about this case, April 11th of 2021. Do you recall that day?
Yes.
What were you doing?
I believe it was a Sunday, so I was at home and off duty.
Did you receive some information
Watching
that prompted a
football in my
response from you?
underwear.
Yes.
And what was that information?
I was notified with other members of my team that there was an incident in Brooklyn Center for which we had been requested to investigate.
Okay. And would you agree that essentially that information prompted you to respond to 63rd and Catherine in Brooklyn Center to assist Agent Phil in the investigation of this case?
That's correct.
Okay. And would you agree you arrived at scene about 5 p.m.?
That's correct.
At the time of your arrival, was there any personnel from the BCA present?
Yes.
And would that include both Agent Phil and other members of the crime lab team and other agents from the BCA?
That's correct.
What actions did you take at the scene upon arrival?
When I got there, I parked outside of the perimeter that had been established.
I finished listening to
I met
my
with,
Jimmy Buffett song that
Agent
was playing
Phil,
in
who
the
was
car
my
before getting out.
supervisor, as well as with Melissa Lauren, who was our crime scene team leader, and just kind of information was a little vague at the time I got there, but more was coming in. Just kind of got an overview of the scene. I made some observations of the scene also.
Yeah. Did you spend any time attempting to find witnesses?
I did, yes.
And was one of the witnesses that you ultimately spoke to a Carrie Blansky, a neighbor?
Yes.
Did you later obtain a video evidence from Ms. Blansky?
Yes.
With regard to a vehicle that was at the scene, a white Buick, did you assist in towing that vehicle?
Yes.
And where did it get towed to?
BCA headquarters in St. Paul.
Okay. And do you remember how long you were at the scene?
Probably about 2 to 2.5 hours.
Okay. So you left perhaps around 7:30 p.m.?
That sounds right, yes.
All right. Now, in addition to the work that you've done, in this case at the scene, or you did at the scene, did you gather additional evidence during the course of the investigation?
Yes.
Okay, I want to talk about some of those tasks, but not all. Do you recall continuing your work on the case on April 13th by going to the medical examiner's office?
Yes.
Why did you go to the medical examiner's office?
There were a few items that were available for us to pick up that we needed to get some of those submitted into our laboratory for
Was one of
further
them
testing.
a drug scale?
Did you pick up those items?
I did.
What were those items?
Did you weigh them?
I picked up
Did you have a
5
scale
items.
handy by coincidence?
One was a what's called a blood on spot card. It's a DNA sample from the deceased. I pulled a projectile or bullet. I acquired fingernail clippings from each hand of the deceased, and then pulled head hairs pulled hairs from the deceased.
Okay. And you agree that the blood sample or the blood spot was for another person to conduct DNA testing?
Yes.
Okay. And
We're gonna have to hear from that person
this
too.
fired bullet, that also was collected for subsequent testing?
Correct.
And am I correct that you transported these and inventoried these at the BCA?
Yes.
Okay. And were each of these individual items assigned an item number?
Yes.
And would you agree those items are just the 5 items you said, 29.1, 0.2, 0.3, 0.4, 0.5?
That's correct.
Okay. And that blood DNA sample, that was the one that you identified as 29.1?
Correct.
And the bullet that you recovered, that was identified as 29.2?
Correct.
And are you aware that that blood sample or that spot was later issued a separate BCA lab item number as item 30?
Yeah. Yes.
And that fired bullet was issued a separate BCA lab item number 31?
Yes.
All right. When you collected
cumulative?
that
This is
fired
pointless.
bullet, you know that it is now affixed with both your item number 29.2 and the BCA lab number 31, correct?
That's correct.
Okay. At this time, the state offers Exhibit 201.
Because we wouldn't want to get all the fired bullets mixed up.
Exhibit 201 will be admitted.
On the stand looks like Alan Tudyk. Kind of. Yeah. Yeah, like in 20 years.
Someone commented that Larson looks like a Muppet. Now I can't stop seeing the little rods
Yes.
that go to his wrist.
You have permission to publish this item on
You just wanted to go. "Ah!"
Whoa.
Did he just say whoa? Well, oh, is he using an overhead projector?
Now,
Okay. Haven't seen
No,
one
that
of these
can't
in
be
action
true.
in a while.
Agent Peterson, did you have an opportunity to look at this fired bullet?
At the time of my collecting the item,
No, I'm sorry. Recently, as it appears to you here.
yes, recently I had.
Okay. And did it have, were you able to identify the type of ammunition it is based on your inspection?
Yeah, that appears to be hollow point ammunition.
Okay. Now, are you familiar with hollow point ammunition, given your experience in law enforcement?
Yes.
And are you familiar with what happens when hollow point ammunition hits an object?
It
Yes.
blows up.
What happens?
Generally, it's designed to, the term is mushroom or kind of
It
fold out.
mushrooms
like you
more
see,
in an
it
African
appears.
American victim because the
And that
police
is to
bullets are racist.
slow the slow the velocity of it as it hits an object, and also it creates kind of a larger wound.
I mean, that's
can
perfect
cause more damage
expansion.
to tissue and
I'd love to know what that
organs in a
what the
person.
manufacturer actually was.
Because what you're saying is when
I
it's
wanna buy
designed to
that
slow
ammo.
down,
I wanna
it's
buy that
actually
ammo.
designed to use the body as drag to slow down.
Right. Yes.
And I'd like to turn
Someone
your attention
commented
back
Wright was
to
a
the
weed
morning
guy,
of
but he ended up with
April
mushrooms.
12th. Did you learn that the BCA had received some video evidence regarding this case?
Yes.
And what video evidence, did you review some of that video evidence?
Yes.
What video evidence have you reviewed?
I reviewed body-worn camera video from Officer Potter, Officer Lucky, and Sergeant Johnson.
Okay. Did you also review a squad video?
Yes, the squad video from Officer Lucky's and Officer Potter's squad car.
And did you review the time frame which captured the incident we're all here for today?
Yes.
And you ultimately wrote some reports about your review of those materials, correct?
Correct.
In preparation for trial, did you examine those videos, particularly specific moments or stills of those videos?
Yes.
And those still images isolated specific moments which attracted your attention, am I correct?
Correct.
Someone in the chat says 9mm federal
Are
Hydra
they fair and
shot.
accurate sort of excerpts or taken from the videos?
They still
that we've
issue
seen
that
here
to
in trial?
departments. I mean, those were big in the 90s, but
Yes.
Pardon me, that you have reviewed?
That I've reviewed, yes.
Okay, I now want to go through a series of still
there's
images.
better rounds than Hydra shocks out there today.
First, I want to direct your attention to a particular moment as the defendant approaches Dante Wright's vehicle. You recall seeing a moment shown on the squad video which attracted your attention?
Yes.
Okay. What did you perceive occurring at that moment which attracted your attention?
We objected that something to be heard.
Yes.
Okay. Kind of curious what this objection is. I would love to hear. So the question was, when you're reviewing someone's body cam footage, were you drawn to a particular moment of the footage? And he said yes. And he said, can you describe the moment that you're drawn to? And they've objected to it. I mean, not sure what the objection necessarily is.
I mean, I would expect this kind of thing to be dealt with on cross, but anytime you take a video, if you look at every frame, you can always find something to talk about eventually. But that doesn't mean that's what the defendant saw. I mean, Binger tried to do the same thing with the fight out in the street, right? Afterwards, he turned that few seconds of video into dozens of separate photographs.
He's like, we have 800 frames to go through here. I won't go through all of them. And then went through like 500 of them, unironically.
Someone's asking, is there a legal basis for which ammo is best for self-defense, legally speaking? No, it's always the wrong ammo, whatever you pick.
Yeah, you cannot buy the proper ammo to put through someone.
Buy something that first operates reliably in your gun, meaning always. And second, if you have the option of good terminal ballistics.
Yeah, this is so what do you think? Oh, I wanted to ask this question earlier. Mithrin Emrys sent a prediction, and he says, prediction, defense will close out the day with another motion for mistrial based on the state once again spending 90% of the day presenting nothing but cumulative evidence that does not bear on the facts and controversy.
Sure, why not? I mean, I would.
Might as well.
It's going to be denied, but may as well do it.
Yeah, do it. And just to clue the judge in, judge, while we're making objections to this cumulative evidence, this is why. So hopefully tomorrow, when we make objections to the subsequent cumulative evidence, you at least stop it at some point.
I mean, Friday is the last day I can put on this case. So if it continues into next week, it's really egregious.
Yeah. So Friday is the 17th. By the way, guys, I turn 40 on the 16th, so that'll be fun.
No kidding. My birthday's tomorrow.
Really?
All
Well,
right, the objection is
happy
overruled.
pre-birthday. Objection's overruled. Okay, we don't know what the objection was. We don't know the basis of the objection. It didn't seem like a great objection to me because if they're going to allow him to talk about reviewed body cam evidence anyway, I don't see why he couldn't talk about the specific scene that caught his attention. And as a BCA,
can they bring to the witness stand every person on the face of the earth who's seen the body camera video and get their opinion on it?
Your Honor, one quick.
Oh, good. Another sidebar. I mean, the one thing I would argue in this case is a BCA investigator reviewing body cam footage and then testifying to some specific thing might actually have some relevance to how they conducted their investigation.
Well, at least they're back at the traffic stop scene.
Yeah. Yeah, exactly. Like, again, I'll take that testimony all day over the rest of the testimony in the trial. I am curious what this guy found interesting about the video, just in case it's something different than what I've seen. But I can't imagine what it would be that he found interesting. Did you notice the malice in the way she was holding the gun? You did, didn't you? In your experience and training, have you ever known someone to maliciously hold a gun without murdering a man?
Is it possible she shouted, "Heart, heart, heart, not taser, taser, taser"?
Did you notice the serial number on the gun actually matched the one used to kill JFK? Would you agree that it was a sawed-off rifle converted into a pistol?
She gave the gun a little twist like the movie Wanted.
Is that the one where they were
curve it through his
shooting the
heart
bullets?
with Angelina Jolie?
Decaf Geek says, overhead projector. This witness brought to you by late 1980s 5th grade science class. I love how overhead projectors now are a camera that then projects an image.
Yeah.
It's like, I guess the giant lens and mirror setup was just too cumbersome. It didn't work.
Well, they were still using them when I was in law school. That was a while ago.
Automata said, I'd love it if he said, what I found interesting was when I saw that scale. Marylander asks, what are your guys' thoughts on open carry?
Well, I'm a Second Amendment absolutist, so I think it's a absolute constitutional right for law-abiding, mentally sound Americans. I would never do it, though.
Jury, we're just going to take a short 15-minute break.
Ooh.
Okay? So, have a good break.
What?
There's some poop that has to be settled.
That's interesting because she ruled in favor of the state on the objection. Then the state called a separate sidebar for something else. Something must have come up during the objection that the state wants to get cleared up ahead of time. Otherwise, the defense is probably going to object like 10 times in a row to the line of questioning that will follow. That's my guess.
Maybe during the discussion of the objection, it became clear that if the state did go ahead with this, the defense was going to respond in XYZ ways, right?
Down.
Yeah.
And now they don't want that.
Please.
Move for a mistrial.
Like when Krauts tried to admit that evidence about what a hero Huber was, or at that family picnic to put out that fire. And they said, well, you can do that, but then we're going to introduce the evidence about the knife to his brother's stomach.
Did you realize that when reviewing the video of the dash cam, that Dante Wright, even while they were attempting to arrest him, was actually rescuing orphans between frames? He is the Flash, and he was quickly running off to save orphans from burning buildings. And he also saved 3 cats and returned them to the same female owner who is 68 and unmarried. Oh, they're doing it in sidebar? God,
it's amazing.
Do it. You dismiss
the witness. Possibly make it more boring.
Why would you dismiss the witness and the jury and then do this in sidebar? Just do it in open court on the record.
So we're going to have 15 minutes of this.
Yeah.
And it's never just 15 minutes.
Oh, are they done in?
Oh, what?
They're done in. Now they're
going
gonna have
to
to
lay some foundation or something. What?
Are we gonna put it on the? Nope.
They're just taking a break.
Lead prosecutor's like, Your Honor, my co-counsel has to poop really bad.
All right.
Well, that was enlightening. Very riveting. 15 minutes? They're right before lunch. I mean, they're going to come back. It's 11:38. They're going to come back at 11:50, effectively. And then, or even 11:55. And then they're going to question him for another 20 minutes and then go to lunch. So prosecution might finish up their questioning and then go to lunch. Let's see. Ryan Dunson, CFE, says Andrew Branca is absolute gold. Thanks for bringing him on, Nick. Hey, no problem. It's my pleasure to have him on here and have someone to suffer with me through this horrendous slog of a trial in many ways. The only reason I'm waiting for the cross, before people get any particular ideas about biases, again, I don't care if Kim Potter goes to jail. If she goes to jail because she did a bad thing, then she goes to jail. I don't think she did a bad thing. I haven't seen evidence of it. But the reason I wait for cross is that's the only time we get testimony about relevant facts, because the state is just flooding information into the jury, who are they're dying right now. This jury's eyes are glazed over. They're sitting here going, oh, another person from an agency I don't understand is going to testify about things that happen later.
If they showed the jury right now, they'd all be wearing eyeglasses with eyeballs painted on the lenses to make it look like their eyes were open. They hate
being there as much as you guys hate watching through the inane questioning. If you bring in a witness that isn't particularly relevant, but is at least animated and entertaining, or has like some character personality, the jury might actually perk up and listen. But these people are BCA people. They're straight laced.
The witness is dull, but at least has something relevant to say. That kind of contributes to the legal arguments that ultimately have to be made here. I mean, that would be interesting. That's what's interesting to me as a lawyer. How are they going to build this narrative of guilt, all the way up to a closing argument that'll be compelling for the jury beyond a reasonable doubt? That's what I keep waiting to see. And every day we watch this trial, and I don't see any progress made in that direction. That's what's frustrating me. And listen, I'm not, Kim Potter's no friend of mine. I don't know her. She doesn't mean anything to me on any kind of personal level. If she gets convicted on the merits, it's nothing to me. I do care a lot about the process, the legal process, because that applies to every defendant, no matter who you are, including any of us. But when I see prosecutors engage in just nonsense that appears to be happening in this trial, that we see in other trials, like the Rittenhouse trial, the violation of what I consider the due process of law is, that's offensive.
Let's see. Hold on. I'm sending a couple invites out to people who have let's see. People who may join the stream. Stream link.
So while Nick's doing that, I'd like to share an anecdote with the audience. We had a call come into my office over the weekend. Somebody who was involved in a use of force event. They've been charged now with felonies, and they were looking for a consult from us on their case to try to help get the charges dismissed or whatever the positive outcome might be. And folks, one of the higher level services we offer at Law Self-Defense is what we call our platinum membership. Our platinum members, if they're in an event and they call our office, we literally drop everything. We drop covering this trial, we drop Christmas, we drop any vacations we have planned. We are on your case immediately, providing the consult at no additional cost to you. And the typical cost for a consult for us is in the range of $10,000. So normally they're not inexpensive. But if you're not a platinum member and that call comes into our office and I'm busy doing other stuff, I can't help you. And I had to tell this guy no this weekend. And he's not happy about it, and his legal counsel's not happy about it. but I have a limited amount of bandwidth, and so if you don't want to be in that person's position, our platinum membership is maybe something you want to take a look at. We don't usually pitch it because it's higher value. We prefer people get more comfortable with the law self-defense community before they take a look at something like that. But if anyone is interested, you can get information on it at lawselfdefense.com/platinum. But if you're not a platinum member, I'm at 150% capacity most of the time. And the only time we carve out an exception to that is when one of our platinum members calls.
Well, there you go, guys. You got to be platinum members. If you need that sweet consultation, you got to get the platinum membership. And that's that goes to what we've been talking about a little bit with lawyer fees and how much things cost. So we got into that I think on Friday. People were talking about someone was talking about how expensive lawyers are and how it's crazy. It's like, the reason lawyers are expensive is because somehow, despite there being literally infinity lawyers popping out of law school every single day, there's always more legal work to do. And in certain areas of law, like criminal defense, which is not as sexy as personal injury or whatever, there's an abundance of need for various representation. And so the reason that fees go up is because you have to eliminate some frivolity from your inbox. If your fees are really low, people say, oh, hey, I'm thinking about suing this person because they said something 8 years ago that might do this and might do that. Like you'll get those emails all the time, requests for representation on stuff that is crazy. I mean, I had a guy offer to pay me significant amount, like basically an annual salary, to just file lawsuits against people that he was mad at every single. I was like, no, that's okay, buddy. Like, I don't want to sit here and file basically frivolous lawsuits from things people said to you 8 years ago. But that will happen if your fees are low enough. So the reason that lawyering costs so much is because of how much bandwidth each case takes to put actual care into it, and then the amount of people who need the work. Because you work in an extremely limited field of law, right? Like,
yep.
Self-defense claims that require an expert in self-defense because they have any merit to them at all, plus have a client who's moneyed enough to hire a private consultant on it, is very narrow. And yet here you are, still very busy.
30 years in.
It's amazing how much work there is. But I guess we can all thank the state for being so active in prosecuting things that either do or don't need to be.
I mean, we really prefer, frankly, these consults, as expensive as they are, is not the most productive use of my time. We don't pursue these cases. These cases come to us. I much prefer that people get a copy of our free book and learn what not to do in the first place. Most of the cases we consult on, there were lots of exits off that road to a prosecution that client could have taken. They made poor decisions. Most of the time, they didn't make poor decisions that, neutralized their justification of self-defense, but they got into fights they did not have to get into. And if you just learn what the rules are, it's not that hard to stay within them and still be able to effectively defend yourself. I'm trying to think now if we've ever had a case where someone had read our book before they got in trouble. I'm not sure we have, because again, where the rules are. It's not that high to stay with them. So I'd much rather sell a $10,000 worth of books to a lot of people than get one consult for the same price and be helping only that one person when they're in dire straits.
Yeah, exactly. It's that's an interesting thing. Again, this came up on Friday. If you watch the nighttime shows, by the way, they are spicier, but they also have lots of good information in them as well. And on Friday, we discussed the fact, we discussed the difference. Lawyers are often representing one client in a specific situation. They have to get into the nitty gritty on facts. They have to figure out how to protect or prosecute this particular person on that had a incident on this particular day under these particular circumstances, and they have to weave those things all into a narrative about a client to convince a jury that they're either guilty or innocent. But in general, that's one person, and it will only ever matter for that one person. Like
Right.
the Kim Potter trial is kind of instructive for other police officers, but other police officers, the overwhelming majority of the time, are not going to be involved in a situation that involves this set of facts where you have this clean of a stop, this guy resisting, your subordinate training officer not closing a door that allows this guy to get back into the car. You've got now 2 officers in the car. You go to pull a taser and you pull a gun. Like, the level of factual specificity of a case like this makes it unique. However, what lawyers like Andrew Branca are doing are talking in about these general principles that can prevent these types of situations in general. And that reaches far beyond this one individual person. So we have different purposes going on, but there's some people out there trying to educate as many people as possible. I'm trying to shed light on these legal processes where I can to as many people as can possibly see it. 1, because the more people see it, the better I do financially. But 2, because it exposes more people to the system than I could ever do representing one person
Right.
in a case in small town Minnesota.
Yeah, it's a weird dynamic because it's super productive for that one client.
Right.
But for the other, 150 million gun owners in the country who might find themselves feeling compelled to use force in a self-defense situation, it doesn't help them at all. In fact, it's the opposite, because it completely takes me offline from the normal work I would be doing.
I got an email real quick, and this is an interesting question, but we'll talk about it. He says, why did Kim Potter not see that she had a firearm in her hand is the subject matter. And he says, from tactical training, if your target is at very close range, you focus your eyes on the target location, not the front side of the weapon. The shots can be made faster and hits will be accurate if grip and trigger press are good. When the other officers are, okay. So the question was rhetorical, and he's providing a reason why she didn't see it. When the other officers are nearby, it would be even more important to see that the target is clear. Taking careful aim with the front sights gives you some degree of tunnel vision and is slower, while aiming part of another officer's body could move into the line of firing. Kim Potter had a lot to watch going on.
Yeah.
I propose
it's not normal human, psychology or physiology to look at the front sights of your gun when you're shooting. We have to train ourselves to overcome the normal state in order to do that. The normal state is to look at the threat.
Yeah. And that's the interesting thing about this, that the prosecution is likely going to try and focus on. They're going to try and focus on the fact that Kim Potter's firearm is in the frame of the body cam footage for 5 seconds in their closing argument. I mean, they've shown it, so they don't need to really belabor it and it doesn't matter for witness testimony, except when they get their expert on, they may do it there. But just in general, in closing argument, they're going to play that video, maybe even just that 5.5 seconds that her firearm is in view. But it's important to remember that your body cam is down here, and that firearm being directly in line with the body cam with your arm bent, you may not even see your own hand when you're looking at this ruckus going on in front of you. And so she likely didn't even see what was in her hand until the moment she's about to fire, if even then. When she moves the gun forward into a firing position to kind of clear to check the target and aim somewhat. But she's at such close range, she doesn't need to do much aiming. It's not like she needs to sight on Dante Wright from 3 feet away. You just kind of point it near him, especially with the taser. You don't need to sight at all. You just need to make sure the taser is going to hit the person. Those 2 prongs will hit them. The taser will do its job after that. So, I think there's a lot of people have talked about how could you not know? How could you not see? How could you not do this? And the reality is that you've got some struggling person in front of you who's put your 2 co-officers in danger. I mean, that's simply how you don't know.
It'll be interesting too to see if, if I were the defense, At this point, I'd be leaning towards making almost like a public policy argument for acquittal here. And I think if Kim Potter testifies as they say she should, her testimony should feed directly into this. And that public policy argument would be, hey, we hear all the time, you know, there are circumstances in which all the check boxes for a police officer to use deadly force have been checked. They are privileged to use deadly force in that particular scenario. But an officer may feel, you know what, even though all the check boxes are checked, I could shoot this person. I'm going to take a chance and try the taser first, right? Because they're 16 years old, or I can see something in the expression of their face that kind of subjectively tells me that they're not someone who's likely to use a gun, or whatever the cop may see. Or he's just averse to having, you know, to the thought of killing someone at all, even though he's a police officer, as we all should be, by the way. And he decides, even though all the conditions to privilege me to shoot this person have been met, I'm going to give the taser the shot. If you convict Kim Potter, what cop would ever make that decision again? Because he knows if he tries to give the person the benefit of the doubt and use only non-deadly force when he'd be privileged to shoot and he screws it up, this is what's going to happen to him.
Yep.
So we hear a lot about, hey, we want to change police training so the police are, you know, use more discretion or slower to go to deadly force, even when it would be technically permitted. This blows that out of the water.
Yeah, and it's interesting because they actually get kind of two shakes at it. One in closing argument, and they get another shake if she's found guilty. They can incorporate that into an appeal on the issue, and you can actually make. So we've talked about this a little bit. She may have been privileged to use deadly force. I think she was. I think there's enough evidence to say that legally she's privileged to use deadly force. The question is the legal gray area, to be more precise, is that we don't know if you lose the privilege to use deadly force by electing not to use deadly force.
Right.
So if she had just pulled her gun and shot him, probably justified, but because she thought she was pulling her taser, she yells taser, 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 might not be justified because she may have lacked the subjective fear to use deadly force.
Right.
I don't
but
know
that's not what she would. That's not what she's going to say. Obviously.
Right.
Right.
And I don't think you can credibly say someone lacks the subjective fear to use deadly force because they chose not to, but that's kind of how that argument can play out.
You can make that inference, but she'll counter that inference by saying, no, I knew I could shoot him lawfully. I knew because my partners were in danger, right? They were about to be dragged by a vehicle. This guy he was out on the warrant was for a gun charge. There's lots of grounds. And remember, she's privileged unless the state can disprove it beyond a reasonable doubt, right? That would be the legal standard if she'd shot him intentionally. And I think there's much more than reasonable doubt that she was privileged to use deadly force here. So I think there's a counter to the inference. Of course, the state will make that inference, but I think if she's going to testify, now, if she wasn't going to testify, they'd have some difficulty here, and that may be why she's going to testify, so she can make those statements in front of the jury into evidence. I knew I was legally privileged to use deadly force there. I was trying to give this kid a break. I screwed it up, but my intentions were within the legal boundaries of the law.
Oh, okay. Here we go. So there are, yes, that is correct. And that is, that's kind of what I was getting to on the, so, appeals can turn on a legal matter. They can turn on a statutory matter. They can turn on case law that exists that shows that a statute needs to be read in a certain way. The other way they can turn is on what's called a public policy argument that you mentioned. This idea that, look, the law is ambiguous enough that we should rely on public policy concerns to make your decision here. And so that's if there's this weird gray area, which we kind of have here, that we can say public policy dictates that we would actually prefer cops to use the less lethal option, not be penalized for using a less than lethal option if they want to do that, even though they may still be preserving their right to use deadly force when it's justified.
Right. And you see these cases happen, right? Where you have a suspect walking around the street with a gun in his hand and he's threatening to kill people, and the cops approach and, hey, listen, if you see that guy and he's threatening to kill people, that checks all the box for deadly force. But every once in a while, a cop will take the personal risk of going out there to talk to that guy. and try to talk them down or get close enough to use a taser or a beanbag gun or something other than lethal force on that person. They're not required to do that under the law because they're dealing with a suspect who presents as an imminent deadly force threat to innocent people. But sometimes they'll make the effort anyway. If you convict Kim Potter here, you're stripping away. Why make that effort? Because if something goes sideways, they're going to find themselves prosecuted and looking at a jail cell for the rest of their lives.
Yep. And so two things have happened actually today that I wasn't aware of. There have been 2 motions filed by the state that we may look into as at the lunch break, which will be coming up in about 35 minutes. The 2 state motions, just as an intro, the state moves the court for an order precluding the defendant from offering improper lay opinion testimony through any witness. And the state hereby moves the court for an order precluding or permitting the state to elicit testimony related to union membership and employment for the purposes of establishing possible bias in law enforcement witnesses. So we've got that came up yesterday in response to Officer Johnson, or not yesterday, Friday. Officer Johnson testified briefly, or he was asked about the union membership, and they they objected to that. And so now the state is asking for permission to ask about that for bias purposes, that because they're a member of the same union, they would be biased in favor of this person. And I'm kind of torn on that because I hate unions a whole lot.
While we are waiting for court to resume,
I mean, for that limited
I just wanted
purpose,
to let you know that
that's not why they
took a
really want
brief
to ask
break
about
here.
it. They want to ask about it because it goes to her lawyering up.
Right. Yeah, that's what they wanted to do. You called the union rep because you were going to get a lawyer, because you were guilty, because you said, I'm going to prison, which for those, many people have asked this question. No, it's not recommended to say I'm going to prison after something. However, it's not legally relevant. It may be somewhat relevant to a jury, but it's not legally relevant to your case.
Yeah, I mean, you may think you're going to prison because you're afraid you'll be wrongfully convicted.
Right. Your conclusions of law are not relevant to whether or not you actually violated a law. Especially your post facto conclusions of law are not relevant to whether or not you violated the law. If you have testimony that says, look, if they caught me doing this, I'm going to go to prison, and then you do the thing, that goes to state of mind, that goes to criminal intent, that goes to a whole bunch of things. After the fact, while you're screaming and wailing in the road hysterically, is not going to be the nail in the coffin the state wants it to be. But they do want that to play a lot for the jury. Chris Harris says, is Andrew one of the lawyers through the USCCA network? How does he feel about programs like that? No. I can never remember the name of the company.
Yeah, I mean, I don't have a real formal relationship with any of these
Right.
groups. I do some partnering work with CCW Safe. They're the ones. I'm a member of CCW Safe. I recommend people, if they're interested in these kinds of things, they at least take a look, consider CCW Safe as an option. None of these plans are perfect for everybody, so what fits best for you, only you can decide. If you want to learn more about CCW Safe, you can go to lawselfdefense.com/CCW Safe. And I think we have a discount code LOSD10, the number 10. We'll get you 10% off your membership with CCW Safe. But I'm not formally, I'm not employed or have any kind of obligation to provide legal services to any of these groups.
This guy says, Andrew, damn it. Says, Andrew, my wife's boyfriend has never used force to get me involved. Not sure if your book is for me. Stop it. Project's done poorly says, please EFAP the Idris TV Jussie skit. It's worth your time. We'll see. We'll see. Not during the daytime stream, but maybe a nighttime stream. Lot of good material for nighttime streams this week. So we are still at muted
when do you
audio.
Sleep, man? When do you sleep?
Not enough.
Good Lord.
Not enough. I usually lately have been taking a nap between my 2 shows for a little bit to make up for it. But excuse me. On Friday night and Saturday night, I slept a whole lot. Last night I didn't because I was dumb and decided to I spent like 4 or 5 hours in my Discord chat talking with my subscribers on ricadalaw.locals.com. Typically I do a live chat every Wednesday, but since the trial's been going on, those have been not as doable and not as long in duration. So I spent a good amount of time talking to a bunch of people last night, but then it went long because I was just hanging out. Terrible plan. As
Yeah,
you know, right?
Yeah. Oh, my wife let me know about it. Someone asked me if I can give some like high points on CCW Safe, why I like them without referencing any other program. I'm happy to do that. Some of the things I like about CCW Safe is there's no cap on their coverage. They'll continue to pay your legal expenses even after you're convicted. If you're appealing your conviction, if there's a hung jury in a retrial, they'll cover you for the retrial again. As many times as that takes. They have a great, their own investigative team that comes to the scene, which is so important to ensure evidence is gathered, that witnesses' names are captured. The police don't always do that stuff, folks. And they have a fantastic national trial counsel who's kind of their lead lawyer for these cases. That's Don West, who is one of the attorneys for the George Zimmerman trial. And Don and his co-counsel, Mark O'Mara, that was a perfect legal defense in that case. And I watched every minute of it. So any case that has Don working on the defendant's behalf is way advanced compared to a case that doesn't have him on it. So those reasons alone, I'm a fan of CCW Safe.
And if you think about the Chauvin trial, which was not a self-defense trial, however, I think it's illustrative of an issue you have. Chauvin's defense was paid for by his police union, but once he lost, the appeal comes up, and the police union says, "Nope, we're done. We're not paying anymore."
He's got a public defender now.
He does. I don't think he even has one. He failed to qualify.
Oh, did he?
Yeah, he didn't qualify for a public defender. Didn't qualify for informa pauperis protection.
I guess he still has a house.
Yeah.
So they're going to make him cash out his house before they. Yeah.
He has a house, and I bet he has an IRA or a 401k, or I guess it'd be a 403b because he's a police union.
Yeah.
But so he's got some sort of retirement plan.
Right.
And this is the killer. Guys, if you're ever doing this, don't make the mistake that Chauvin did. In his pro se representation, he said that if he cashed out his 403b or his retirement plan, he would incur a significant penalty from the IRS, which would then put him at a problem. The problem is all the judge heard was that he has assets and means that he has access to and is refusing to access because of something. But they don't really care about the penalty that you would suffer.
No.
The fact that you have the money for legal representation means you can pay for legal representation.
You have to really be pretty much destitute, folks, to qualify for a public defender. It's not just a free lawyer.
Yeah. So we talked again, another thing we talked about on Friday, public defenders. Oftentimes people will be legitimately impoverished and not qualify for a public defender. You have to, if you own anything, you own a car, sell your car. If you own a house, sell your house. If you own some piece of artwork, sell your art, sell whatever it is. Oh, you got an inheritance. Oh, you got a retirement plan. Oh, you got a rainy day fund that you've been saving up because you're a responsible Dave Ramsey investor or whatever.
Yeah. Your kids have a college fund?
Nope. Yep.
Guess what?
Get rid of it. Get rid of it. If you can pull it out, even at a penalty, you're going to have to. The state does not want to pay for your defense. You're constitutionally entitled to it. They don't want to do it anyway. So, yeah. So a thing like CCW Safe or whatever, who's going to pay for those retrials if you get a mistrial. Remember, one juror is a mistrial. If they're going to pay for your appeal, I mean, that's huge. That's huge news. Your appellate costs, your trial costs are going to be a lot. Your appellate costs aren't going to be as much, but that's only in respect to how much your trial court costs.
Yes, that's right. And also you probably expended whatever resources you have on the trial in the first place to try to not get convicted. Now, what do you have left for your appeal? And an appellate court it's going to be less expensive than the trial, but appellate work is expensive work, folks.
Yeah. I mean, you're talking for an appeal. you're gonna be 50 grand deep. And that's just a testament to how much the underlying trial costs. Someone in the chat earlier asked me what I estimate for the price of the representation per day at trial right now. You can expect between $1,200 and $1,500 an hour on the low end.
Yeah, on the low end
for having these 3 attorneys there in the courtroom. So, and that's only because it's in Minnesota that I would estimate it to be that low. If you're in Chicago, LA, or New York, you can go ahead and make that $2,000 to $2,500 a day easily. And I mean, it may be that much for them too, or not a day, an hour. An hour. And you've got 8-hour days. So you're talking $13,000 to $15,000 a day that you're paying.
And that's just these guys. That's not expert witnesses. That's not some kind of, analysis you're having done on the side to compete with the, contest the state's analysis. All that costs more. Yep.
It's crazy. It's crazy how much this stuff costs. But it's 3 lawyers who are, and Earl Grey and Paul Eng are some of the best lawyers around for this type of thing. I mean, that's why you're paying so much, is because they're paying for top shelf representation. But it is, I mean, your options are resolving this or going to prison literally forever. Do you buy top shelf representation? I do.
You only get to make these arguments once, folks. Like all these evidentiary arguments, you only get to make them once, and then the judge makes a decision, and that decision is final. And it's, for all practical purposes, it's not appealable. I mean, the appellate courts do not like to second guess trial judge evidentiary decisions, because the appellate court judges are not there. They're not seeing these witnesses and seeing this evidence directly and seeing people's expressions on their faces. And they're not there in the moment. And they don't want to be trial judges. They used to be trial judges and they got promoted. They don't want to do that job anymore. That job is a trial judge job. But when the trial judge makes that call, the prospects that an appellate court is going to reverse, absent outright abuse of discretion, is zero.
All right. Is counsel ready for the all right. The objection is sustained. Is counsel ready for the jury?
Sure, Your Honor.
Okay. Thank you, counsel.
Do you remember what where we were?
You mean?
Oh yeah, there was. They objected to his impression of the video.
Right. He was going to start going through frame by frame, right?
I really wish I had any idea what the objection was. That sounds like a very interesting legal argument took place. And look how long it took.
Yeah.
She said 15 minutes. That was a 25-minute break. Looks like they took a pee break in the middle of their objection argument, but they came back to it a while ago. I mean, Your Honor, they just blew up my entire line of questioning in my notebook, and I don't know what to do.
Well, she told them to call their next witness, right?
No, I think bring the witness
bring
back.
The jury back in. Right, okay.
Bring the jury back in, bring the witness back
Peterson.
to the stand.
Yep.
It'll be lunch in 20 minutes, so the DA will likely wrap up. It'll be a question as to whether the defense has anything to ask this witness, or if they just want to go ahead and bypass it as basically cumulative anyway. Mike Brogan says, I'd wager the part which stood out to him was her, I'm going to prison, I want my union rep. That could be. That could be the part that they were
discussing. Please be seated. All right, Mr. Larson, you may continue.
Thank you, Your Honor. When we left off, we were discussing your review of the video evidence in this case. Do you recall that?
Yes.
And are you aware of an additional video that was created in preparation for trial using these independent videos, which essentially was a synced up composite video of Officer Potter's body-worn camera, Sergeant Johnson's body-worn camera, and the squad still video?
Yes.
And that was it was a fair and accurate composite video of these 3 video sources, correct?
What I reviewed, yes.
The state offers Exhibit 204.
Is 204 already into, is 204 is a photo of what?
204 is a composite video which has never been shown to this jury. It's the synced up video of Officer Potter and Sergeant Johnson's body worn cameras along with the squad video, which separately illuminates the location of all of the individuals.
All right. The objection is overruled.
Oh
and you
my
may
god,
show that.
we're gonna watch the same videos. It's a composite of 3 videos we've already watched.
Now, Sergeant
At least
Johnson,
3.
during the playing of this exhibit, I may pause the video several times and ask you several questions. Okay?
Oh god.
Please tell us.
All these videos have been shown, just not this particular composite version variant.
We will be here in a second.
Sergeant Johnson, or pardon me, strike that. Agent Peterson, right now you see 2 images on your screen.
Yes,
And in the top left corner, do you know where that video source is from?
that is from Officer Potter's body camera.
Okay. And the image on the right is going to be Sergeant Johnson's?
Yes.
Okay. In a moment, a third image is going to appear on the screen. Is that the squad video of the same time frame?
It should be, yes.
Okay. And this image begins at 2:01. Okay. Please start. Positive. Sergeant, pardon me, Agent Peterson, at the time you we paused, you talked about observing something that was noteworthy to you about how Officer Potter approached the vehicle. Do you recall what that was? Some conduct that Officer Potter
She has her hand
had,
on
which
her
you,
firearm.
noted.
Yes, but I guess I'm not seeing it in where the video is.
Pardon me. When it occurs, could you please identify and we'll pause the video?
Yes.
Continue to go.
Right there.
Pause. What did you observe?
It appeared to me in watching this that there was a manipulation in some way of her holster.
Why did that attract your attention?
I've seen it before on other videos I've watched of officers. I myself.
This is the Binger video.
Have done that when I
Holy
was on
shit.
patrol. Just caught my attention.
Yep.
What was
And
the
when you're on
manipulation?
patrol, what exactly are you believing
It would be
there
the
is occurring on the
moving the strap or
Um,
whatever the retention is on that particular holster.
He
So
hadn't
I
testified to that yet.
I carried the same type of holster that Officer Potter used, a level 2.
That'll be
and,
the recklessness.
It would be my practice at times to, when I was making a traffic stop, unlatch the first level of protection or safety on the holster, just to, I guess, give myself a little of an advantage
contrary to
should I
policy.
need to draw.
So essentially, it's a way to, if you had to draw your firearm, you're preparing to do it more quickly.
Yes.
The objection is sustained. I don't believe he has answered.
Well, why would you do that?
It would just make drawing the firearm easier, more efficient.
Okay. Can continue to play the video.
Therefore, she murdered him.
They'll say she wouldn't have drawn the gun if she'd also had to disengage that retention in the moment. She would have realized it was the Glock. So it's okay to undo that retention if you're going to end up needing an actual gun.
The real question, this is slowed down video. Notice how slow everything's moving?
Yep. Yep.
I would object to this.
Yep.
Just a quarter speed or something slower. It's like a 75%.
Yep. Oh, you can hear it.
Just say that.
Oh, I would object to this so hard. I would object. They have not represented this as slowed down.
I grabbed the wrong fucking gun! I shot him! Oh my god! You sit down.
This is doctored evidence.
Oh my god! AI active, 63rd Captain's right, blood from 38.
That's real dirty, by the way. In my opinion, that is real dirty to not represent that as slowed down very clearly for the jury.
Agent Peterson, when you reviewed that video, did you write reports as to what you observed?
Yes.
And when you took those notes, you were watching these videos because you knew that you were conducting or participating in the conducting of a criminal investigation, correct?
Correct.
And certain observations were important to your investigation, correct?
Correct.
Did you take note in your review of the video of whether Sergeant Johnson's head was visible on Kim Potter's body-worn camera during the incident?
I did take note of that, yes.
And was it visible throughout the incident?
His head.
Objected as an opinion of the witness. The body camera speaks for itself. All of them do.
Oh my God. Not every single argument has to happen by sidebar. Some of them can and should happen in front of a jury. Ugh. That was bad. I think they missed an opportunity there. That's the first kind of thing that I think I would categorize as a mistake by Gray and Eng here. I think they should have objected to that video as being slowed down. If they didn't notice it at the time pre-trial, I think they should have objected during the playing of it.
Of course, one of the reasons the state offers thousands of exhibits is so the defense doesn't have time to actually look at every second of every video.
You may answer the question.
Agent Peterson, was it possible to see Sergeant Johnson's head throughout the incident from Officer Potter's body-worn camera?
There were times where you could see his head, yes.
Okay. And during those times, what direction was his head pointed?
Towards the interior of the vehicle.
Okay. Was it possible to see his face?
At times, yes.
Okay. At the time of the shot, was it possible to see his face?
I recall seeing the top of his head and not his face.
Okay. So the video revealed that he was looking down?
Yes.
Okay. When you examined the video, did you recall examining Officer Lucky's position at various points during the incident?
Yes.
Okay. Could you describe what you observed with regard to the location of Officer Lucky's feet, shoulders, elbows?
At what point?
Throughout the 10, 12, 14-second period of the struggle with Mr. Wright.
He's standing outside the vehicle on the driver's side and does reach in to try to restrain Mr. Wright.
Did you observe that his feet and shoulders remained out of the vehicle?
Checked it out as leading, Your Honor. The video speaks for itself.
The objection is sustained.
What with regard to, were you able to observe where Officer Lucky's shoulders were throughout this incident?
At what time, Your Honor?
Your Honor, I do have still images if you'd like me to show them.
Oh, just a minute, please.
That's why the video is supposed to speak for itself.
Make it more precise as to time.
He said throughout the video, he was completely imprecise as far as time because his shoulders
2:01 and 58 seconds.
His shoulders change from being outside the car to being inside the car as he reaches. Hey, what's up, Viva, in the chat? How's it going, buddy? I heard you got a kid sleeping in the car. Good work. That's a great way to do it. Again, they should just object to this
Showing
again.
you now Exhibit 204.
Second he asks the question, the video speaks for itself.
Pardon me, 2:01 and 58 seconds. Would you agree?
Yes.
Where is Officer Lucky's body at this moment?
It is
Objection, he can't
outside
see, Your Honor. Oh, wait, I
the
guess it's on the
driver's
video.
compartment of the vehicle.
Okay. Where are his hips?
They're slightly behind the open.
Where is his
driver's door.
buttocks?
And can you infer where his elbows are?
Well, on the bottom squad video, you can see his right arm is outside the vehicle, and at the top left video, you can just make that his elbow appears on this video to be outside the vehicle.
Okay. Can we go ahead 2 seconds to 2:02 and 00?
Is the argument here supposed to be they were out of the vehicle at the moment the shot was fired, therefore they were not in danger of being dragged?
I think that's going to be the...
Okay. You'd agree the video is now paused at 2:02 and 0 seconds, correct?
Correct.
Can you see where Officer Lucky's body is at this time?
From this video, the bottom video there from the squad camera, it appears that his feet and legs are outside the vehicle on the pavement, and his torso is kind of leaning towards the open door.
If you look at the top left corner in Officer Potter's body on camera, are Officer Lucky's shoulders inside the vehicle or outside the vehicle?
Based on the view of this video, it does not appear that his shoulders are in the vehicle.
Okay, let's go ahead 1 second. Officer Peterson, I've just moved ahead 1 second. Would your answers remain the same for this still image?
Officer Lucky's inside the
yes.
car now. Wait, they would? He's clearly in the car. His shoulders are in the car.
Now I want to turn back to 2:01 and 59 seconds, and I have another couple questions for
My
you, sir.
mind is blown on that. You're going to argue that your answers are saying that his shoulders are out of the car on that image rather than 1 second ago when they were clearly out of the car?
Okay. Did you also examine Sergeant Johnson's position at various points during this incident?
Your Honor, I object to this. The video speaks for itself. The time speaks for itself. This officer's view of it should not be, the jury's the one that decides. It's not this officer. He's
Thank
not
you.
Expert of videos.
All right. Counsel, will you please?
I mean, come on. Like, what are we doing here? I can just bring any bum off the street to say, did you view this? Here's
Look
what
at this
did you
frame.
see
Look
here?
at that frame. Look at that frame. What about this frame?
Tyler Bell, no, this is not redirect. This is still direct examination of this witness that they're belaboring on this video that has already been shown over and over. Oh, it's a composite of 3 different body cams. Great. We've seen all 3 different body cams. We've seen all of this stuff over and over. And
of course, in any case, this is not what Kim Potter is seeing when she's making decisions.
Right. And interestingly, there are experts in video who can tell you what the observer in the video is seeing. One of those experts we saw in Kyle Rittenhouse's trial was John Black. Could have easily been hired by the state of Minnesota here and was not. They can hire video experts who do this exact thing. but they're trying to sneak it in through a BCA witness. This BCA witness is just like you or I, just a guy who watched a video.
They could have grabbed somebody out of the corridor.
Yep. Literally anybody. They could interview any juror and say, are his shoulders inside the vehicle or out of the vehicle? That's why this is irrelevant testimony, because the video itself is enough, and the videos have already been introduced.
The video is evidence. This guy's perceptions of the videos is not evidence.
Right. And, and again, this is stuff the judge has to clamp down on.
Members of the jury, we're going to break for lunch. Okay? So we'll start up again at about 1:30.
They couldn't even manage to finish out the questioning of this BCA witness because they really want someone to testify about what they want them to see in the video. That is embarrassing for the prosecution. Absolutely ridiculous.
You don't have to do this kind of stuff when you have the legal merits, folks.
Yeah. They all, importantly, everybody whose body cam was on, who might have been witness to what their body cam was seeing, has already been called and questioned by the state, except for Kim Potter, who they can't call.
Your Honor, Paul and I talked with the special agent during this lunch break because I want to make sure that I know what he's going to say, and we sure haven't found anything out by now. I'd like to talk to him.
I don't think there's anything to prohibit you from talking to the agent. All right. Why don't we take a lunch break and let's everybody hear. You know what my problem is. You've got a witness telling the jury what is on a piece of evidence.
But you're allowing it.
The evidence is the video. And it seems like this is more like a final argument material where you stop the video and say, look, both of his feet are on the ground. He's not hanging out of the car. Why do you need a supposed expert witness to describe what's on a video?
They can say that the witness, BCA said this.
I did not qualify Agent Peterson as an expert. He did review these videos and knows details of them because it was part of his investigation. And in fact, review of these videos was a significant part of this investigation, as it is now with many different criminal investigations, including ones involving officer-involved shootings.
Okay, but when you call him a BCA or, given his position, the jury's going to get the impression that he is an expert. Yes. So.
Correct, Judge.
Your Honor, I just wanted to clarify that the state's intent this morning was to introduce a series of still images which show that Johnson's body is completely out of the vehicle. These were selected to provide efficient and clear testimony about that fact. I understand the court's ruling excluding those. So then at this point, the state is going to go through those several seconds of video that have been introduced for the jury so that they can see and the state can make that very simple point that has been observed by Agent Peterson. It has been more difficult using the video as opposed to the still images, and I apologize that I can't do it more efficiently than I was intending to do it this morning with the still images. Thank you.
What they neglect to mention, Your Honor, is that taser, I'm going to tase you, then a few seconds go by, I'm going to tase you again, and then taser. When the taser was yelled, that's the signal for the officers to try and get out of the car. Right after she yelled that, she shot and they're moving out. So to impeach Johnson, which they didn't use this video to impeach him like they're supposed to, they didn't do that. Now they're trying to impeach him by some witness saying that, no, he was out of the car. That's ridiculous. That's just not good evidence.
Okay, the still photographs, I think, are a little, they don't give the whole picture. Because the timing, it doesn't show the timing. So the video has already been shown. It shows the timing. It shows everybody's body position at very specific times and when it happened and what their body positions were. So I excluded the photographs for two reasons. Number one, a number of them were not provided to the defense beforehand. And secondly, it was duplicative of what has already been submitted, which is the video. And third, it can be misleading because it's a shot at a certain period of time that doesn't show the entire sequence.
And I would only say, Your Honor, that still imagery does not somehow prevent the jury from reviewing the entire video in the manner in which the court suggested.
Our misleading evidence should be permitted because
often have the ability to impeach some sort of sense that there was a fog of war where Johnson didn't know where his body was located. It specifically can rebut that notion that he was going to be being dragged on this incident. That was a significant point. It's basically defense number 2 that we've had to hear about all of last week. So the fact that there's still imagery that can illuminate the credibility of that claim is what the state has been attempting to do during the testimony phase of this case. Certainly it's going to be brought up in closing argument, but the fact that we can do that in closing argument doesn't abrogate the fact that we can also use a witness to illuminate and to describe video evidence, which is a significant aspect of any investigation involving body-worn camera. Respectfully, Your Honor.
He didn't qualify him as an expert.
Mr. Johnson, Major Johnson, they could have cross-examined him on it like a lawyer should do and not come back later without showing us photos and use still photos. That's not fair, and it's not admissible. It's simply not.
Oh, here comes Frank.
Yeah, if I may, at that point, I'm trying not to have multiple lawyers argue. I get it.
Except I'm doing it.
If I were impeaching with a prior inconsistent statement, that might be one thing with Major Johnson. But as you recall, in chambers, I raised an objection to lay witnesses being unnoticed experts. And so I didn't object at trial because the court had said they could do that because they get trained. But he nonetheless offered an opinion. And so we get to impeach that opinion without having to ask him. And that's what we've been doing in part about that. And
you got to qualify the guy to impeach the opinion.
Mr. Gray's concern about proper form of impeachment is just wrong. We're just attacking what appears to be the underlying basis for his opinion.
Well,
Nick, which witness first admitted the video evidence?
Johnson.
So
actually, this video, nobody. This video is all new.
The different elements have all been introduced through other witnesses, right?
Because we rebut their case, and he was our witness. But regardless, I don't know if
all right, we're kind of getting off base here. I mean, we're talking about these still photographs. They're out. I'm not going to reconsider my decision on that. Okay. The video evidence is the evidence. So that's my ruling on that. And there's no need for this officer to testify as to what the video evidence shows.
It's such a weird argument, too.
You can show that to the
wants
jury.
to impeach their own witness.
All right.
Yep.
Because his testimony was not favorable to them.
Let's see. I'm emailing Earl Grey and Paul Eng about the video. I don't normally do this, but just in case they're not aware of the slowed down video. I mean, this is some really nasty stuff, in my opinion.
And now we know they hadn't shown him the photograph.
Tim
So
Blanc
they probably
here at
didn't show him the
Fox 9
video.
and the Twin Cities broadcast.
Yeah. If they think that this is just a composite of other videos that they've shown, then that is
because that's how it was represented.
Yep. I'm trying to find Paul Eng's email address. Sorry, Viva. Hey, welcome to the show.
Yeah, thank you. By the way, check this out. Well, somewhere there. Yeah, he's still there. It's a stupid question, but Andrew, you brought it up, and it's an interesting point that I was listening to like a couple hours ago. It's not an admitted fact that she would have been privileged to use lethal force yet.
I'm not sure what you mean by an admitted fact.
No, like, the parties have not admitted that
Oh
she
no,
would have been entitled to use lethal
I'm
force.
sure the state would contest that.
Okay.
I'm just saying, based on there's a narrative of lawful use of deadly force being permissible under these circumstances. If she reasonably perceived that Dante Wright was about to take off in that car at speed in such a way that the other officers, maybe even herself, were endangered by the motion of the vehicle, well, then the car itself is being used as a deadly weapon that can cause serious bodily injury or death to the officers, and that would justify the use of deadly force in self-defense. Clearly now the state's trying to argue through these still photos that they hadn't shared with the defense before, apparently, that the officers were not in a position to be dragged at the moment the shot was fired. But that doesn't necessarily invalidate the defense of others' claim of Potter because of a variety of factors. One is she's not seeing 3 different camera angles at the same time when she's making her decision. So that's not the same basis of information. Second, there's a unavoidable time lag between when you make the decision to use force and when the force is actually used. And it's possible the circumstances could change in that 0.2, 0.3, 0.4 of a second, but your brain's already made the decision to use the force, and you can't stop it at that point. There's just a reaction gap that occurs. So, but that would be the defense argument here. I think that she would have been privileged to use deadly defensive force. She was trying to give this kid a break by going to the taser first, and then she screwed that up. But if she had just gone for her gun first, that would have been legally privileged, is what I expect the defense argument to be.
And this might be my naivety or ignorance, but is a taser not itself considered lethal force?
No, I don't think so. Not in Minnesota.
No, because it doesn't normally result in death or serious bodily injury. There are odd circumstances where it can happen, but that's true of a police baton too. That's true of any non-lethal weapon that the police might use. Depending on the manner of its use, it's capable of causing death or serious bodily injury, but that's not its intended purpose or the likely outcome. So it's considered a less than lethal. So for example, if a cop was swinging a baton at someone's ribs or the center of their body, that would normally be considered a non-deadly use of that baton. But if the person were suddenly to trip or bend over so their head got struck instead, well, that blow could cause death or serious bodily injury. But was that intended use of the baton one likely to cause deadly injury? The answer would be no. That's just a mistake. That's just an accident.
Yeah, in I think where you might be getting the impression, Viva, is there's been discussion about the Arbery trial where just a few weeks before, or not Arbery, sorry, Rayshard Brooks down in Atlanta, Georgia, where just a few weeks before the Rayshard Brooks shooting, in which he stole a police officer's taser, turned around and fired at him. The officer returned fire and killed him. Some officers were prosecuted for improper utilization of deadly force for using a taser in Atlanta just before that by the same prosecution office. So that, but as far as I know, at least in Minnesota, tasers are not considered a lethal weapon or a deadly force under the law currently.
So if an officer is using a taser to torture a suspect, then you'd have a good argument that's serious bodily injury. It's not just neutralizing the suspect so you can handcuff them. You're just there to cause them pain. And I would certainly think you could have an argument there. But that would not be, that's obviously not an appropriate use of a taser. And by the way, when in the Brooks case, where the Brooks grabs the cop's taser and goes to tase the officer, I would argue that that is a deadly use of force scenario because this is a criminal suspect who's violently fighting with police. He's already stripped weapons off their belt. If he disables them, they have a reasonable expectation that he's going to take their firearms as well.
Yeah.
That's the difference between an offensive and defensive use of these things, like defensive use of pepper spray, defensive use of a taser. When you use it and you neutralize the threat, you stop using force on that suspect. An offensive use, sometimes bad guys will use pepper spray to pepper spray a victim, right? To make it, to facilitate their ability to rob them. That's a completely different use of force dynamic than the defensive use of that same instrument.
Red Dragon 412 says, important point on the slowed down video. The file was at normal speed. It was played at 5x speed using VLC, or 0.5x speed using VLC. That'd be interesting if they did that. I don't know if the file was at normal speed or not. Someone said that it appears that way, but I don't have an easy way to check that or the requisite expertise. It doesn't matter ultimately
It
because
doesn't matter.
what they're presenting to the jury is not an accurate representation of what happened that day. And they have not clearly stated to the jury or to the witness or to the defense counsel that what has happened is why they have slowed it down, why they believe they've slowed it down. Because if they say we're slowing this down to 0.5% for X reason, then the defense has the opportunity to object and say, objection, Your Honor, the video speaks for itself. Life doesn't happen at 0.5 speed or whatever it is. Why do we need to do this? You need to have a specific reason. You need to have an expert to tell us about this. And that's the thing they're trying to do. They're trying to weasel in expert testimony through a random BCA investigator. And until we find out that this guy is the BCA's video guru about objective decision-making under stress at slow speeds, then his testimony about what happens at frames in this video is completely irrelevant. It would be the same as grabbing anybody out in the hallway of the courtroom and bring them in and say, what do you see at this particular frame? Well,
right. And the video being offered is what the jury actually sees. So I don't care what the underlying file is. It's what they see, what they're shown, how it's played back. It would be no different than if you had a photograph and you held up the photograph in your hand such that your fingers obscured the relevant part of the photograph, right? The gun. And then you say, hey, you can't see a gun in this photo. That's simply not a truthful representation of what the evidence is.
Right. Well, and it would be similarly impermissible.
It is interesting because I was listening at the time, wasn't watching, but they did say this is an accurate representation of what the video captures, and then it's slowed down. The voices are not pitch oriented, but the voice is clearly slower, and it's true. In that speed, it really sounds like it took more time to occur, that there was more thought process that could have occurred, and that would leave a lingering impact in the jury.
Double the time for decision making, for observing, all of that.
The other weird sort of misrepresentation that happened in this, as pointed out by someone in the chat, and whoever said it, thank you. I don't remember what name it was, but they're focusing on her unlatching the firearm, which, by the way, I'm not sure we can determine that she did that clearly from the video. I think that's a post facto determination. We know she unlatched it because she ended up drawing her gun, sort of thing, but in a similar way, she appears to unlatch her taser prior to unlatching the firearm. It's almost like she was preparing for either potential use scenario, but that wasn't highlighted here. And that's the danger of having some random witness just testify about what they're seeing on a video. We saw the same thing happen in the Rittenhouse trial, where he raised his gun. That all came from a detective who reviewed a video, not anybody there, not anybody with knowledge of the situation. And this goes back to the Rittenhouse trial and me saying, if you have a problem with this, it happens in every courtroom all the time. Bad lawyering by prosecution, either not caught by the defense or just shoddily allowed by a judge who's curious. And this type of stuff needs to stop. This is prejudicial to a defendant in a grotesque way. I mean, if they go to closing argument and say she unlatched her gun preparing to use a gun when she could have used a taser, she knew she was going to use a gun there, because this is their first-degree manslaughter argument. It's not their second-degree manslaughter argument for recklessness. This is she was going to commit an underlying assault. She knew she was going to do it, and when she did that, it caused death. She didn't intend to kill him, but she intended to assault him and cause him harm, and we know that because she was getting ready to do it long before he was ever violently resisting. And that'll be a complete mischaracterization of what happened if she actually unlatched both of her taser and her firearm, because she anticipated from a violent guy with a felony warrant, with a warrant out for his arrest, drugs in the car, who had also violated about 8 traffic violations or whatever. She anticipated the resisting arrest. I mean, that's reasonable.
And to circle back to why are lawyers expensive, folks? One of the reasons good lawyers are expensive is because they catch this stuff in the moment when it matters, preferably before the jury ever hears this stuff, but certainly when that's happening, when they finally realize they're getting ambushed by this evidence, because realizing that evening that it happened is too late.
And imagine what the state has done here. they have introduced these same body cam videos 4 or 5 times
at least.
And so they have exhibit after exhibit of the body cam video, of a composite of the body cam video and something else, a composite of the body cam video and a different squad cars video. They've done all of this. And so by the time the defense gets to evidence piece number 200, and it's the 5th time they've seen body cam footage, they may not notice it's slowed down to half. Because they're like, okay, we've seen the body cam footage 100 times now.
We're seeing every combination and permutation of all these photos and videos from all these different body cameras and dash cameras, from cars on the scene at the traffic stop, from cars that arrive afterwards. It's insanely cumulative.
Well, the judge now raised an issue, even though the video has already been viewed. Did she, any indication as to what she's going to do to clarify the mistake when the jury returns?
I mean, hopefully she'll just tell him to stop reviewing this video, because this guy has not been qualified as particularly
and then
able
potentially
to do it.
Potentially to replay it at normal speed. And as Nick, Andrew, I'm going to go continue watching now. I'm going to take the dog to the vet, but this is good stuff. I mean, it's very interesting. When for those who have not been following it as thoroughly as you, when does the prosecution expect to close?
I don't know that they've said. I mean, apparently never.
Yeah,
I mean,
they haven't said they still have another BCA witness, I think, after
so
this
every
guy.
witness who testifies mentions another person that was working with them at the scene that we can infer is now going to be the next state witness, in an endless line of little BCA investigator Russian doll kind of scheme where you think nothing more could be added, but nope, you open that BCA agent, there's another BCA agent inside that one who's going to be next to consume 2 or 3 hours of court time.
Because it's interesting. You think like the material elements are going to be, if not admitted, at least known, because you have a video. Like in Rittenhouse, you basically have the entire incident caught on video. What is there to do other than argue from the video, or potentially has her partner? What's his name? The other police officer, has he testified
Lucky?
yet?
Yeah,
Lucky,
the other
yeah.
cops testified already for the state.
Lucky
Okay,
and the other officer on the scene, Johnson, as well. They both testified for the state.
And their testimony was favorable to the defense. That's why the defense is now trying to impeach the testimony of Officer Johnson that they had called as a witness last week.
I mean, I have to go back and watch it now, but like he'll testify where he was, what was going on. I think everybody understands that. So it's going to be a question of framing it so that it looks less serious for the jury, that he wasn't in the car, his arm wasn't in the car, his shoulders weren't in the car, so no risk of him being dragged. So the lethal force used would have been unjustified regardless. But all right, well, I'm going to continue watching, but thank you guys for having me. I'll see if I can get back in, but you guys are doing good.
All right, Viva. Thanks,
you,
buddy.
Viva.
Gentlemen, have a good day.
So what I just did was I checked the video because people are suggesting that the video itself displays the speed. I don't see it on there. However, I was counting between the seconds of the video, and I think it very clearly is 2 seconds per second. So here, I'll play it, and just watch the timer down here. I'm going to play it on mute. Just count yourself off. Look at how long these seconds are. I mean, there's no way that's in real time.
No, the voices alone give it away.
Yeah, but the thing is, so the video that the defense received is actually probably in full time. The reason that the seconds don't match the actual time that's happening is because it's not playing 1 second of video for 1 second of real time that we're hearing or that we're watching. It's playing 1 second of video on the file versus 2 seconds that elapse in real time, which means that they've manipulated the evidence in the courtroom. So the defense wouldn't be aware that this was a manipulated video prior to it being played in court.
Right, because they were given the underlying file, which is at normal speed.
Right, which
so
is
they're effectively doctoring the evidence in real time in the courtroom.
Yes,
just like if they had put a filter in front of a photograph, like a translucent piece of plastic to obscure the details of the photograph. Or
it's massively important, in my opinion, that this is going on, because and to be to give some deference to the prosecution, it's possible that they don't realize that they've done this or some nonsense like that. It is certainly possible that, oops, I just happened to just happened to accidentally click the half speed thing or whatever, didn't mean to. That is a possibility. However, that possibility is still overtly prejudicial to the defendant, and whether they intended to or not, they've done it. And now it needs to be addressed. That is really nasty. Okay. Mark Gee over on Odyssey says, are you a man between the ages of 18 and 99 plus? Are you concerned that your performance might get you into questionable areas? Want to know what to expect beforehand? Then get hard with Law of Self-Defense at lawofselfdefense.com/get hard. Works for women as well. That will, by the way, that's a real thing. lawofselfdefense.com/get hard to get yourself a hard copy version of Andrew Branca's.
It's not just for Major Johnson.
Oh, phenomenal. Yeah, this, you know what I like about Viva? If you've watched Viva over the past several weeks and you took a still frame from every one of his video, what you would find is this time lapse. You know, like when you see those time lapses of a flower like sprouting up and blooming, it's his hair slowly leaving his body. Like it's like a supernova happened inside of his brain, and eventually it just pressed out to his hair. Oh my goodness. Well, I'm going to start reading through some of these super chats that came in earlier as we get going. If there's anything that comes to mind, though, please feel free to step over and we can talk about that as well. Let's see, where were we? VFM0035 says, in the last 25 minutes of Binger, he states that Grosskreutz had self-defense right to kill Rittenhouse, but Rittenhouse had no self-defense rights at all that night. Oh God, I'm gonna finish that interview, but it's gonna be painful. Logan Orr says this lateness is pretty much Binger levels of gay. Squizgar says, haha, called it 8 minutes late and all the gay. What do I win? Look, my youngest daughter had an activity to go to, and I had to brush her hair this morning. So, which if you know anything about 4-year-olds hair,
oh yeah,
that is long. It is impossible to brush quickly. So yeah, Matt Hagan says, how much would it take for Law of Self-Defense to take his tie off for the day show? Cat Zap says, when will the next 20 minutes of Binger Blather interview roast commence? I would like to do it tonight. I will be invited. I don't expect the entire panel will be able to make it because it's a weeknight, but I would like to get it wrapped up. Stephen Lavelle says, this is my celebratory, just submitted my tax returns episode viewing rather than my usual guilty procrastinating putting my tax returns together one. Thanks to all panelists. Wait, you're doing your tax returns on December 13th? Business tax returns, I guess. Russell Hall says, what's happening with the Billy Samirmir mistrial? I don't know who that is. I don't know what that is. Run the Cushion says, hey, Nick, are there any steps in establishing the charges against Kim Potter? I've done jury duty before, but it wasn't with a case like this. Yes, the judge read the charges to the jurors after they were impaneled, and she will read them again with instructions prior to the jury entering deliberations. They will likely get a written copy of those instructions that they will be able to review in the jury room. So next we've got Russell Hall says, when did Michael Jackson reincarnate as a judge? William Andrews says, drunk Bronca should kill sober Bronca so we get drunk Bronca all the time. He'd have to do it in self-defense, though. Paul says, I sent you a Christmas present in your Twitter DMs. Allison S. says, plot twist, doctor reveals Dante Wright is still alive and hanging out with Epstein. Abe Eckstein says, there are no facts in dispute. They just want the pictures and evidence. Yes. Michael Milano says, just wait till she asks, have you seen photos of the accident after the shooting? Do you want to? She then shows all the accident photos again. You joke about that reckless jokery, Michael, but that's what's basically been going on. I mean, the fact that, have you reviewed this video evidence? Yes, so did the jury, Your Honor. We don't need someone else to review the video and tell us
how
what
many
they thought
times
about
is
it.
the prosecution going to ask a witness to recite what some other person told them at the scene? I mean, they know that's hearsay.
Right. Again, and the prosecution's argument, I love that he said that. Well, Your Honor, I wanted to introduce all these videos, but then I couldn't. So we had to do it this way, which is really hard. Oh, I'm sorry, the state, that your job is difficult in prosecuting someone to put them into prison for a period of a decade or longer. Geez, shucks. It's really rough that that's hard for you. But
And where was the part in the opening statement where Erin Eldridge talked about her taking off the retention on her holster as she approached the car? And that's the basis for this recklessness allegation or intent to commit an assault allegation. I mean, this is just stuff they're making up midway through the trial.
Because they likely know how this trial is going. The state's witnesses have been unfavorable to the state. And did you make that joke? This is their FBI drone video.
Yeah.
It's like, because it is like, here we go. We're going to introduce a video. We're going to play it at half speed. We're going to do it in the middle of trial with some other witness to testify about what they see on a video.
And it's going to magically reveal some desperate piece of evidence that we need.
And something that they did not mention prior because they couldn't. They didn't see it. The prosecution likely did not see this on the video until later, or they missed the BCA guy's notes, or they didn't realize that they would need to pull it out in the way that they're doing. Things are not functioning for them in the way that they want.
Yeah, I mean, ADA Larson has spent all weekend desperately reviewing videos and ways he can characterize videos to make this kind of argument today.
Mithra and Emrys says, one of the most disingenuous things about reviewing video over and over again, slowing it down, etc., is that it stops being representative of the event as it happened. Monday morning quarterbacking grants perfect hindsight. And especially with slowing down a video or taking out frames of it. And I mean, sometimes you actually do have to do it, right? Sometimes you do have to get technical on things and say, this is the time and we have to slow it down for whatever reason. But you typically need to bring in someone to justify why it's slowed down.
That's why you use experts to do that, so that they can also explore the consequences of having done that. I mean, obviously, a slow-mo review of something is different than the actual experience itself, or we wouldn't have, NFL video reviews of calls, right?
Right.
And in these cases, what matters is not really what actually happened. What matters is the defendant's reasonable perceptions of what happened, and they were not perceiving things at half speed and frame by frame.
Right, which is another reason why and this gets muddy, but when you're going to introduce evidence that is frame by frame or half speed or altered in some way, you do it to the witness who is actually there. You have Kim Potter testify about her actions at this point. Were you aware that Sergeant John here, Miss Potter, you're relying on the fact that Sergeant Johnson was in the car at the time that you pulled that trigger, but you weren't aware of where he was, were you? Because we can tell by your body camera, we can't see. Isn't that right? You're looking at the body camera still right now. It's looking down at the dashboard. How can you couldn't possibly say that you knew where he was at the time you pulled your trigger? Could you? You couldn't do that because you couldn't see him, because you were looking at Dante Wright, weren't you? You were looking at the struggle. You weren't looking at the other officer. That's how you do it. That's how you break it down frame by frame. So, what was going through, this wasn't going through your head because you're on cross. This wasn't going through your head at this point, because at this point, we can clearly see that you're focused on this person right here. Isn't that right? You don't do it with some guy who wasn't there, who reviewed the video later in his office, 3 days after the shooting. That doesn't help anybody. It's not useful. And so the muddy line between allowing freeze frame video or slowed down video for the purpose of questioning and even impeaching a witness about their statements is one thing, but to do it through third party testimony, who is not there present, who is not in the moment, is very disingenuous, in my opinion. anyway. Sorry.
Hey, Nick, I
Little
saw
rant there.
somebody ask about delivery expectations if they get hard. lawselfdefense.com/get hard. You will not get it before Christmas for sure, and it could be a couple weeks after that. So if you need speedy delivery, that's not going to happen. Sorry about that. There's nothing I can do about it.
If they need speedy delivery, they'll have to buy it on Amazon, I guess.
What they might want to do, if they want to get this information even in greater intensity and more quickly, is we do have a January 8th, 2022 Law of Self-Defense advanced class that people can attend. CLE level quality plain English instruction, a law school seminar equivalent on self-defense law. You can learn more about that at lawselfdefense.com/advanced. That
There
you'll
you
get
go.
on January 8th because I'll be teaching it on January 8th.
January 8th or February 8th?
January 8th.
Okay, my brain heard a different thing, so thank you for clarifying. Gili Bjornolfsson says, I can't tell you openly how you earned this, but you earned this 1,000 times over, literally. Oh, okay. Thank you. Thank you, Gili Bjornolfsson. I appreciate that very much. I'm happy to help. Free Flyer says, I teach use of force and deadly force. The amount of people who don't understand the amount of instantaneous decision-making that happens in fractions of seconds is not represented by frame-by-frame video. Yeah. I mean, it's crazy. And the other thing is there's all sorts of psychological studies that have been done to empirically show that things like adrenaline, they distort the perception of time from the normal. So that's actually, and again, that's why you bring in experts to talk about this. That's why you question the witnesses as they were experiencing things at the time and get to what they were experiencing. Officer Lucky and Officer Johnson are both in high adrenaline situations. They can testify to how time was flowing for them, or not directly like that, but they can testify to what their perceptions were at particular moments of video. This BCA guy doing it later can't.
Folks, I saw a comment here, someone asking if I can do a class for Oklahoma. If you mean a travel class, I don't really travel anymore. So the answer to that would be no, but we do have separate courses for each of the 50 states, streamed online and DVD format. And I just checked the URL, and in fact, they're half off right now, 50% off. And that would be instant access if you get the streamed for sure. So if you're interested in that, lawselfdefense.com/state, and there'll be the list of separate classes for each of the 50 states.
Do you do local in-person classes?
I used to, like 45 weekends a year, but it meant I was traveling 4 days out of every week. You know, fly there Friday, teach Saturday, teach Sunday, fly back on Monday.
I meant local to where you are now. Like, do you do any live classes?
I don't really bother. It's too inefficient. I mean, in most places you would teach at gun stores and stuff like that, they can fit maybe 30 people in a class, and it's just so much more efficient to do the class online. So I can charge less money than I would have to charge to make it worthwhile in person and reach a lot more people than just 30 at a time. It's terribly inefficient, and travel classes are awful. I mean, the first $1,000 or $2,000 goes right to the airline and the hotel and the rental car company before I would even see a dime. And it's just a terrible way to deliver this kind of content. Very, very cost ineffective.
Okay. Gisli Bjornolfsson says, call me GB, bro. I will from now on. GB says, the philosophy of self-defense transcends national laws in my experience. You guys taught me well. Hey, thank you. Thank you. Yeah, because I don't know what currency that is, but that is not U.S. currency. So thank you, GB. I appreciate that. Nabor 605 says, I can't believe Dante died from not carpooling. Stephen Carpenter says, could the prosecution be trying to get some kind of bored, inappropriate response from Potter so they can argue that she actually isn't remorseful? Maybe. I mean, they'll try and do, they're going to do that on the stand. Right. I have a feeling the cross-examination of Kim Potter is going to be a lengthy one.
It's going to take hours and hours and hours. I mean, if I were this prosecution, I'd never let her go. I mean, I'd be like a pit bull, just sink my teeth in, and when they drag me out of that courtroom, that's when I'd be done.
Okay, ISK is Icelandic kroner. Oh, thank you. Thank you. Hail to Iceland. No, not hail. Oh, God, I shouldn't say that in a cold environment. Ahoy to Iceland. How's it going, man? Z. Michael Gelke says, do all failing prosecutors resort to fabricating stuff with computers? Jonathan Bailey says, the doctor's TikTok name is 4 Doors More Corpse. DK says, plot twist, Wright was never shot. Potter was using the blank she stole from the set of Rust. Nabor says, so the green tent was placed there to help make CG. Avaxine says, is this guy Jonah Goldberg? Evan Bouchong says, every time I get told we can't do X or Y because the system is so backed up, I'm going to point to this trial, make the state get to the point. That worked in my favor one time. In Minnesota, by the way, if you ever have a drug charge, go opt immediately for the speedy trial. The Bureau of Criminal Apprehension does the forensic testing on controlled substances, and they're backed up months at a time. So it's likely that the state will not be able to even get a positive result. They'll maybe have a field test, but they won't have an actual result on your drug stuff. Get your speedy trial. They're backed up. They're bogged down. Make them comply with their constitutional requirement to give you a speedy trial. It's one thing I learned from waiving a speedy trial. Actually, we ended up winning that one, but still, we waived it. And then I found out that they wouldn't have the drug results for like another 9 months. And it was like, oh, I wish we wouldn't have waived our speedy trial back then.
Same with DNA.
Yeah, it's
unless you think they would just put it in a computer or something and get an answer immediately, but it can take months to get DNA results.
Yep. So that's something strong. If you can put together a competent defense that fast, if you're on top of it, if you have a good defense team, that is really, really helpful to exercise your right to a speedy trial. Many people waive it kind of as a matter of course. Oh, we won't do that. The ones who are prepped and ready, who will take their speedy trial right away and are willing to go to trial on it. That's the other thing. You have to have a lawyer who's willing to go to trial for you. If you do that, you actually can really strongly increase your chances on things like that, where lab testing is necessary.
It can be tough. I mean, people need to keep in mind most criminal defendants are guilty, so they don't want a speedy trial because it just advances the date on which they're going to be found guilty.
Yep.
Also, a lot of attorneys, the attorney has their own schedule they're managing, and it may not be in his interest to have a speedy trial. And he just explains to the client, well, it's I just won't have time to fit this in my calendar, so we're going to have to waive. I mean, the client could say, screw that, I'll get another lawyer, but it's rarely expressed to the client in those terms. And so the client waives it, just thinking that's the normal necessary thing to do.
Absolutely. Britt Cormeyer says Earl should be tanking lunch to ask the witness, so have you unhooked your holster like you think Kim may have? How many of those times have you then pulled your gun and shot someone?
Well, he said he had.
Yeah, he said he had unlatched it. He had done that before. Which that's what by the way, that's what they want to do. They want to get that guy to say, I would unlatch it when I was approaching a situation where I felt there may be risk involved, where I was worried, or I had some external factors that put me on edge, or put me at a heightened response state, because that's what they want to do, is focus on things like that.
Where a half second, a second may make all the difference in getting that gun into play. Not just for you, but for your partners. And
Exactly.
It is possible to use those retention holsters with great proficiency, but that's not the typical officer who can do that. Most of them don't do anything like the practice they would need to do to be speedy with an effective retention holster. And for folks who don't know, these levels of retention, the reason they exist is because criminals will fight with a cop and try to take the cop's gun out of the holster. So
Right.
you try to complicate that process by having various mechanical gadgets and ways you have to twist the gun to get it out of the holster to make it more difficult for the gun to be seized by a bad guy from the cop's own holster. But that also complicates the task of presenting the pistol by the officer himself.
Free Flyer says, is a logical connection that Dante's resisting created the unreasonably risky or hazardous situation? Yes. In Minnesota, you don't get to use contributory negligence as an absolute defense to a negligent homicide claim. However, it is something that you can raise for the jury to consider. Did the decedent in this case contribute to, in a material way, the risk factors that that led to his death? And if the jury determines that since you can raise that, you can make the argument. And if they determine, yeah, this guy's the reason that he died, not Kim Potter. She didn't create it. Like, Kim Potter did not just pull her gun around, point it, and shoot it. Right? She didn't do this in a vacuum. She did this in response to the way that this guy was acting at the scene. And therefore, if his behavior was sufficient to outweigh hers, a jury can conclude, no, it's his fault. It's his fault that this happened.
Most cops will tell you that they don't decide how much force gets used in a violent encounter with a suspect. The suspect decides how much force is going to be used.
Hanged Fox says, any thoughts on Tennessee's permitless carry law? It's a weird one. Instead of repealing the requirement for licensing, they added an exception for anyone who would be eligible for the license.
I don't do gun law. I think all these permits are nonsense. Bad guys don't get permits. All they do is inhibit law-abiding citizens. So I think it's all ridiculous. I think it all should be constitutional carry. If you're a law-abiding, mentally sound American citizen, you have a right to keep and bear arms, period. Without restriction, without constraint. Of course, no one's made me king yet. So we live in the world we live in. I can assure you, in places like New Jersey, will happily put you in prison for having a gun on your person without whatever they require for a license. Someone had asked here about, they tried to sign up for CCW Safe. They live in New York. They can't get it. Folks, there are 2 or 3 states in the country that have effectively banned these self-defense insurance programs. New York is one. They do have a carve-out. Law enforcement officers can still sign up, but other than that, if you're a normal person, you can't. I think Washington State has done the same thing. I don't know all these details. I don't memorize these. I don't work for these companies, so you just have to look at their websites. If there's some reason, believe me, they would love to take your money. So if they're telling you they can't take your money, it's because there's some kind of prohibition in effect that there's nothing they can do about.
Yeah. Oh man, that sounds like a good constitutional challenge to that law, by the way. It's interfering with interstate commerce, right? Like that's a quintessential Commerce Clause question, in my opinion.
But all these companies are relatively small, comparatively speaking, and of course the state of New York has infinite resources comparatively, and it's easier for them to just write off that one state and not get into some kind of lengthy legal battle.
Oh yeah, I wasn't suggesting for them. I would suggest, some advocacy group should take that up pro bono and say, hey, like, it's almost like the NRA could do it if they weren't dealing with their own problems.
Well, of course, they had started up their own self-defense insurance product that was complete garbage from top to bottom, which is one of the reasons I'm not that popular with the NRA anymore, because I pointed that out. They set up like a reimbursement program. So if you were acquitted, then they'd reimburse your legal expenses. Folks, that's completely useless, because you need that money to fight the legal battle in the first place. I mean, it's like someone saying, hey, if you go to war and you win the war, we'll provide you with an army. That's completely pointless. And of course, if due to lack of resources, you get convicted, well, then they don't have to pay you anything, because that's an exclusion from their program. Thankfully, it only lasted 2 or 3 years before it went into the garbage heap.
Yeah, good. Because that is never helpful. Getting reimbursed later is like, oh, thanks. I already sold my house. I already sold my car. I already cashed in my IRA and took a 10% penalty on top of the tax burden.
And you might get convicted just because you didn't have enough money.
Right.
I mean, we'd like to think we live in a country where how much money you have doesn't affect how much justice you get, but that's not the world we live in.
No. And it is absolutely not. Let's see. Nordic Nightmare says, take my money, good sir. Tips hat. Oh, gladly. Thank you. JM says, can Potter claim she reassessed the situation at the moment and it required deadly force, even though she had just said taser, taser, taser? That I think that would be an unconvincing argument.
What was the argument? You said it so fast, I missed it.
She reassessed the situation at the last moment and it required deadly force, even though she had just said taser, taser, taser.
No, that wouldn't work, because the gun's already in her hand.
The short answer to your question is yes, she can claim that. I think it would be very unconvincing, and it would make her look like, a post-textual reason for why she did what she did, why she shot someone. It would look like, no, I calculated this out to be the corrent answer. And juries don't like that. Mr. Scott says, as Backdoor Binger looks confused at the books Nick sent wondering what he's going to do with them, Judge Chris says, sometimes you got to take a plugging. Oh, gross. Lil Binger says, chunky Dr. Seuss is boring.
Hey, by the way, I should mention, I mean, when I teach CLE courses, which is continuing legal education, it's like criminal defense lawyers come, prosecutors come, judges come. And what I teach is also helpful to a prosecutor. I mean, if he wants to refine his argument to attack a claim of self-defense, it's the same legal elements, just from the other direction. So it would actually be, now, hopefully with an ethical prosecutor, it would also make clearer to them when there's not merit to attacking a claim of self-defense, and we'd have fewer of these cases lacking legal merit go to trial in the first place.
Travis G says $5 for her future mention of hollow point bullets. That was this lady who is I haven't put this up because chat is degenerate and I've left it. They're replaying her testimony, but no chat. You do not get Minnesota Blondes on screen. Barry Dworak says, doesn't wasting a few days of nothing piss off the jury?
I would think so.
You'd hope so.
They all have lives.
Allison S says, so did the hollow point bullet dock with his chest? Stop it. Neighbor says, I hope we get a Sprite expert for that dark soda. That would be a little interesting. That Sprite in that bottle looked like it might have had a little bit of a lot of Robitussin in it. I mean, just maybe. But did they allow that evidence in the Zimmerman trial? The Skittles and Arizona iced tea.
Well, they talked about it relentlessly. I don't remember if like the bag of Skittles itself was an evidence. They certainly had photographs of it and the iced tea for sure.
Nathaniel Hyde says Brandon Herrera just released a video testing Alec Baldwin's revolver theory. It is part of the Mythbusters playlist. I got to get that guy on to talk. He sounds hilarious. Charles Argo #2 says this woman looks and sounds like the lefty woman on the 5 on Fox. Travis G says, does he qualify as an expert witness or a fact witness? Can he testify to hearsay regarding circumstances of the crash as an expert? No. There's a narrow list of hearsay objections, and the list is exhaustive. As opposed to other lists which are not exhaustive, the hearsay exceptions are exhaustive. So you have your things. Business records, for example, is one way. There's a lot of ways around hearsay. Right. And I think that's what you were alluding to earlier when you said it's just lazy. It's just lazy how they're trying to introduce this hearsay evidence.
I mean, they had the opportunity to have Johnson testify himself, right? So you wouldn't need hearsay. Just have him say when he's on the stand, what did you say to this other person that you're calling as a witness later? No, it's crazy. And people should understand the hearsay can be a very kind of fuzzy, difficult to understand concept for lay people. But the reason the hearsay prohibition exists is because allowing someone to come in the court and testify about what someone else said outside of court is just considered inherently unreliable. It's like the Ferris Bueller, my cousin's sister's aunt told this story about what. There's no way to verify that. There's no way to come to any kind of impression of credibility or authenticity of the statement when it's being told secondhand like that. Now, the exceptions for hearsay are typically circumstances in which that inherent unreliability is overcome. So it's an excited utterance in the moment, or it's a statement against interest in the moment, or it's a business record. So there's something that captures that information other than it was said by your sister's cousin outside of the courtroom. But that's the general principle. Hearsay, someone else's repeated statement considered inherently unreliable, can't be verified for credibility by a jury unless there's something that offsets that inherent lack of credibility.
Right. And the elaborating on what you said about the unreliability of it is if I say something sarcastically, if I say, oh yeah, I ran into you, right? Like car accident. Oh yeah, I ran into you. And then someone comes in and says, he said to me, I ran into you. Or, oh, I did run into you. The way they say it, of course, influences how what the perception is. And by them getting to editorialize or even just add their own perception about what you said or how you said something. Well, he said it sadly. It's like, no, you don't get to do that. You don't get to characterize the way something is said because that's unreliable. Now, the attorneys can try and characterize it, and then that can be challenged on cross, and then that can be challenged back on redirect. That's why this adversarial process exists. But if you have someone who is third party, how do you challenge them on what they say? Oh, he didn't say it that way, did he? Yeah, he did. Oh, describe it again. That wouldn't go well. So that's why the hearsay exceptions happen in that way is that if the other person's available, then we got to get the other person if you really want that statement. And it's hard is not an excuse in court. You're already expending tens to hundreds of thousands of dollars and tons of hours. Get it done right. We want the facts.
And this is just part of the job. You know who your witnesses are that you're going to call. You know the story you want to tell. You have to stage these things so you get this done without breaking the rules. I mean, this, in theory, this is not the first time prosecuting the case. They know what this environment is and what the requirements are.
Yep. And someone said, what if someone said something on a PA system? Well, one of the exceptions to hearsay is that, hearsay only applies if you're using what was said to offer as proof for what was said. So if you're saying, I heard this thing over the PA system, which made me think about whatever, that's going to your state of mind. That's an exception to hearsay. So it all depends on how you get it in. There's a lot of ways to get around hearsay, but you have to do it appropriately. And that's the rub there. BA Krim says, do you have some Rittenhouse left? I might need to finish it off to get through this testimony. No, I will not buy Rittenhouse Rye ever again because Heaven Hill pulled a stupid on Twitter, which is too bad. It's a good $35 whiskey. It really is. But they got dumb. And so I probably won't ever buy it again. Hacko says in Whoville, they say that Dante Wright's heart grew 3 sizes that day. Nabor says he died of a broken heart like Padme Amidala. Stop it. That was the worst. That movie. Oh, never mind. I'm not going to do a Star Wars rant in the middle of this show. Tyler Wales says, so did they determine what killed him yet? Kyle Bogue says, if I were on this jury, I'd be drinking some of Jim Jones's Kool-Aid right about now. Good Lord, what a waste of time. Can Bronca get drunk for us now? No, I don't know if you do that during the day show.
No, I'm working.
This is a respectable man, not a horrific degenerate, chat. Come on. I'm the one who does that. Alex A says, and did you observe the word heartbreaker embroidered on the jacket? And is that consistent with the injuries observed? Meeflower says, what the jury hears. Mr. Me, how did Dante die? Or Mr. Medical Examiner, how did Dante die? Gunshot to the chest. Mr. Medical Examiner, blah, blah, no further questions. Defense, no questions. Nabor 605
right, that's
says,
how it should have gone.
Yes.
More or less.
Yeah. How long have you been a medical examiner? Oh, forever. What does being a medical examiner entail? I've either helped on autopsies or done them myself. 1 million of them. I've seen more dead bodies than you'll ever see in your life. And I am a doctor with requisite training to determine causes of death. Okay, cool. How did he die? Bullet right through his lungs and heart. Really rough gig. Goes quick. Dies in like a minute. Cool. That's it. That's all you need to know. You didn't need any of the other stuff going on in that. Nabor says, is the state trying to get that Potter shot at the heart design on the jacket in order to make sure Wright was shot in the heart and she's to blame? Chris Demand,
that was a lot of work, man, but it was worth it.
Chris Demand says, she did shoot him. Shocking news. Joshua Unset says all the dead's crimes are diminished as just crimes. Meanwhile, the DL will put just inhibited driving in jail for 10 years in normal circumstances. Correct.
I just saw someone mention I've got apparently my book has 3 1-star reviews on Amazon, which could be, I don't usually check that stuff, but if it has 3 1-star reviews, it's got 949 5-star reviews. So
I'm sorry.
Yeah,
Andrew,
yeah.
it's me bringing you on the show has
It hurts.
impeached the reviews. Cause Diver says, bring back Officer Bay. Bring back Officer Bay. Brandon did mention you in one of his vids and was in the chat on the Rittenhouse trial. Yes, he did. He did. And I've DM'd with him a little bit, and I would love to set something up. It's all about scheduling. That's the main thing. Contact and scheduling, but contact has been made. So hopefully we can schedule something in the future. Ryan Keeler says he was shot through the heart and she's to blame. Would you say that Officer Potter gave Love a bad name? Z. Michael Galkey says this man is single-handedly making teabagged a legal term. Automata says, I find the amount of feet emojis troubling. Fat Planet says, shot through the heart, but he was too late. He gave Love a bad name. Joseph Berger says, have some literal shekels, even though I'm annoyed that last week you insulted both RuneScape and IRC. Silo 101 says, don't mind simping, but chat has real low standards. Ouch. Mr. JUPL says, the Virgin Lemoyne versus the Chad Earl Grey. Patient Zero says, I strongly disavow the chat and demand they stop this immediately when this witness is done testifying. Appalachian Drone Flight says, could you describe how you organize your sock drawer, please? Dear God. You guys need to stop with the blonde BCA lady. You need to stop. It's very disrespectful. Jeremy Trotter, welcome to Super Lawyer status. Same with Cindy Sturgill, welcome to Paralegal status. Brett Cherry, aka Pop Drop 619 says, can the defense waive a witness because they are not disputing the facts they're going to testify about? Much love from South Africa. Waiver of a witness would require the prosecution to similarly agree. You would have to stipulate to waiving the witness and stipulate to the facts that they would testify to. Prosecution doesn't want to stipulate to those facts.
Right.
They want to elicit those facts from that witness very intentionally. And to be fair, they have a reason to want to do that. The witness may say something that would lead the prosecutor to another question that they had not planned. It doesn't happen often, but it might happen. And if they can get that, and if they can get something else out of the witness that they didn't get in an interview, then that would be good for them. That would be good for the process of getting to the truth. So I don't think you're very often going to find stipulated facts of a witness in a criminal trial, and certainly not a major one.
And there's no, I mean, the prosecutor doesn't want to do that. It would be like the difference between actually going and seeing a movie and just having someone tell you what the movie is about. I mean, those are two completely different experiences.
Exactly. SSJ2 Rich says, when did the state bring a meteorology expert to testify about what cloud formation existed at the time of death? Probably soon. Afro Fry Cook says, bought Law of Self-Defense and state-specific DVD, 50% because I want to carry responsibly, and 50% because Andrew Branca is hilarious with some booze in him. Matthew Dombrowski says, why are they focusing on the cause of death? I don't remember the defense contesting that she shot him, because it's really all they have.
Right.
Lost in Thought says, all I keep hearing in my head during this trial is police are on the scene. Know what I mean? Lamau Vice. Mr. Tibbs 89 says, Your Honor, we request a directed verdict since the DA's office has only proven there was an accident caused by driving while shot. Loretta Silver member says, tent on scene equals guilty, guilty, guilty. Like, you just want to say, did you see the tent? Yeah. Well, you assholes put it up. Like, it's your fault. Darren Upward says, imagine if some troll put a picture of Binger in between those and he asked without realizing, can you describe what you see here? Chris Deman says, what even is their case? They're trying to say the weapons are evidence in a crime, therefore guilt of a crime. I don't get how any of these past few days is even relevant. Again, as tedious as it is sometimes on the technical things, the identification of the weapon is relevant to proving beyond a reasonable doubt that Kim Potter shot Dante Wright with that weapon. They need to do that. They need to establish that that was the gun, that the ejected cartridge is evidence that the gun was fired, that the bullet recovered from Dante Wright is from the gun. They need to do that as reliably as they can for the underlying case. The reason it's so exceptionally boring is everything else they're asking around it. This could all be done very quickly. Like you said, 2-day trial. This is a 2-day trial in any other circumstance. This isn't even it's not even a murder charge. It's manslaughter charges. We really do not need 10 days of testimony on this.
No, very common for murder cases themselves to be 2 or 3 day trials, folks. I mean, they normally don't take very much time because usually guilt is so obvious it hardly takes any time at all. They'll do jury selection in the morning, and by the end of the next day, it's all over.
Yeah, you also and in this case, like when you really think about it, you normally don't have that many witnesses to a shooting. 1 to 5 common, and all of the witnesses that they've been bringing in are people who witnessed the accident later or who came to the scene later. So really, you've got a couple fact witnesses from the scene itself. You've got a couple expert, like an expert witness or two, maybe. And then you've got some fact witnesses for the state on behalf of the investigation side of it. But you really don't need that many people, and you really don't need that much testimony. Bringing out all of these people is nonsensical. Even in, again, one of the really interesting cases that never went to full trial was Darren Wilson in the Mike Brown shooting, because all of those people who interviewed with the news as witnesses, when they got to the grand jury, turns out they didn't see anything happen at the actual time of the shooting or even leading up to it or even following it. They all made inferences that they could say to the news.
It was all hearsay testimony, basically. So it was all my friend says he saw this, so I saw this too. But then when they were asked about, well, where were you exactly standing? They were on the opposite side of a building. I mean, they patently could not have seen anything.
And then they testified to that under oath. And then the state goes, yeah, well, I mean, they failed to return an indictment. But if they had returned an indictment, the state would not really be able to reliably bring those grand jury witnesses. They would not be able to bring those grand jury witnesses to trial and expect them to say something different, because they have testified under oath before the grand jury. Those transcripts were released by the state, and they would have real impeachability problems.
And that prosecutor in that jurisdiction lost his job over that decision to run an honest grand jury.
Yeah,
he was replaced by a Soros-funded candidate next election,
which was really too bad, because he was criticized at the time for doing. They're like, how dare you let someone testify on behalf of the defendant in the grand jury thing? It's like, because you don't have to.
No.
But it's like he was doing what the grand jury was supposed to do: discern prior to the case whether or not there was sufficient cause. And in Darren Wilson's case, there just wasn't. All of the evidence pointed towards acquittal, and the fact that he was being attacked at the time that he shot, that he had just been beaten, and that Mike Brown had basically put his head down and charged directly at him. And any honest review of the evidence, so any review that wasn't from Ben Crump said that.
Right.
The only person who said otherwise was Ben Crump to the media. Callum Lane says, negative review on Andrew's book I thought was hilarious. Quote, the author on one occasion commented that a typical jury has the collective IQ of a door hinge or something to that effect. The legal mind is predatory and psychotic. Well, where's the lie, though?
I don't know. I don't think I would have said door hinge, but something to that effect. Yeah, I'm sure. I mean, just watch any jury selection, folks.
Oh, we're back. We're back. Here we go.
They can look at it as much as they want in the jury deliberation room. The state has the right to argue that Officer Johnson wasn't in danger of getting dragged by the car in final argument. That's totally fair game. You know, the state can argue and stop the video in final argument and say, look, both of his feet are on the ground. That's all fair game, but I'm not going to let the witnesses tell the jury what's on there. Okay?
Good ruling, Judge.
As far as the photographs that 403, 405, and 402, I understand that the defense never got those still photographs, correct?
Yes.
And they're not even on the state's witness list or the exhibit list.
Ooh.
Your Honor, the defense did receive those exhibits. This morning, we had a 15-minute break for them to review them. That was at approximately
how generous of you.
They've now had about 2.5 hours to review the still images. They aren't novel per se, because they are still images of the videos that they have had for several months. I have not heard any renewed claim that they are continually
prejudiced by us being able to introduce these images. These are images which the jury has seen in real time in the video, but these are specific excerpts which have been created so that they are isolated exhibits.
They're
so that
different,
they,
or you wouldn't
can
be doing this.
Shown to the jury.
Yep.
Yep.
Yes, I am not going to reconsider any of my prior rulings.
Good.
No matter how many times you want to argue it. Okay, so,
Again, the state was seeking clarity, Your Honor, is that
That's a pimp
this
slap right there,
morning,
folks.
it seemed like the court was saying you can't use still images to allow the witness to explain what was observed in the video. Then the state utilized the video and asked the witness to explain what was being seen in the video, and that too was
Yes.
cut out. What the state is
correct.
asking now is to admit these still images as exhibits, but I will refrain from asking the juror what is specifically occurring in these
A
still
witness,
images.
he means.
I've ruled that the still exhibits, the still photographs, 402, 403, and 405 will not be admitted. The objection is sustained.
Get over it.
Okay.
The state.
All right. Are you ready for the jury?
I mean, Larson's treating the judge like a bitch here.
Yeah.
Okay. Thank you, Deputy.
He's
Oh, by the way,
being completely insubordinate.
one word objections, please. Okay. And
Objection.
say
Bullshit.
one word, and then if you need to make an argument, we've got to use these buggers. Okay.
Why?
Okay. Thank you, Deputy.
Silliness. I mean, I get the idea that because you could just make the argument to persuade the jury, even if you're going to lose the objection, but
Right.
If you're going to be speaking, go to the podium because our poor court reporter can't hear. Okay.
she's an
That also
underprivileged
prevents you
youth.
from talking
Can't
over
hear.
each other, right?
Yes, Your Honor. Will do.
Let's see. Chris Demand says, "Why is there even a case? What even is their case?" Oh no, I read that one. Ibni says, "I don't think the prosecution has asked a single open-ended question all day. Not really." Kim Potter Feet Pick says, "The next person they call is going to be the car wash owner." Tampa Guy says, "Jesus wept. Are most trials so pedantic and repetitive?" No. Hey, we have a new addition to the stream. Please welcome Carrie Christie.
Hello, guys.
Hello.
How's it going?
It's going.
Carrie is an attorney down in Tyler, Texas at the Beard and Harris Law Firm
Okay,
for anybody
please be
who
seated.
is not aware.
Nice to meet you,
All right,
Carrie. I'm
members of the
relatively new
jury, I'm
around here.
sorry for the short
Nice to meet
delay.
you.
Okay.
Oh, and
you
I'm
may
Andrew.
continue,
I know it doesn't show
Mr.
on my little
Larson.
Yes, sir. Yes,
I'll
sir.
be brief. Could you please redisplay exhibit 204? Agent Peterson, I'm showing you exhibit 204. Would you agree that this is the video paused exactly at 2:02 p.m.?
Yes.
Thank you. No further questions.
All right. You may cross, counsel.
Earl's my man. I live for Earl Gray Cross.
Good afternoon, Special Agent Peterson. Would you agree with me that a visual observation being there is much better than a body-worn camera planted on your chest?
A visual observation?
Yes,
What do
you're
you
there
mean?
and you can see everything, and your body-worn camera only takes up a certain amount. Is that a fair statement?
Yes.
And with respect to hollow point bullets, they're used by law enforcement because they do not leave the body and shoot somebody else. Is that a fair statement?
Generally speaking, yes.
Yeah. And that's why they're used by law enforcement?
Yes.
And does your office use them?
Yes.
And when, did you notice in these videos that Johnson's video was a second off of Potter's?
No.
All right. And with respect to the taser statement, you're familiar with tasers?
Yes.
And is when somebody yells taser, that's warning to the other law enforcement officers that are there to back off. Their statement?
I don't know if it's fair to say to back off.
But to not touch the guy because you might get electrocuted.
That's part of the reason. Sure. Yeah.
What's the other reason?
To give warning that the taser is going to be deployed.
Okay. Thank you. That's all I have.
Council?
Video is the second off. Pretty interesting.
Agent Peterson, earlier this morning, you testified about your career in the Force Investigations Unit, correct?
Yes.
You've evaluated over 70 claimed reports of excessive force, correct?
Yes.
Including several homicides.
Judge, I object to this. I never went into past experience. It's outside the scope of cross-examination.
I'm getting to a point, Your Honor.
Oh, so?
You may continue for a while.
Someone's got some sass.
In your experience, has reviewing body-worn camera footage been a critical aspect of your investigation?
Yes.
And indeed, requesting body-worn camera is a critical request that is made in an investigation.
Same objection, Mayor. I ain't going to question body-worn cameras.
The objection is sustained beyond the scope.
What would occur if there was no body-worn camera to review in an officer involved
Objection
case?
calls for
If you
speculation.
had no body-worn camera footage.
Object to that is not relevant, Your Honor. It's also outside the scope.
I am again sustaining the objection outside the scope.
Does body-worn camera footage have certain benefits?
The objection is overruled.
When body-worn camera video exists, are there certain benefits to reviewing that video versus relying on the testimony of witnesses?
I didn't ask that question. It's outside the scope. I talked about visual observation.
Okay, one word objections, please. I'll let you answer that.
Oh, man.
I'm going to have to repeat it. I'm sorry.
Sure. Does reviewing body-worn camera footage in these cases have advantages at times than simply relying on the testimony or statements of witnesses?
At times, yes.
Yes. No further questions.
She should not have let him answer that question, in my opinion. He just asked the same question three
Especially
times.
from Peterson, what I asked you was, is a visual observation of something, forget about the testimony, a visual observation of something better than a body-worn camera that has tunnel vision?
It can be, yes. It'll be different.
It's a large, you can see it better if you're there looking at it than a body-worn camera. Isn't that true? Because you see more?
Yeah, that would be accurate.
Thank you.
Mr. Morrison?
What advantages does reviewing body-worn camera have in your investigation?
Oh, my God.
Oh, boy.
Object, Your Honor, outside the scope of recross.
The objection is overruled.
What is the advantage of body-worn camera? It provides a
I hope he
independent
recrosses him.
depiction of an event
that can be reviewed. Paused.
Leading.
Yep.
Leading?
Yes.
Leading, yeah.
Brought into court as an exhibit.
Why don't you just
Yes.
take the stand,
No
Laura?
further questions.
Right.
What was the point?
Anything further?
No, Your Honor. Thank you.
He laughs. No.
Thank you, Your Honor.
I mean,
Welcome to the show, Lacey. How's it going?
Hey, Nick. It's going pretty good. How are you doing?
I'm doing very well, thank you. Lacey is another attorney at Beard and Harris.
The
down
state
in
may call
Texas.
its next witness.
This time, Your Honor, the state calls Michelle Pascal.
Oh my goodness. I'm gonna be back in just a moment.
Okay.
Whoops, wrong profile picture. 1 second.
Good afternoon. Will you please stand behind the witness
I'm quite
chair?
enjoying that one.
Raise your right hand. Do you swear under penalty of perjury that you will truthfully testify in connection with this trial? I do. Please take a seat. Thank you. And would you please remove your mask? State your full name and spell it.
First name is Michelle, last name is Frasconi, Michelle. Last name Frascone.
Okay, we have a court reporter taking down everything that's being said. So you have to say yes or no instead of shaking your head. Don't say uh-huh or uh-uh. Only one person can talk at a time. Wait until the question is finished before you answer. If you don't understand a question, ask for clarification. And finally, if an objection is made, stop talking. Don't answer it unless I tell you to.
Thank you.
Counsel?
Would you state your occupation for the record?
I'm a police officer for the state of Minnesota.
What's your current, what law enforcement agency are you with?
I work for the state of Minnesota, the Bureau of Criminal Apprehension.
What is your current rank?
Assistant Special Agent in Charge.
How long have you been with the Bureau of Criminal Apprehension?
I have been with them since 2016.
What unit are you currently assigned to?
Currently assigned to the Force Investigative Unit.
Prior to working for the BCA, do I understand that you have prior law enforcement experience?
That's correct.
And what is that?
Prior to coming to the BCA, worked for the city of Woodbury as a police officer.
And that was from 2006 to 2016, correct?
That's correct.
And you're a licensed peace officer still today?
Yes, I am.
And you take continuing education courses to maintain that license?
Yes.
Based on your law enforcement experience, did you acquire specialized knowledge or experience in the use of firearms and other weapons such as tasers?
I did.
If asked, are you able to describe the basic features and functionality of weapons such as firearms and tasers?
I hope they explain how this firearm went off.
As part
and
of your
shot
work
this
in the
innocent
Force
man.
Investigations Unit, do I understand that you've responded or participated in the investigation over 100 officer-involved shootings,
That's correct.
both as a lead agent and at times a supporting agent?
Correct.
And you were assigned to assist in the investigation of the case involving Kim Potter, correct?
That's correct.
I want to get right to your actions on April 11th of 2001. Do you recall that day?
I do.
And what were you doing?
It was a Sunday afternoon and I was at home.
Okay. And did you receive a report of an officer-involved shooting in Brooklyn Center, which prompted a response from you?
Yes, I did.
And could you describe that response?
I was contacted by my supervisor who requested that I respond to the Brooklyn Center Police Department.
And when did you arrive to the Brooklyn Center Police Department?
I think I arrived around 4 p.m.
When you arrived, were you the first agent at the precinct, or was anyone else from the BCA already present?
Prior to my arrival, Special Agent in Charge Scott Mueller was at the police department.
And what did you do when you first arrived?
When I first arrived, I met with Agent Mueller, who provided me just some general information about what the investigation was involving.
Soon after you met with Agent Mueller, were you joined by another BCA agent?
Yes, I was.
And who was that?
Agent Sam McGinnis.
At the time after you were briefed by Mueller and spoke to Agent McGinnis, did you learn who the involved officer or officers were?
Yes, I did.
And who was that?
Officer Kim Potter was the involved officer, and then there were 2 witness officers that were also at the agency.
Was that Officer Lucky and Sergeant Johnson?
That's correct.
Okay. After meeting with Agent Mueller and Agent McGinnis, what was the next? Who was the next individual who you encountered?
I went into the conference room that Officer Potter was in with her counsel, and then at the point after that, I went upstairs and met with Sergeant Johnson.
Okay, well, let's talk about both of those encounters. You said you went upstairs to see Johnson. So do I understand there's a conference room on a lower level or a main level of the Brooklyn Center Police Department?
That's correct.
Okay, and that's where you saw Officer Potter?
Correct.
Was Agent McGinnis with you as well?
Yes, he was.
When you observed Officer Potter, was she still wearing her uniform?
Yes, she was.
How much time did you spend with her?
A very short amount of time.
Okay. Before that date, did you know her?
I did,
In what capacity?
in a professional capacity, and our husbands had prior worked together many years ago.
Okay. Would you agree that Ms. Potter is sitting here at council table over at the front council table closest to you?
Yes,
Okay. At the time you encountered her, did you observe whether she had a firearm on her duty belt?
yes, I did.
Did you receive any information about that firearm?
I was advised that that firearm was Sergeant Johnson's firearm.
Okay. What was the first action that you and Agent McGinnis took when you encountered her?
Photographs were taken of her uniform.
And what happened to the equipment that she was wearing?
It was collected.
Okay. At that time, did you know why she was in possession of Sergeant Johnson's firearm?
I did not.
After the firearm was collected, do you recall what was done with it?
It was placed inside of a box.
Did you observe at that time whether it was loaded or unloaded?
I did.
And what was it?
It was unloaded.
Unloaded? So you took Sergeant Johnson's gun from Officer Potter. What did you do after that?
I went upstairs and met with Sergeant Johnson.
At some point, did you also speak again with Agent Mueller?
I did.
Did you reveal that you had a prior interaction with Officer Potter?
I did.
And did that affect your involvement in this investigation?
Not a lot. I just asked for, to have other duties assigned to me. And at that time I was assigned to Sergeant Johnson.
Okay. And why did you ask to not have duties related to Officer Potter?
Just out of just making sure that there was no conflict or any issues as a result of it.
Sometimes we use the words appearance of impropriety. You wanted to avoid something like that, am I correct?
I'm going to let you answer that. Objection overruled.
So you said you were tasked with then going to talk to Sergeant Johnson?
That's correct.
And did you bring anything with you when you met with him?
I did.
And what was that?
I brought his handgun upstairs.
Okay. And when you brought his handgun upstairs, what did you anticipate doing?
I wasn't sure of his involvement at the time, so I wanted to make sure that it was with me. Many times we find that supervisors will exchange weapons when they weren't actually have any involvement in the case. And so when I went upstairs to meet with him, there was a possibility that his weapon would be returned. However, I became aware that he was a first person witness. And so at that time I held on to his handgun.
On a scale of 1 to infinity, how many of our
Where did
witnesses
you
would
discover
you
Officer Potter's
describe
handgun?
as first
In his
person
holster.
witnesses?
So you made a plan to collect both firearms at that point?
That's correct.
I now want to discuss your interactions with Sergeant
Why would
Johnson.
they ever
How much
break
time did
that?
you spend with
I'm
him?
very confused.
I guess I would approximate 10 minutes or so.
Did you take any photographs of him?
I did.
At the time, was he wearing Officer Potter's firearm?
Yes, he was.
Did you inspect that firearm to see whether it was loaded or unloaded?
I did.
And was it
It was loaded.
loaded? And what did you do with that firearm after you collected it?
I secured it in a box for our crime scene.
When you collected both firearms, did you document them by serial number to ensure that they were distinguished?
I did.
And to whom did you bring those firearms after you documented them?
Agent McGinnis.
Agent McGinnis. I now want to show you just a few photographs. Could you please put up Exhibit 176? I'm showing you Exhibit 176. If I says, can you recognize which gun this is?
Yes.
Which gun is this?
Officer Potter's.
Take a look again. It's the unloaded
Oh,
firearm.
I apologize. Sergeant Johnson's.
You said you took several photographs of Officer Johnson. If I showed you 2 photos of them, would you recognize them?
Yes.
At this time, the state offers exhibits 84 and 85 photographs of Sergeant Johnson. 84 and 85, sir?
Any objection? Exhibits 84 and 85 will be admitted and you may publish.
Please show 84.
Razor 319 says, what would the BCA would do if some agencies in the
Agent
state...
Fresconi, I'm showing you exhibit
Damn it.
84.
I'll get him in a second.
Is this the picture of Sergeant Michael Johnson as you saw him on April 11th?
Yes.
Now exhibit 85.
Be funny if it was an underwear picture that she saw.
Could you describe what's shown here in exhibit 85?
That would be Officer Potter's handgun showing that it was loaded and contained within Sergeant Johnson's
And on the
holster.
right, we have Major Johnson.
I'd now like to show exhibit 178, which is already admitted into evidence. Do you recognize which gun this is?
I do.
Which gun is this?
This is Officer Potter's handgun.
Okay.
Are you sure you got it right this time?
time? Discovered in the firearm?
Correct.
Okay. And then exhibit 179.
Because they're just so distinctly different.
Again, just a close-up of that serial number, correct?
That's correct.
Then exhibit 180.
Have you memorized Officer Johnson's Glock serial number?
Again, the loaded magazine. that
In
you
the
discovered.
10 minutes you were meeting with him?
And then again, Agent Fresconi.
It's the same as his OnlyFans handle.
My OnlyFans URL is my serial number.
Block me.
Correct.
Block me, baby.
And that was exhibit 199. No further questions here.
Is there any cross?
No cross.
Oh,
Thank God.
Step
What a
down.
waste of time that was. Razor 390 says, what would the BCA do if some agencies in the state they are performing investigations for don't have body-worn cameras? BWC evidence would be, body-worn camera evidence would be
The
supplementary
state may call
evidence,
its next witness.
source versus primary source in the BCA process. If they didn't have the body-worn cameras, they would just rely on witness testimony and interviews like normal police work.
Yep.
No.
Mark Gee says this witness is a Glock racist. How dare she misidentify a Glock that looks like every other Glock?
Swear under penalty of perjury that you will truthfully testify in connection with this cause.
I do, Your Honor.
Please have a seat. Remove your mask, please.
I hope this is another
And state your
BCA
full
agent.
name and spell it.
Yes.
Sam
Yes.
McGinnis, SAM MCGINNIS.
All right, the court reporter is taking down everything that's being said. So say yes or
We
no.
have good
instead
history
of
with
shaking your
McInnes
head.
witnesses on
Don't
this
say
on this
uh-huh or
on this channel.
If you don't understand a question, let the lawyer know. If an objection is made, stop talking and don't answer the question unless I tell you to. Okay, only one person can talk at a time, so wait till the question's finished before you answer.
Yes, Your Honor.
All right.
Could you please state your occupation for the record?
I'm a senior special agent with the Minnesota Bureau of Criminal Apprehension, currently in the Force Investigations Unit
How long have you been employed by the Bureau of Criminal Apprehension?
since April of 2020.
Do you have law enforcement experience prior to joining the BCA?
I do.
Could you please recount that for the
Thick
jury?
beard.
I was with the Waseca Police Department from 2011 to 2015. From 2015 to 2020, I was with the
Are you
Mankato Department
envious,
of
Nick?
Public Safety.
Could you describe your assignments when you
itchy.
worked for the Mankato Police Department?
I started there as a patrol officer, and I worked my way through investigations, working narcotics, and I left there as a patrol sergeant.
Did you have any specialized experience with firearms?
I did. One of my collateral duties was a firearms instructor.
And that required an additional certification, correct?
I did.
Currently undercover and
And you're still a
official
licensed peace
barricade.
officer and take continuing education courses to maintain that license?
Correct.
Would you agree that you have acquired specialized training and experience in both firearms and tasers?
The basic functions, yes.
Yep. And if asked, you are able to describe the basic features and functionality of both firearms and tasers, correct?
Yes.
Now, the jury has already heard testimony about what the Force Investigations Unit does, but I want to specifically focus on what you did on April 11th. Okay, sir?
Yes, sir.
Do you recall that day?
I do.
And did you receive some information that prompted a response from you?
I did.
And what was
It's
that
a little odd
information?
that Frank
I was
and
contacted
Eldridge
by
have completely stepped
ASAC
back,
Mike Phil
and it's
concerning
all
a
Larson
fatal
all the
officer
time.
involved shooting that occurred in Brooklyn
Yeah.
Center. He informed me that the driver was deceased. There was one officer that had shot or discharged their
I
firearm.
don't know why
and
you
two
would
officers
swap
that had been
her
on
out
scene
for him,
during the
though.
incident.
It's not like he's
And
particularly
was there a
better.
request for you to respond somewhere?
Yes.
Where did you go?
ASAC Phil requested that I respond directly to the Brooklyn Center Police Department.
When did you arrive?
Approximately a little after 1600 hours.
Okay. We know that is 4 p.m.
Correct.
When you arrived, were you the first agent there?
I was not.
Who else was present?
Special Agent in Charge Scott Mueller and Assistant Special Agent in Charge Michelle Fresconi were already on scene.
Did you have a conversation with them prior to beginning your investigation?
I did.
And were you given an initial task?
I was.
What was that task?
I was tasked with photographing and collecting the equipment from Officer Kim Potter.
And did you meet with Officer Potter at the Brooklyn Center Police Department?
I did.
And she's seated here at council table?
Yes, sir.
At the time that you encountered her, was she still wearing her uniform?
She was.
Was she in possession of her duty belt?
She was.
Was she in possession of a firearm?
She was.
Did you receive any information about that firearm?
After our interaction together, I did, yes.
Yep. And you learned that that was Sergeant Johnson's firearm, correct?
I did.
Was that a loaded or unloaded firearm?
Unloaded.
Did you ultimately take photographs of her?
I did.
Did those photographs include her wearing the duty belt, firearm, and taser that she had on her person?
Yes.
After taking those photographs, do you recall what you did? Next.
I do.
What was that?
I collected her equipment to include her duty belt.
Okay. Did you collect that firearm?
I did.
And where did that go?
That went into a box and then into ASAC Fresconi's custody.
And when you collected it, did you confirm that it was unloaded?
Yes.
Okay. After the firearm was removed, you testified that you did collect that duty belt?
Yes.
And could you describe what is all contained in a typical officer's duty belt?
Typically, a firearm, a set of keys, spare magazines for said firearm, flashlight, mace, handcuffs, radio, taser, a baton.
Is the placement of items on an officer's duty belt something that a typical officer plans out and does deliberately?
Yes.
When you collected the duty belt, did you separate the taser from the duty belt or did it remain in its holster?
It remained in its holster.
Just like when she shot.
How much time did you
Dante
spend with
Wright.
Officer Potter?
Altogether, maybe 2 hours.
2 hours. Do I understand that you at one point went to North Memorial Hospital where she provided a blood sample?
Yes.
And then you returned back to the Brooklyn Center Police Department?
Myself, Officer Potter left from the hospital and didn't return.
Yes, thank you for clarifying. When you returned to the Brooklyn Center Police Department, did you have another encounter with Agent Fresconi?
I did.
And did she provide you any evidence at that point?
She did.
What did she provide you?
2 firearms.
And at that point, did she describe to you which firearm was Potter's and which firearm was Sergeant Johnson's?
Yes.
And did you document that in a chain of custody form that's used by the BCA?
Yes.
After you collected the firearms from Agent Fresconi, can you tell the jury where you brought those firearms?
I brought those 2 firearms along with the blood sample or blood kit to the crime scene team leader, Melissa Lauren. and sign them over to her custody.
Okay. At this time, I want to show the jury the photographs that you took of the defendant. The state offers at this time exhibits 210 to 213.
Is this the defendant giving the Nazi salute?
Exhibits 210 to 213 will be admitted into evidence and you may publish.
Wouldn't you agree this is the defendant clothed only in the Confederate flag of the United States?
First, I'm showing you exhibit 210. Do you recognize this?
I do.
What is this?
It's a picture that I took of Officer Potter.
And this is her standing, looking straight towards you, right?
Correct.
Front, face forward.
No, that's actually her from
And
the
you can,
back.
can you see the taser
Right.
in her holster?
That's the wrong side.
And what side of her body does she have that holstered?
Her left side.
Okay. Published 213, 211, pardon me, 211. And what, this is another photograph of Officer Potter, correct?
Yes.
And to which direction is she standing in 211?
She's showing me her right side.
Okay. And this is the side that she held her firearm?
Correct.
Okay. 212? I'm showing you exhibit 212. What's shown here?
Her left side.
Okay. And this is, again, as you testified, the side where she's wearing her taser?
Correct.
Yeah. It's bright
And
yellow.
then 213.
Except for the grip itself is
For
black.
completeness, this
Yeah,
is
but
what
still.
Officer Potter looked
Yeah.
like from behind, correct?
Correct.
Right. Now, do you know
Oh,
whether
that's a
you
view
can
we
take
didn't need.
do you know whether the duty belt and
Yeah, that was
taser that you
pointless.
collected from the
That
defendant
was
were
not very
photographed?
flattering.
They were.
Thank you for
And you've
saying
seen a
that
set
so
of
I didn't have
photographs
to.
prior to trial.
I have.
State
I
offers
mean, I don't
exhibits
mean it in a mean way,
214
it's
to
just-
225, Your Honor. These are photographs of the duty
It's
belt and taser.
unnecessary and flattering.
Really
picture.
shows nothing.
The state offers
has
exhibit
nothing
Those
to do with it.
exhibits will be
23,000.
admitted into evidence and you may publish.
Yeah, that's the thing.
Thank you, Your Honor.
Saying it was unnecessary describes the entire case of the state so far.
Seems to be.
We'll try to do these in a series, Agent McGinnis, and I'll ask you what is shown. And if you could please just fulsomely describe what you see, I think we can go pretty efficiently. I'm showing you exhibit 214. What is shown here?
Officer Potter's duty belt laying flat on a table.
Exhibit 215. What's shown here?
Her taser out of the holster.
216. What is shown here?
Officer Potter's empty firearm holster.
Okay. And right next to the firearm holster, these are some of the items which you described an officer typically carries on a duty belt.
Yes, sir.
Exhibit 217.
Her
Would you agree that 217 is another more close-up image of the
Where
firearm
is the
holster?
retention there?
Yes, sir.
Exhibit 218.
yeah, I see a button for it, but I don't see the
Yeah.
actual.
Just a more
strap.
close-up image of the firearm holster,
Well, and I
correct?
thought he just,
Yes.
I mean, he testified that he took a picture of the
Exhibit
duty belt
219.
with the firearm in it. Did I miss that?
It was on
Just
her.
another image of
Yeah.
how the firearm holster is mounted on the duty belt. Is that correct, sir?
Correct.
Where's the?
Exhibit 220.
Her asp baton has a whole lot of wear on the nub of it.
What does Exhibit 220 show you?
Officer Potter's empty taser holster.
Exhibit 221. Another photo of the taser holster, correct?
Correct.
Exhibit 222. Another photo of the taser holster, correct?
Correct.
Exhibit 223.
Oh, for God's sake.
Would you agree this is a side
This
view
is unnecessary
of
too.
the taser holster?
Yes.
Could you describe what the black piece of plastic on that taser holster is?
They're just trying to
What
bore
looks like a
the
lever,
jury
if you
into
will?
tuning
A
out.
lever?
Yeah.
It's a security mechanism. It once the taser is inside of the holster, it's retained there by that security mechanism and can't be brought out again until that is pushed and the taser is released.
You should ask if you could
And then
prime
exhibit
the lever
224.
by releasing it early and
Early.
having the taser sit out.
This is just a straight image of the taser. Is that correct? Exhibit 224?
Yes, sir.
And then 225? What is shown here?
Oh my
Just the
gosh.
bottom of Officer Potter's
The
taser
bottom?
showing the serial number and the department number on it.
Thank you. Put that down. Based on your examination of the defendant and the defendant's equipment, could you testify about how she had her weapons holstered to enable her to draw them?
They were both what I would call a straight draw position. So both the rear handles of the taser and the gun would be facing her rear.
How was the firearm? Pardon me. How would Officer Potter be able to pull the firearm from her firearm holster?
Her firearm was on her dominant side, which you have to use her right hand to draw.
Yep. Was there any safety mechanisms or straps that were holding it into the holster?
Yes.
What was that? Could you describe that?
That particular holster has a snap retention system, same concept. It's a security mechanism. Once the firearm is in the holster and that snap is, placed on, the firearm cannot be removed until that snap is released.
Okay. And you would unsnap that snap with your dominant hand, with your right hand?
Yes.
Okay. What about the taser on the left side? How is that
Or the
unholstered?
other hand. I mean, if you want
Again,
to.
breaking that retention system or pushing that lever, and then using your non-dominant hand.
Am I correct that the defendant's duty belt and taser were stored at the BCA during the pendency of this case?
Yes.
When the BCA stored these items, were they altered or manipulated in any way?
No.
Unlike your video.
Yeah.
Do you agree that the belt was transported here to the Hennepin County Government Center in preparation for trial?
Yes,
And did you see that belt and its contents again while here at the Government Center?
I did.
And when you did you take some action to alter that duty belt prior to trial?
Yes.
And what was that?
The holster, the firearm holster and the taser holster were both removed from the duty belt.
And why was that done?
To be shown in court.
If I showed you these actual items we've been discussing, would you recognize them?
Yes.
Okay. Let's start with the duty belt. The state offers Exhibit 378.
378 will be admitted into evidence, and you may
I just don't see a thumb strap
show
there.
the agent badge exhibit.
At least this is at least partially relevant to the question of should she have drawn the taser?
I guess I'm showing you Exhibit
firearm?
378. You recognize
guess.
this item.
Yes.
And what is this?
Officer Potter's duty belt.
Would you agree it's the duty belt, but without the two holsters?
I would.
Do you think it would fit me if you had to guess?
I'd say that's a definite no.
State offers at this time Exhibit 379, the firearm holster.
379 will be admitted, and you may approach the witness.
We'll try something.
I wonder if Potter's put on a bunch of weight and the defense can say, hey, the belt don't fit.
Yes.
Mess to quit.
Belt doesn't fit, must have quit.
That's not mine. That's
Yes, I'm
Officer
showing you.
Johnson's.
Yeah.
That's Major Johnson right there.
On the view screen here. Exhibit 379, correct?
Yes, sir.
And would you agree this is the firearm holster?
I would.
All right. I'm going to stop this.
Thanks for doing that before you walked up.
Just
Could you just done that up?
snap. Is this the snap that you're talking about?
Yes.
Okay, so when you're holding it on the right side like this, this is the snap that must be depressed to take the whole firearm off?
To release the firearm, yes.
Are you depressed that it took you two hands to work the snap?
Counsel, Counsel, you need to stay behind the podium.
That's fine.
Okay.
Next, the state offers Exhibit 380, the taser holster.
What's that objection? Was it him trying to walk by the jury with the holster?
It's that
Oh, that exhibit
Larson
will be
is
admitted.
demonstrating the holster.
Thank you.
Yeah.
So he's in effect providing
Guinness, you
testimony.
recognize
Yeah.
this as the taser holster, Exhibit 380?
Yes.
And the clasp or the lever that you talked about is still functioning today?
Yes.
She's sending Morse code to the jury? Oh my goodness.
He's like, it moves. I must touch it. I must touch it.
Now I want to show you the actual taser. State Officers Exhibit 203.
203 will be admitted.
Fire it in the court. That would be
Permission
awesome.
Hit a juror. Hit a juror and see what happens.
Name?
Oh,
Tase
gosh.
yourself. Believe in the ball. Tase yourself.
That's how you win cases. You tase a juror on accident.
Agent McGinnis,
Look at how
you are in
easy it is
possession
to
of
screw
Exhibit
this up.
203. Could you describe this taser's general features?
It's a TASER 7, model TASER 7, yellow in color. It has a safety switch on it, a battery in the bottom of it.
Could you hold up the taser and show the jury the safety switch?
Ooh.
If you have that safety switch in the disarmed position, can that be fired?
No.
To activate it, you have to flip the safety switch. Am I correct?
Correct.
Okay. And one moment ago, deputy came over and provided you a live battery, correct?
Correct.
All right. What will happen when you turn on that battery, based on your training experience?
When I put the battery in and activate the TASER,
Yeah.
it will show the, it'll arm it and show the lasers, the CID screen, and the flashlight.
Okay. When you say it'll show this CID screen, could you describe where that's going to come from?
From the back, it shows the information about the TASER, the battery level, and the probe status.
Okay. And you testified that there's also lasers?
Yes.
Okay. Could you tell the jury what is shot out the end of that taser once you arm it?
There are aiming lasers that I guess show you where to fire. The TASER probes.
Okay. At this time, Agent McGinnis, I'd ask you to stand up, stay behind the witness box there, and to activate the taser to show the LED lights, the lasers, and the flashlight.
Pew, 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 pew.
Thank you. Agent McGinnis, without pointing the taser at Judge Chu, could you please show the back end of that taser to the jury? Thank you. You can please disarm that taser, and could you remove that battery so it can be collected by the deputy?
If you tase me, it would be okay.
All right, I want to get back to some investigative work you did in this case. Did you ever visit the crime scene?
Briefly.
Okay, just to bring the firearms to Melissa Lauren?
Yes.
In addition to the evidence that you obtained from Officer Potter, did you collect other evidence?
Yes.
Okay. In terms of what you gathered, would you agree you gathered a lot of the documentation in this case?
Yes.
That include paperwork, records, policies, et cetera?
Correct.
Did you also participate in a number of witness interviews?
Yes.
And you collected reports from various officers?
Yes.
I want to talk not about those per se, but your events on May 4th. Do you recall meeting with witnesses at the Brooklyn Center Police Department on May 4th?
Yes.
Okay, who were those witnesses?
Commander Garrett Flesland and Sergeant Mike Peterson.
Was that a scheduled meeting?
It was.
What was the purpose of the meeting?
To upload Officer Potter's data from her taser.
Okay. And to do that, did you have to then bring Officer Potter's taser, the one you just held in your hand, back to the police department?
Yes.
And what sort of data did you hope to obtain from that?
The records of use, a full audit of the taser, make sure it's functioning properly, things of that nature.
Okay. And did you receive assistance in getting that information off of the taser?
I did.
And how was that performed?
Sergeant Mike Peterson removed the battery from the taser and put it in the docking station at the Brooklyn Center Police Department, and then uploaded the data onto their computer system.
And then you end up getting a report from that, correct?
Sergeant Peterson printed out a copy of the audit for me, yes.
And then you provided it to you.
Correct.
Okay. What did you learn regarding who had possessed that taser prior to coming into possession of it yourself?
I learned that Officer Potter was the only one that had possession of that taser, at least in the field.
Okay. And when did you gain possession of it?
March 26th, I believe.
Did you receive any other information about the taser's functionality?
Yes.
And whether it was functioning at that time?
It was.
Okay. Now, was there any data that you received regarding when the taser had been function tested?
She received it March 26th.
What is a
weeks
function
before
test?
this event.
It's a test you perform on the taser to make sure the core electronics
Wait,
are
so
working
she
properly.
just got it in March before
internal and
April?
external check.
Yes.
So if she had a different model before this, she only had 2 weeks
Are
experience.
you familiar with how often an
taser.
officer is supposed to perform a function test?
Yes.
How often?
According to the Brooklyn Center Police Department taser policy, they should perform a spark test before each shift.
Do they?
If an officer has a taser on their duty belt, how would the officer have to remove that taser to perform the function test?
Yes.
Now, have you heard of a function test also being called a spark test?
Yes.
Why is it called a spark test?
The spark test name comes from when you arc the taser to make sure that it's working properly.
So part of the function test is actually not only turning it on, but causing an electrical current to be shot through it.
Correct.
Or sparked.
Or arc? Might as well say it again.
In the information that you received in the report, did the report indicate when and whether a function test was performed on particular days?
Yes.
All right. Slightly related topic. In addition to the taser data, did you gather information about when Officer Potter worked since March 26th?
Yes.
And how did you receive that information?
Commander Flesland emailed me a copy, the dates she had worked.
Okay. And do you recall how many shifts Officer Potter worked between March 26th and April 11th?
Yes.
How many?
10.
If I showed you that email again, would you recognize it?
Yes.
State Offers Exhibit 226.
226 will be admitted and you may publish.
I wonder if she ever spark tested it.
I bet she didn't, but so what?
Right.
Right, yeah.
I mean, they're going to dock her a day's pay.
You show all the other spark test records of every other officer.
Their officer.
The failure to spark test is
Agent
not what
McGinnis,
led
I'm
to
gonna-
this.
yeah, let's zoom in here. I'm showing you Exhibit 226. Would you agree this is a copy of Commander Flessen's email to you?
Yes.
And right here, we've zoomed in on the pertinent portion of the email. This would recount Officer Potter's work history from March 26th to April 11th, correct?
Correct.
And essentially, she worked March 26th, 7th, and 8th, March 31st and April 1st, April 5th and 6th, and then April 9th, 10th, and 11th, correct?
Correct.
Okay. Let me take that down. Once you had that work schedule, what did you do with that information?
I cross-referenced it to the TASER audit showing when function tests or spark tests were conducted and when they weren't.
Did you draw any conclusions?
I did.
What were those conclusions?
Officer Potter had conducted function test or spark test on her TASER 6 out of the 10 shifts.
Oh, for God's sakes.
But not all 10.
No.
Do you recall the last occasion when she performed the function test?
April the 9th.
April 9th? So she worked on April 10th and 11th and did not perform the function test on either day.
Correct.
We had a previous officer testify they checked every other
One-word
day.
objections, please.
Well, there were two different
It has
objection
been asked
bases.
and answered. Please move on.
And it is leading.
And no more speaking objections.
That wasn't a speaking objection. He
All
actually
right.
just gave 2 one-word objections for different grounds.
I do want to talk more about these function tests. And I don't want to repeat your testimony, but you did
But I
conclude
want to
that
repeat
there were
your
days on
testimony.
which the function test was not performed, correct?
Correct.
Now, Agent McGinnis, you were a police officer for 10 years. In terms of your investigation, was this information that you learned about her failure to function test noteworthy?
It was.
The objection is sustained.
I didn't hear what he said.
Was her failure to function
was
test
noteworthy
based
that
on your
you failed
understanding
to
of Brooklyn
test every
Center
day.
policy, a violation of that policy?
I think you need more foundation for that, counsel. I'm going to sustain the objection for lack of foundation.
You previously testified that you understood, Agent McGinnis, that the function test was something that needed to be performed every day before officer shift, correct? You testified to that?
Yes.
Okay. And then you also testified about information about when that was not done by Officer Potter, correct?
The objection is overruled.
He's been
Yes.
leading the whole time.
Just doing the math here. Based on that information in your investigation, did you conclude that she violated that policy?
I'm going to sustain the objection.
It's the same
for lack
foundation
of
you had before.
foundation.
Right.
You didn't make more foundation.
Did let's say this, your results, pardon me, your conclusions that she did not
Conclusions and opinion.
function test,
Objection.
those
Here it
are,
comes.
you found no information to the contrary, correct?
Correct.
Now, earlier we discussed the collection of the firearm used by Officer Potter and that you provided that to Melissa Lauren, correct?
Correct.
Do you know whether after it was inventoried, there was further examination of that firearm?
I am aware that there was, yes.
Yep. And that additional work was done by forensic scientists, not you?
Yes.
Now, you did, though, have an opportunity to view and examine that firearm on a later occasion, correct?
Yes.
And you'd agree that you'd be able to recognize that firearm if I showed it to you?
Yes.
And
What is the question, counsel?
What is the question?
Asking Agent McGinnis, agent to identify the firearm, Your Honor.
Well, that's already been done. The objection is sustained.
Yep. Can we have a sidebar, Your Honor?
Been done a million times. Hey, what's up, Joe? How's it going,
Hey,
buddy?
Mick. I'm great. How you guys doing?
Hey, Joe. How are you,
Good.
brother?
I'm noticing
Andrew, good
you're
to see
not roaming the streets of New York. What happened?
We're on a 3-day break. I'm
Oh,
on
that's
vacation.
right.
Yeah,
That's
we're off
right.
from Monday, Tuesday, Wednesday on the Ghislaine Maxwell trial. So
Oh, nice.
I'm not back there till Thursday.
Good. This is a roving disaster of unfocused questioning, poorly constructed questioning by the state.
Lots of smirking.
Yeah. And Nick, the viewers are wondering, how do you think the jury's reacting to all of these objections?
Frankly, look, I don't think the objections are obnoxious at this point. Like they're pointing out they're not doing good work and they're winning on these objections a lot of times. So I think that's fine.
I mean, I think by the 15th time the jury sees a photograph of the Glock, objecting to putting them through more of that might be appreciated.
The objection is overruled.
Okay.
Could you show Exhibit 178 to the witness, please?
So he's not going to show the Glock now?
No, I guess he is.
No, he's showing it.
Showing the picture, but not the box this time.
Yeah.
Yes.
Is that Officer Potter's firearm?
It appears to be, yes.
I think
And if I showed you that same very firearm, in actuality, would you recognize it?
Yes.
Okay, I'm not showing you.
The same firearm that looks the same as every other police officer carries.
Yeah,
This
no
also
kidding.
is Officer Potter's
I've got
firearm?
my share
Yes.
of Glock 17s. I can't tell them apart.
Well, except there's the one you like and the one that mouths
Now,
off to you.
Do you recall taking the firearm and the Officer Potter's taser on May 6th of 2021?
Yes.
Okay. Describe the circumstances that prompted you to be in possession of both of those items.
Myself, Melissa Lauren, and one of our crime scene photographers, one of our special agents, we're going to take pictures of the items and weigh them.
And did you use a scale provided by the BCA Crime Lab?
Yes.
They use right scale.
And when you weighed the firearm, what was included in that weight?
Should have objected to the scale.
Ammunition.
17 rounds of live ammunition?
Correct.
And why did you weigh the firearm with ammo?
That would represent what was in the firearm the day of the incident.
And did you, you weighed both items, correct?
Correct.
Did you document the weights of those items?
Yes.
Okay, what were the results?
The firearm weighed approximately 2.11 pounds. The taser weighed approximately 0.94 pounds.
So the Glock with the ammo weighed about over twice as much as the taser.
The objection is overruled. I'll let you answer.
Yes.
Thank you. Now, I'd like to discuss for a moment some other differences beyond weight between the Glock and the taser. Could you please put up simultaneously exhibits 224 and 178?
You know, I would actually object to this line of questioning. This guy's not an expert on tasers and Glocks. They haven't qualified him as a weapons expert. They have a weapons expert who trains on these things. Why are they having him do
Was
that?
identifying differences between these two weapons something that you did in the course of your investigation?
Yes.
Didn't we already
And
go
can
through
you
this?
identify some
Yeah, I
of the
think we
differences
did.
for the jury at this time?
Yes.
Okay, please.
The objection is overruled. You may answer.
The taser
Oh
is
my
yellow. The
gosh.
firearm is black. The taser has
Oh my
a
gosh.
stocky body to it compared to the Glock handgun. The grip of the taser
I
is
guess
shorter
the picture isn't worth 1,000 words in
and
this
wider
courtroom.
than the Glock.
Let's pause on that. How much shorter
He's
is
just
is the
listing all the
handle on
difference
the
that a 10-year-old would
taser?
I don't know the exact number,
That's
but when you're
pointless.
holding the taser,
Why
you can't get all your fingers on it.
Why don't they have a picture of the Glock and the taser
Pinky
together,
finger?
Correct.
right next to each other in the
What
same
about the
frame?
texture of the grip?
The Glock handgun is textured a majority of the way around it, including the back. The Taser 7 has some light texturing on the sides, but not on the back.
Is there a difference in feng
The
shui?
Glock
between
trigger
the
is
two?
curved. The Taser trigger is flat with some serrations cut into it. The Taser has an external, I guess, on and off switch or safety. The Glock does not.
What does the Glock have in terms of a safety mechanism?
Technically, it has an internal
It
safety.
would be easier to ask what are
and
the
then
similarities between the
It's
two.
not really a safety,
None?
but the button
Cool.
on the trigger, it would need to
Let's
be
move on.
pushed in along with the trigger to be set off.
And so, and then previously you've already shown the jury in the demonstration, the lasers and the LED lights?
Correct.
Okay. Is there any lasers or LED lights on the
Hope they
firearm?
ask if this
There
guy's
is
ever
not.
had to deploy a taser or a firearm in the field.
And you've already testified as to the differences between the holsters, correct?
Yes.
And the hands, which are used to unholster the weapons.
Correct.
Okay.
I'll let the answer stand.
Thank you.
Do you want to move on, Counsel?
Yep. I now would like to show you another object.
It's a banana. How is the banana and the Glock
Time.
different?
Permission to approach the witness with Exhibit 180.
It's a box of chocolates because I'm in love with his
Mr.
beard.
McGinnis, I'm showing you an item marked for identification as Exhibit 381.
He really does have a very fine
I
beard.
do.
And what is this?
A Taser 7.
And do you know the origin of this Taser 7?
I believe it belongs to the BCA.
How is it different from the Taser that we've seen today?
It's newer. That's about it. Unused.
What about with regard to the probes?
I believe there are training probes in there.
So these are not live probes that are functional?
To my knowledge, yes.
And what about the battery based on your experience with this?
It is not a live battery or is not charged.
Why is there any
So besides
black
the
on a
probes
taser?
and the battery, is this item identical to Officer Potter's Taser?
I believe so, yes.
Your Honor, at this time, the state offers Exhibit 381 as a demonstrative exhibit.
No objection for as a demonstrative exhibit only.
Okay. Yes, 381 will be a court exhibit. It will not be admitted into evidence because it's demonstrative only.
Now, Agent McGinnis, we went through some of the differences between the firearm and the taser pretty quickly. Would you agree that a person can experience some of these differences better when holding the weapons in their hands?
Yes.
The objection is overruled. I'll let the answer stand.
Okay. I got at this time permission to publish exhibits 381 and exhibit 199, utilizing the services of a deputy by inviting jurors to place their hands on each exhibit here in court.
Counsel, sidebar, please.
Seriously, like this guy is leading the witness
Yes.
consistently and constantly. He's offering opinion testimony that he has not been qualified. He may be qualified for. They haven't laid the foundation
They
for
shouldn't.
any of this.
No.
Again, he's observing the same things that differences that any lay observer would observe, and therefore the pictures speak for themselves. If you want to get him as an expert on the differences between a Glock and a taser, qualify him. That's it.
What are your thoughts about allowing the jury to hold each of them so that they can feel the distinction between them?
I think they may get to, and well, I don't know if they'll get to in the evidence room if they'll get to hold a Glock, but maybe.
No, they just said the taser's not going back. They're certainly not going to let a Glock go back, I wouldn't think, if they're not letting an inoperable taser go back.
It might make jury deliberations go way faster.
Yeah.
Give the foreman the Glock.
I mean,
All right, that's it. We're out of here.
But of course, the proper comparison is how different do they feel when you're fighting with a suspect you're trying to arrest on a gun warrant?
Right.
While your partners are half in the vehicle and they're trying to take off.
That's part of the reason why this is frustrating, because one of the people in the chat said this guy's a weapons trainer. Okay, great. He's a weapons trainer. Has he ever deployed this taser in the field versus a Glock? Like, has he actually felt it in a stress situation? Maybe he has. Qualify him.
I don't
He tased the man just to watch him writhe.
I can't imagine that in that type of scenario there, you're thinking about the weight of the gun.
No.
If you're not noticing the color, you're not noticing the weight.
That's like when I read a cell phone review and it's like, this is a 0.7 pound cell phone versus a 1.1 pound cell phone. It's like, I really don't care unless I've been sitting at a pool reading with my hand over my head for the past 2 hours. Then I notice the slight difference in weight. But yeah, when you're fighting with someone in a situation where your fellow officers might be killed, you're going to pick up the thing, and 2 pounds versus 1 pound isn't going to matter.
You're not even gonna notice.
I mean, you can always tell the difference when you're handling them at your leisure with no threat to anybody.
Well, yes.
I mean,
Maybe they need to have the live, have the
Might make
taser
'em live.
charged
Give
and
everyone
live
a live
rounds
one.
in the Glock and see.
well, the electricity in the live battery would make it a bit heavier, right?
Yes.
The
more electrons.
This guy in the chat brings up
They're
a good
heavier.
question. He says, don't worry. He says, the defendant is a woman and probably has smaller hands that fit better on the taser than the current witness. Very possible. I mean, if Kim Potter is 5'2", 5'3",
The
5'4",
objection is sustained. I think if there was an objection, members of the jury, you're going to be able to see the taser and the handgun when you're in deliberations. It won't have a battery in it, so it won't be functional.
You won't have a live battery, correct?
Oh, they will have a Glock and the taser back in the jury room, apparently.
Say Glock?
I have no further questions for this witness.
He said both, the taser and the handgun.
Counsel.
They won't be functional.
I wouldn't want to be in a room full of jurors with a Glock.
I'm really curious about this cross.
Good afternoon, Agent McGinnis.
Good afternoon, sir.
This TASER 7 is a new version of the TASER. Am I right about that?
Yes.
It just came out
Yes.
in the spring of 2021,
Somewhere in that area.
or it was just purchased by Brooklyn Center in March.
That's what
This year.
I was told. Yes.
In fact, the only person who had a TASER 7 was, at the time, Officer Potter.
Wow.
Yep.
In that department.
Correct.
Are you asking me, sir?
I'm asking you, yeah.
I have to take your word for it. I'm not sure how many they had rolled out at that time.
All the other officers had more yellow on their tasers in their belt.
The TASER 7, or the tasers in general, have a handle that is similar to a gun, correct? There are differences, of course, but it's designed so you hold it in your hand, right?
Correct.
It's designed so that you pull a trigger like a gun, right?
They both have triggers, yes.
And it's designed so you aim at somebody, right?
Yes.
And while this TASER 7 is yellow in color, the top is black, is that not?
Yes, there is black on the top.
And the handle itself is black, right?
Yes, sir.
Inexplicably black.
And you know from your investigation that this TASER was working all the way through the 10 shifts that Officer Potter had it. Is that correct?
Yes.
In fact, on that day in May, you tested the battery power of the TASER, did you not?
Yes.
You found that the battery was 78% charge, isn't that correct?
Correct.
Well enough to fire the TASER, of course.
Yes.
Right. And it was a brand new gun, right?
TASER.
Right, yeah, TASER. It was a brand new TASER.
Yes. Nice. I like that.
So it'd be
Subtle.
fair to assume that would be in working order, a brand new gun. Is that correct?
TASER.
Did it again.
A TASER, sorry.
Yes.
There is a confusion here between the TASER and the gun. So you would assume that a TASER that was fully charged or charged at 78% worked throughout the 10 shifts, correct?
Depending on what it started at, yes.
But you have no evidence whatsoever that this TASER wasn't operable, do you?
Correct.
And we have Officer Potter sometimes doing the test, the charge test, or whatever it's called. What's it called again?
The spark test.
The spark test, okay. But she did it 6 out of 10 times, right?
Yes.
And it worked, right?
Yes.
Do you have a percentage of the officers in Brooklyn Center who skipped that spark test?
I do not.
Good question. Why don't you?
Yes.
Waiting on that question.
You also tried to find or did find an answer to the question of whether she had deployed her TASER since she was assigned that TASER. Did you not?
Yes.
And you found out that she had not deployed it whatsoever. Is that correct?
Yes.
Did she have training after receiving the new TASER? That's my question.
Yep. And so far, it's an item she's never actually used. Not in the field.
Yeah.
Maybe not even in training.
So the last spark
Right.
test was on the 9th throughout the 11th. Is that right?
Yes, sir.
You have no evidence between those 2 days that somehow, some way that TASER was no longer functioning. Is that correct?
No, sir.
And you also took Officer Potter in for a blood sample. Is that right?
Yes.
And she willingly went to I believe it was North Memorial. Is that right?
Yes, she did consent to the blood draw.
She consented to the blood sample, right?
Yes, sir.
And you know the results of that sample.
Yes, sir.
There was nothing in her blood.
Correct.
No alcohol, no marijuana, nothing.
No, sir.
All the screens were taken. Is that correct?
To my knowledge, yes.
Same here.
May I pause for a second?
Yes.
I agree with you. It's an important question to find out whether she ever had any training with the new TASER.
She may have, and if she has, they won't ask the question.
Well, it
Yeah.
can't
If
be
she
much.
hasn't, they may.
I mean, how
And
much
they
training
may.
could she have had?
Yeah.
She only had it
She's
2
the
weeks.
only one who ever had it.
During your
she got
investigation, did you ever inquire of the TASER manufacturer why the TASER couldn't be shaped in a different fashion to avoid any confusion? Did you ever do that?
Objections, go into it.
The objection is overruled. You may answer if you know.
Could you repeat that
Did
question,
you ever
sir?
inquire of the TASER manufacturer why it has built a unit like this when they could easily have shaped it differently?
I did not, and I do not know why.
Thank you.
Amy, go ahead and redirect.
Their crosses are
Agent
really
McGinnis,
Yeah.
you've testified about the Brooklyn Center function test policy. Does that policy permit an officer to not put their hands on that taser if they think it's working?
Excuse me. I don't understand the question. Do you want to rephrase that?
Sure. The Brooklyn Center function test policy requires that an officer test it every day, correct?
Leading.
Before each shift, yes.
Was there any exception in that policy?
No.
The policy's not in evidence.
Okay. I had previously stated that it lacked foundation. I don't know if you've established with this witness that he's aware of Brooklyn Center policy.
Right.
Respect.
Oh,
You have not entered the policy into
policy.
evidence. You've not offered it. You have not asked if they're familiar with the policy. You have not asked them to recite the policy.
Are you
You've not
kidding me?
asked-
He's scrambling for the policy on his
policy.
desk.
I have to say every attorney's
I mean,
worst nightmare.
this is key
The
to his
scrambling
questioning.
moment
Right. Well,
where
and
you
he's,
realize you forgot something.
yeah. Yeah, but I mean, he's had everything else on the in picture
About your
form.
damn checklist, buddy. Should have
You're
put
going
that
to
on
ask
the
this
checklist.
guy about the policy. You better have that thing on your desk. What are you
Yes.
doing?
What
Mom,
exactly-
can I go out to my car?
The dog ate it.
They should object that this is beyond the
McGinnis, over
scope
the
of
course of
cross.
your investigation, did you review the Brooklyn Center
We didn't ask about
conductive
this on
energy
cross.
device
Objection.
policy?
Mm-mm.
It's not. He didn't ask about the policy on cross in this way. Like, what are you doing?
He's introducing new evidence on redirect.
Yeah, that's what he's
Yes.
trying to do.
I mean, that's
what he's
rather
trying to
outside.
do, yeah.
Man, I'll allow it.
Guys, if like whatever the judge rules here, if you want to understand how to properly do defense attorney work, Paul Eng and Earl Grey are doing a phenomenal job.
And how not to prosecute? I mean, all these ducks need to be in a row. You don't just scramble around like this. You know what questions you're going to ask and what needs to be in evidence.
He had the checklist going. I mean, it should have been included.
Maybe he
Enter
needed those-
policy into evidence.
Maybe he needed those little Kraus boxes that he could just check.
Check the box. Check yes or no.
Check. Check. But I mean, they are all over they're not letting them. And it's important because these are not fact witnesses that are sympathetic in any way. These are nameless, faceless people at the BCA. They can be
Yeah.
replaced by any other investigator any other day. They have no connection to this case. They have no connection to the facts. They have no connection to the victim or the defendant at all. So these are the people you grill with objection. You don't let them get away with nonsense. You object to everything. You can't really bully or badger a police. Like, how do you bully a police officer in uniform on stand? How do you bully someone whose job it is to investigate murder on the stand? They do this all the time.
Right.
You don't let up on people like this. There's no reason to. The jury's not sympathetic towards these people
Yeah.
in any particular way.
And they've been bullied on the stand before, and they remember the last time.
Yeah. So you
So-
just
Yes.
go ahead and handle these things according to the rules and according to the law. Don't let the state get away with it.
It's havoc.
Havoc. Your Honor, this guy hasn't read a policy maybe in his entire life, for all I know. They haven't asked the question. They should have asked the question. They chose not to, Your Honor.
It's not like they can't bring in a BCPD, employee has expertise on the policy.
In theory,
the TASER trainer is
In theory-
listed in their witness list.
even if it gets rejected, they could bring in another cop who will testify about policy.
Yeah, they still have 48 people on the witness list.
Overruled.
Oh, wow.
Counsel, do you want to re-ask that question?
Agent McGinnis, we were just discussing Brooklyn Center, the TASER policy, correct? Specifically the function test policy.
Correct.
And you testified on direct examination that it was required prior to every shift, correct?
Correct.
By the officer. The officer has to put it in their hands and conduct the function test.
It doesn't say that, but yes.
Okay. The policy does say, it's quote, members carrying the TASER device should perform a spark test on the unit prior to every shift.
Correct.
There is no exception.
No.
Thank you. Agent McGinnis, are you familiar with the model prior to the TASER 7, the TASER X26P?
I believe there's one in between there.
What model is that?
Or it's at the same time, the X26P, then the X2.
X2. Are you familiar with the basic layout of those particular versions of tasers?
Yes.
Do those have a similar external safety switch as what we saw in the X7?
Objection
The
irrelevant.
objection is overruled. You may answer.
Yes.
No further questions. Thank you.
Are you familiar with the custom and practices of individual officers within the Brooklyn Center Police Department?
I am not.
Great. That's great.
Okay, you may step down.
Thank you.
All right, members of the jury. Oh, wait.
Lacey, I say you do that tomorrow.
You can go ahead.
That is-
No, I'm going to excuse the jury first. Could you sit down? I'm sorry. All right, members of the jury, we're going to take our afternoon break, 20 minutes.
The amount of frustration there for Paul Lang, right? He just testified to what she should have done. He's not even familiar with the customs and practices of the department. None of that testimony should have come in. He didn't have foundation. He didn't magically get foundation. They objected properly to foundation the whole time. I think that question was an FU to the judge a little bit, personally.
Oh, yeah.
but-
Yeah.
100%.
We don't know what they argued behind their little headphones, but I would say, objection, Your Honor, they have not laid foundation for this. He has no idea.
Okay, please be seated. Yes, you may step down. And I think, Mr. Larson.
That answer, nobody
Okay,
is.
counsel. Let's take a break.
Jeez.
Oh my.
So I can properly welcome them and introduce them to the stream. We've been waiting for a little bit of a break. We have Amazon Prime and Amazon Secundus, Carrie and Lacey from Beard and Harris down in Tyler, Texas. They are with the law firm of Beard and Harris, which is Ty Beard, who has been on the show.
Yeah.
These two have both been on the show before as well. So thank you guys for joining us.
Thank you for having us.
Thank you.
So hold on a second. That office he has there with all those desks and chairs, they're actually used by real people and not there just for clients to walk in and be impressed.
Yes.
Exactly. Yeah.
Wow.
And then, of course, we also have to welcome back to the show Mr. Joe Neerman, Good Logic on YouTube. Everybody's in the description. You guys can find more of Carrie and Lacey over on the Beard and Harris Law YouTube page, where they're doing more, if I'm not mistaken, correct me if I'm wrong, but you're doing more sort of straight-laced, straightforward informational views about different aspects of law that are kind of within the practice area of Beard and Harris. Is that correct?
That's correct.
Okay, good. I asked that as a leading question, but
Yes, you were objection leading. We are also embarking on some what we're going to call law mom chats that we're going to be working on here over the next couple of weeks for Lacey and I, just to kind of discuss relevant things that we've seen in the news or that's happening around town here with different aspects of the legal practice, and then what it's like to try to coordinate that with being single moms. So we're gonna embark on that here soon.
there you go. That'll be awesome. I look very much forward to it. You guys are great. So And
Thank you, Nick.
and being
Thanks, Nick.
Texan, y'all are firearms experts already. So by birth. So
Lacey is.
I think the last time I was on your show, Nick, I think I had my 9mm with me.
Yeah, I was.
Which
I was
it was on
worried.
the table.
Enjoyed, others did not.
I was worried about demonetization is all. Because you're like, look, I got this gat. What up?
Yes, and I sat and said, "Oh my gosh, I've never shot a gun." So there you go.
Have you since shot a gun?
No, sir.
Oh my goodness, Lacey, what are you doing? Drag her to the range.
I had to take a little break from the range from when I was pregnant and then having my daughter, but I actually have been looking to get my daughter some of those headphones, noise canceling headphones, because I haven't been skeet shooting in a long time and I'm ready to get back out there, but she goes everywhere with me. So
yeah, you got to do that. You got to put the plugs in and the headphones over the top for the kids. I think that's a good practice. And then you got to drag Carrie out there and make her fire a bunch of rounds. Put Ty's picture up or whatever.
No, I think. Oh, I probably shouldn't say this on air, but it'd probably be my ex-husband's picture up there.
Oh, you should say that on air. That's fine.
And just so your audience knows, since the last time we were on your show, which was over almost 3 years ago, Lacey and I have taken court appointments for misdemeanor cases here in Smith County. So we've been doing some criminal defense work here as well.
Yeah, Ty was telling me that you guys are getting more into the criminal aspects of things, and that's great. I think that's fantastic. It's a good way to get in courtroom experience against an unfair opponent, right? Like in civil cases, you're on even ground, limited only by the amount of resources that your client has, versus in criminal cases, you can never match the state's authority. You can never match their resources.
Their ability. I mean, their ability to call experts. You in the court appointed world, you have to get permission from the judge, even to have experts. And it's a little bit more complicated than, say, just a private criminal defense attorney. So it's a lot more challenging to try to help people have a voice.
And yeah, definitely. And also welcome to the stream, of course, Good Logic, Joe. Now you get a proper introduction. Joe has been covering in person the Ghislaine Maxwell trial up in New York. He's been at the courthouse every day, but they're on a break. So he gets to join us here, which is awesome.
Thank you for having me.
Yeah. Thank you. Of course. You like have
I'm making it like I just met you like 10 minutes.
You have like a revolving door policy. You can just come in and out whenever you want.
I seriously sleep in Nick's basement. No.
Look, you can pop into this stream like a bullet and Dante right anytime you need to.
Oh my.
That was rude.
Yeah.
Why would you say that, Joe?
That was wow. Wow. Okay. All right. That's the second most offensive thing I've heard on a stream in the last 24 hours.
Oh my goodness. So
full 24 hours? That's actually kind of impressive.
I don't know if I won't even reference.
What was the first most offensive thing?
Yeah, I was wondering if that question was going to come.
Were you on? It was when you were on Adam and Sitch.
No. I popped on Don the Plebes channel late last night.
Okay.
And they were talking about the Rittenhouse case. And while they were talking about it, so they were talking about the evidence fairy who came and dropped off evidence. And somebody made reference to, like, it's basically as if, you imagine you're a monkey walks up and brings in the evidence and and then just disappears into the jungle with the other animals or something to that effect. And in the context of where they were focusing on the individual who, supposedly dropped that evidence off, all of us were just like,
oh, okay.
You didn't mean. You meant like in a jungle in the forest,
not in the urban jungle of Kenosha. You're saying
yes. And I disavow any statements made on this stream, and I'm leaving right now. So yeah,
very uncouth.
It was very not my statement. I didn't make the statement. I was just And Nathan DeBruin was on the stream also, so I was trying to protect him. He's been subpoenaed to appear in Zeminski trial.
He was subpoenaed back at the time. Actually, he was subpoenaed at the time he offered his or he did his interview with Binger prior to Kyle's trial, which is why that's actually why I think what Binger did was more improper. And if I was Zeminski's attorney, based on what DeBruin said, the fact that DeBruin said that he could not identify Zeminski, Binger showed him a picture, and then a few minutes later asked him if he could go ahead and change his statement to identify Zeminski. I mean, that is grounds for potential mistrial right there.
Well, I wanted to ask you. So I'm actually supposed to have him on my stream tonight. I invited him onto my stream tonight.
DeBruin?
DeBruin, yeah, photo chat. And my question is, I told him I want to review his testimony on the stand in Rittenhouse with him and get like his feedback as to what he was thinking while all this was happening. And my question for you is, should I watch it on something like Law and Crime, or should I air us viewing it, the actual testimony?
I would go with the Law and Crime.
It's better, right? Than having us chuckling in the background and like reacting like oh, like
yeah,
like.
I just think that's noise that's added, and it's like meta, which I don't like the meta thing. Like I'm watching myself or whatever. It's kind of weird. So I would just do the original feed personally.
Okay.
Like everybody on Earth should watch the testimony from my show in general. But when you're reviewing it with him, I would do it through the less filtered lens.
Yeah, that way I get a better feel for what he was really thinking rather than reacting to us reacting to him.
Yeah.
So
unless you specifically want his reaction to us, I mean, then of course.
See, I'm sort of torn about that, but then I'm worried that maybe something was said, that might be taken the wrong way along the way, and that's what I was like. That was really my main concern, less about the noise and more about like I don't know what I didn't go through it to see like if anyone said anything that they'd be uncomfortable me playing in front of him. I don't know. It was a little bit. I was very torn. I was thinking about it right before I came on here. So seeing as how we branched toward this conversation, I figured you're the king of running streams. So you are my guru, and this was
Stream
a new question.
king.
The shorter version was the king of
it already is.
The king of grift. What was that, Lacey? Sorry.
I was saying, don't make your head any bigger than it already is.
Look, it's impossible.
If his head gets bigger, his nose adjusts.
I just plugged one of those pumps in. I'm just sitting here stepping on it all day, like those bike tire pumps, constantly watching myself on stream. Oh my goodness. No, I think, by the way, chat, if you want to see Nathan DeBruin tonight, he's a great guest, great witness. Seems like one of the more genuine dudes you'd run across is how he comes across. I don't know if he is. He just seems that way.
He either is or he fakes it better than anyone else out there.
Better than you can. He is. If he's not Nathan DeBruin, he's verbal from The Usual Suspects, right? Like this is Kaiser Sose. And
Yes,
you have to
yes.
you have to ask how many Turkish murdered families he's avenged in his life. But no, he comes across great. Check out Joe at Good Logic on YouTube. I've got his channel in the description. You stream at 9 p.m. Central Time, 10 p.m. Eastern.
Correct.
And Nathan DeBruin will be on tonight for that. So make sure to check that out. If you like Photo Chad, Nate, I have to make, look, it's Christmas time and my wife spent all our money, but I will be making a donation. I committed to donating $2,700, which is what the stream brought in gross the other day, to Photo Chat, and will be making that donation. Make no mistake. The commitment is public and the commitment will be fulfilled, but it is Christmas time and my wife spent all her money on gifts. So I was like, oh, okay. I have to probably make that in about,
You're waiting for the 21st to roll in. And then
once,
when the 21st rolls in, that's when we all get paid.
Once YouTube drops the money on me, then I will drop the money back on Photo Chad. He deserves every penny. What happened to him is atrocious. He testified honestly and openly in court and was suspended from his job because of it. That's disgusting. That should never happen.
That's awful.
Yeah.
Yep. That should never happen.
No.
He wasn't even accused of like testifying inappropriately or anything like that.
Right. I watched that.
Yeah.
I watched his testimony.
So whatever number is on his Give, Send, Go, add 2,700 to it because it will be added as soon as I can reasonably do it. But the YouTube's payment processing delay just has, well, a delay. So that's how it goes. So, but
he'll get it before Christmas. So
yes, absolutely. And he deserves it. I hope he turns that into pursuing his dream of having a photography business and of doing it full time. And he gets out under the thumb of whatever brand he's stuck under right now. So, so Andrew, what's your synopsis of today? Is it completely useless or only mostly useless?
Well, I mean, at least they're getting to the actual equipment, the taser and stuff. I'm not sure I understand the relevance of much of it. I mean, it's not like she pulled out the taser and it didn't work.
Right.
She didn't know how to operate it. She hadn't function checked it. And I mean, she clearly believed she had a taser in her gun and clearly did not. So I'm not sure.
This would be way more relevant if she had pulled the taser, it failed to discharge, so she holstered the taser or dropped it and then pulled her sidearm as an alternative. Or if she pulled it and it failed some sort of initial test or it didn't light up or whatever, that would matter with the spark test. That would matter with a battery that hadn't been inspected. All of that would have made sense. With the fact that she doesn't seem to have pulled the taser at all at any point, or even thought about the taser specifically, or thought about the sidearm in that same respect, that she just grabbed the gun and pulled it, tells me that the taser is relatively irrelevant outside of the very limited scope of questioning around the similarities and differences between the two things. And if you get someone in there to testify, well, this doesn't feel the same. It's lighter. It has a shorter hand grip. It's got almost like a 2-finger trigger that's larger. It's different color. Sure, that testimony is welcome.
All that, even if you get to all that and you say, well, she should have known it was not the taser, right? It feels sufficiently different. It looks sufficiently different. She should have known that it was not the taser. It was the Glock in her hand. That's still only negligence.
I agree.
That's not recklessness.
I agree.
Because recklessness requires intentionally ignoring a known risk. And she didn't know the risk.
At least gross negligence is an element of one of the claims. So it's at least relevant to showing the negligence aspect. I agree. It doesn't go far enough to show the recklessness. And I think we have the negligence anyway. Look, if you want to draw a taser and you draw a gun, per se negligence. There's no question there that you were negligent in that moment. The question is, does it rise to culpability? And in Minnesota, that requires recklessness. So then we need to get to the element of recklessness. But at least it's an element on point, as opposed to the overwhelming majority of testimony about this subsequent
car
accident.
Well, which they did bring up. She hadn't had that taser for very long. Correct?
2 weeks.
Was it 2 weeks? 2 to 3 weeks? Have they gotten into whether or not she had training with the new taser? Did she fire the new taser at all?
They did not ask that. If I'm simping for the defense here, I would say the defense is waiting for the actual expert who is the use of force trainer for the police, who's going to testify about the training of Kim Potter specifically. If I think that's what's going to happen.
I bet she's had none.
I think
because
she hasn't
either.
If she had some, they would have had this witness check the training logs, just like they checked her work log, and he would have come in and testified about it.
And my guess is the defense wants to bombshell that on the expert witness. While he is the focus, while her training is in focus, say, she's never had training with this model taser, has she? And then on redirect, they're going to come out and be like, well, it's similar to the other one. And then they're going to come in and say, but it's a different model, isn't it? Yes, no further questions.
Is there a different training program for this new model? I guarantee you there is, because the company that sells the taser sells the training program. So,
right. Yeah. So that's what if I'm guessing why they didn't drop the hammer here, it's because they're just waiting for when it is the peak pertinence. Because again, this defense has not been slouching during this trial. They've been active and attentive. They know what's going on. They're prepared on all this stuff. The only thing I think they may have missed is the speed of that video. And again, it's probably because from the looks of it, they did not get a slowed down version of the video. They got the normal speed. So I hope they review my email and either get back and say, we're aware of it. We raised it and it was overruled, or we're aware of it. We might be raising it in the event of, you know, things going south or whatever. But
and they just seem like they're just better prepared overall.
Yeah. Shockingly,
You know, I mean,
the state with 6 attorneys seems less prepared than the defense with 3.
Yeah, I mean, the state seems to be scrambling quite a bit, especially that one guy.
I know earlier a Johnny Cochran joke was made, and it made me think, Carrie, about the conversation we had not too long ago about when the state gets overly confident and think that they have it in the bag and they don't prepare. This is what happens. You start scrambling around, realizing you never admitted something into evidence.
I mean, let's face it, a lot of times with the prosecution, it's pretty much a cakewalk, right? I mean, the defendant's pretty obviously guilty, and the defense counsel maybe is inexperienced, and it's just not that hard to get the conviction.
Right.
Mrs. C says the state already introduced into evidence Kim Potter's signature on TASER 7 training dated March 26. So she may have been trained on this specific thing.
I think that was the day that they said that they gave it to her.
The day it was issued to her. Yeah, but I mean, how much time was their training? Was this, and did the training occur in a high stress, high pressure situation?
Was it
or was it perfunctory? Was it, hey, here's the charging end, and here's the handle, and off you go, just like your other one?
Was it a typical? Was it a typical annual 3-hour training that you do, or was this a 30-minute overview?
Right. Was this where you actually were firing this at another person, where you're in your officer training, you're firing it at each other just to see what it feels like and how it handles? Or was this just, here's a certificate, you did an online course for 15 minutes, here's your certificate, and you
because earlier in the trial, the prosecution was making big statements or getting testimony from people about, well, you do scenario-based training, right? Stress-based training, and you do jumping jacks and stuff like that to get your blood going to test these things under stress-like conditions. She may not have done any of that with this. Right.
Well, and you can do all the jumping jacks you want, but unless and until you have someone who is hopped up on adrenaline or drugs or is coming after you in an aggressive manner, you don't know how you're going to respond.
Right. Well, and the other interesting aspect of this is one of the things he said, she's the only officer in Brooklyn Center who had this taser. So did she get individualized training on this taser? Did everybody undergo this taser training program? Or was it, as Andrew said, was it perfunctory? Was it this basic thing? Here's the overview. New taser looks kind of like the old taser. You know how these things work.
Make sure you sign up for the next quarterly class, right?
Yes.
The in-depth thing.
Or you got to have or you got to do training by a date certain. So just make sure you get it in before this date.
Because nobody does in-depth training one officer at a time. It's right.
No,
it would be too
don't.
inefficient.
Yeah. Well, actually, I would say the state does things inefficiently, but not usually this.
Right.
Not usually stuff like that.
Well, and too, Nick, when McGinnis was testifying, he kept glaring at somebody to his right. Like his eyes would cut over when the state was asking him questions. And I don't know who he was glaring at over on his right side, because it was obvious the jury was on his left side, because he kept addressing the jury like you would do when you are adequately prepared to testify in front of a jury. You look at the jury when you're testifying. But for some reason, I just kept noticing him. It was a glare. There was something in his eyes, and I don't know who it was. Was it Officer Potter? Was it her defense team? Because they weren't even talking, but he just kept, I don't know. There was just something that wasn't.
So the interesting thing to me is that the actual Brooklyn Center PD officers all seem extremely sympathetic to Kim Potter. The BCA officers do not in any way seem sympathetic to her.
Okay, maybe that's what I was observing, because of course I don't know that
the female BCA officer though seemed a little sympathetic or
hey,
very
Nick,
uneasy.
I've got to go, Nick. Thank you so much for letting me be on here and make some comments and talk.
Of course, and I'll
nice meeting you.
Nice to meet you, Andrew.
I'll make sure you guys have the invite for future streams. If you have time, feel free to pop on whenever.
Okay, thank you so much, Nick.
See ya.
Bye.
Oh my. We are back to the jury coming in. And with that, I'm going to step away for just a minute again because I made this stupid mistake while drinking to break the seal. So I'll be back in just a minute.
All right, please be seated. The state may call its next witness.
This time the state calls Eric Copeland.
Okay, good afternoon. Please stand and back up your witness chair. Raise your right hand. Do you swear under penalty of perjury that you will truthfully testify?
I do.
Please have a seat. Remove your mask. And then state your full name and spell it.
My name is Eric Keppen, and last name is spelled Koeppen.
Okay, a couple of things to keep in mind when you're testifying. Yes or no answers because of the court reporter. No or nodding your head.
Sounds good. Thank you.
If there's an objection, stop talking immediately and don't answer unless I tell you to. If you don't understand a question, let the lawyer know. And two people can't be talking at the same time. So wait until the question's finished before you answer.
Okay.
All right. Counsel?
Mr. Keppen, could you state your occupation for the record?
I work as a forensic scientist in the biology section of the BCA laboratory.
Oh, more BCA
How long have you
people.
been
Great.
employed in the biology section of the BCA?
I've been employed there since February 2017.
About 4.5 years now?
That is correct.
And what are your current duties in the biology section?
As a forensic scientist, we examine items of evidence, process that item of evidence for any sort of biological fluid, do examinations, take notes on that item, make any collections. We'll then process that item for DNA profiling, make any comparisons to known samples provided in that case, write up a report, do reviews on other scientists' work, and then testify in court as needed.
What is your educational background to do such things?
In 2013, I graduated from Hamlin University with a Bachelor's of Science in Biology. I also graduated with a Forensic Science Certificate from Hamlin in 2013 as well.
Have you received any specialized training since your employment at the BCA?
Yes. Upon my employment at the BCA, we are placed into a training program. This takes about a year. You are expected to observe other scientists in the laboratory, attend classroom lectures, perform written and oral examinations, and then complete a competency test at the end of our training.
And are you evaluated after that competency test? Are you evaluated regularly to verify your proficiency in conducting your work?
Yes, we take what are called proficiency tests. Those are twice a year. They're used to kind of examine our workflow and make sure that we get the correct results of the test.
And you've testified as an expert before, correct?
That is correct.
Now, before we talk about the DNA testing you performed in this case, would you please explain to the jury quickly what DNA is?
So DNA is a chemical or a molecule that's found within the cells. It kind of is the makeup of who we are as a person. Gives you your hair color, your eye color,
DNA
things
is
of
a
that nature.
molecule.
It's highly unique to certain individuals besides twins.
Is it possible to identify, besides twins, the DNA of a particular person?
Yes, it is.
When you identify the DNA of a particular person, do you have a name for that result?
We would call that a match.
A match. Oh, I'm sorry, but just the actual it's called DNA profile. Is that of an individual? Is that what that's called?
At the end of our testing, we do obtain, yes, a DNA profile.
Profile of a specific individual, for example.
Do we need
Of
DNA
an individual,
evidence
or generally
on this?
after the end of our testing,
You
it's an
shouldn't.
unknown
Does
profile.
Tim Potter have a
until we
twin
make our
sister?
comparisons.
Now, is it possible then to distinguish the DNA profile of one person from the DNA profile of another person?
That is correct.
Now, is it possible to compare the DNA of a known donor with the DNA found in an unknown sample containing DNA to determine whether that person's DNA matches the DNA profile found in the sample?
Yes, sir.
Is that sort of the middle of the road, what you do on a daily basis, sir?
Yes, I could agree with that.
What is a single source DNA profile?
So a single source profile is one that we determine to be coming from a single individual. We determine this since you get half of your DNA from your mother and half of your DNA from your father. At most, at the locations that we're testing, we'd expect 2 types. If there are more than 2 types at the location, then we can call that a mixture of DNA.
So when you do have 2 single source DNA profiles, given the unique nature of them, are you able to determine if those 2 profiles are a match or not a match?
Yes.
Okay. What other types of DNA results do you expect to find besides a single source result?
Like I stated earlier, we do end up getting mixtures of DNA where there's multiple contributors to that sample. There are often times where we get samples that we're unable to make any sort of
wish this were the nighttime show so I
identification
could
to.
make some really good jokes about this.
Is testing a sample of blood recovered from a scene something you do on a regular basis?
Yes, it is.
Are you typically able to recover DNA from swabbing the blood sample?
Yes.
And when you test blood samples, are they typically single source profiles?
Yes.
But they could be mixtures.
That is correct.
Seriously, what is the relevance?
And you'll be able to determine that whether it's a single source or a mixture based on the DNA profile you receive, correct?
Correct. During our interpretation is when we'd be making that determination if it's a single source or a mixture.
Okay, I just want to move now on to the testing that you perform at the BCA. Based on your training and experience, do you have an opinion as to whether or not the DNA testing methods used at the BCA are generally accepted in the scientific community?
Yes, they are.
Does the BCA have a particular protocol or methodology that is used when performing DNA testing?
Yes.
Okay. And
It's like this guy gets his
Can you
haircut.
explain briefly the DNA
failed out of the
testing
Binger haircut
policy?
school.
Yes.
or process, I should
Process,
say.
sure.
Finally, someone with a
DNA
worse haircut than
profiling
me.
is done generally into 4 steps. The first step is extraction. We'll get a sample subjected to certain chemicals to help break up the cellular material and release that DNA into a solution. We'll then
Release that
purify
DNA.
that solution to get that extract of DNA, so
no.
that purified DNA. This will bring us to
Welcome
our
back
next
to
step, which is quantitation.
Nothing.
We'll see how much DNA is present within that extract and see if it's suitable to move forward in the profiling process. If it does meet a certain threshold, it moves forward to the next step, which is called amplification. We'll be targeting certain
Sometimes
areas
refer to
of that
these as
DNA
levels
for
of dating.
identification purposes, and we'll be focusing on those areas,
Why are we
making
here?
millions upon millions of
What is
copies
the purpose
of that area
of
or those
having
areas.
this guy on the stand?
And then once that is completed,
You know,
the
I
final
want to
step
know
is
the
interpretation.
makeups of the
We'll,
specific plastics
where
that go into the
basically that
manufacture of
sample
the
is
clock.
injected into our instrumentation. A profile is then generated. We'll then basically visualize that profile and make our interpretations.
Okay. Now I have a couple of questions about items which are collected and inventoried at the BCA. When an item is collected, are they typically given both a BCA lab item number and a description of what the item actually is?
Yes, when items are submitted, they're giving a BCA lab item number, as well as a description that's provided by the agency.
So if you take an item out of the vault, you're going to have an opportunity to see both the item's lab number and then that description of the item.
Generally, the description is not written on the item itself. However, it is in our laboratory information management system, so I'll be able to see that on the computer, yes.
Okay. And those numbers and descriptions typically would be provided by the scientist or agent who collected or inventoried those items, correct?
That is correct.
All right. And those numbers and descriptions, do you utilize those when you issue a report about your findings?
Yes,
Okay. And that's done obviously to aid anyone reading it.
that is correct.
Now I want to move on to the testing you did in
On
this
cross,
case.
you were bullied
Did you
in high
generate a
school,
report
weren't you?
document in the testing that you performed?
Yes, I did.
Were certain items of
This
evidence
is
in
hard.
connection with this investigation inventoried at the lab?
Yes.
Did that include a blood stain or sample from a known individual named Dante Wright?
Yes,
And that blood stain was identified as BCA item 30?
that is correct.
Were there also a series of swabs taken from blood droplets located in this case?
Yes, sir.
And of the items, would you agree that based on the item number and the description provided to you, they are the following? Item 22, that's blood from the vehicle's driver's seat. Item 25, blood from the vehicle's front passenger dashboard. Item 26, blood from a vehicle's passenger side headliner. And then item 27, blood from the vehicle's rear driver's seat.
Yes.
All right. So you obtained those swabs to conduct testing on them.
That is correct.
And did the swab, the known swab of Dante Wright, give you a full DNA profile?
Yes, it did.
And were you able to obtain separate DNA profiles from those 4 swabs of blood?
Yes.
Okay. And of those 4 DNA profiles, am I correct that each one was a single source DNA profile?
Yes, you are correct.
All right. Did you compare the DNA profile from each blood sample to the DNA profile of Dante Wright?
Yes, I did.
Okay. And are you prepared here to report the result for each?
Yes.
All right. Let's start
They're
with the
all
first one,
Dante
item
Wright.
22.
Spoiler.
Blood from the driver's seat.
Oh, the
Great.
girlfriend.
What was the
Girlfriend will
result
be in the
of your
passenger
testing?
seat.
So blood from the driver's seat, item 22, was a single source male DNA profile. That male profile matched Mr. Wright's, and that profile would not be expected to occur
Hey,
more
both
than
these guys
once
are
among
from
unrelated
Slytherin House.
individuals in the world population.
It'd be really cool if there was like other
Next,
person's
item
blood there.
25. That's the blood from a vehicle,
Deep
the
in the
vehicle's
mystery.
front passenger dashboard. What was your result there?
So from the front vehicle dashboard, the passenger side,
I want to see
it was
Greg
a
gets
single
this.
source profile.
Was there any blood on the
It was an
scale?
unidentified female profile. It did not match Mr. Wright's, and there were no further comparisons on that profile.
Were you provided any DNA samples from any other known individuals?
No, I was not.
So you had no DNA profile from an individual named Delana Albrecht Payton?
No, I was not.
Okay. Item 26, blood found on the front, the passenger side headliner.
Item 26 was also a single source male DNA profile. That single source profile matched Mr. Wright's. And once again, that profile is not expected to occur more than once among unrelated individuals in the world population.
That is crazy though.
And then
right?
item 27,
He
blood
shot
from
this
a
way and
vehicle's
blood squirts
rear
up
driver's
onto
seat.
the
Item
roof of
27
the
was a
car.
single source male DNA profile, matched Mr. Wright's, would not be expected to occur more than once among unrelated individuals in the world population.
Okay. I'm now going to show you a series of photographs already admitted as evidence in this case. Could you please show Exhibit 191? I'm showing you Exhibit 191. Do you see a sticker on there which states 22?
Yes, I do.
Okay. Could you go to the next Exhibit 192? And you'd agree that there's a sticker on the front seat there that says 22?
Yes.
All right. And based on your training and experience, to what would you conclude that this 22 corresponds?
This number 22 corresponds to item 22, which I previously reported.
Okay. And that report was that it was a match of Dante Wright's DNA profile?
That is correct.
Okay. Next, please show Exhibit 193. And then move on to Exhibit 194. Would you agree that Exhibit 194 shows an item 25?
Yes, sir.
Based on your training experience, would you assume that this corresponds to the item number 25 that you tested?
Yes.
And this was the DNA profile that was a match for an unidentified female?
It was an unidentified female profile.
Okay. Next, Exhibit 195. And then, can you see the item 26 on the roof of that vehicle, sir?
Yes, I can.
Okay, and then go to Exhibit 196. And based on your training experience, do you believe that this was the lab item number you tested that was number 26?
Yes.
And am I right that the result of your testing showed that blood was also a match for Dante Wright's DNA profile?
That is correct.
Okay. And then finally, please show Exhibit 197. And then move to 198. I'm showing you an item If you could zoom in on that, Mr. Miller. I'm showing you Exhibit 198. Would you agree if we close up there that it shows item number 27?
Yes.
And based on your training experience, are you to believe that that is a match for the, that is the blood sample that you tested as lab item number 27?
Yes.
And that too was a match for Dante Wright's DNA profile?
That is correct.
All right. You can take that down. So to summarize your findings, of those 4 blood items, 3 of them were a match for Dante Wright, and that 4th one on the passenger dashboard was
very
was
important to
from a
identify that Dante
unknown
Wright
female
lost blood
DNA
in this
profile.
incident.
That is correct.
Okay. No further questions.
You may step down.
That's it.
Thank goodness they didn't belabor the waste of
Yes.
time that was that witness. Again, the whole question, and hopefully every time they do that, the jury is thinking, yeah, why did we do
call
that?
its next witness.
This time the state calls Travis Milan.
Why did we sit through that just now?
Good afternoon. Please step forward. Stand behind the witness chair.
Is this another BCA scientist, I hope?
Swear under penalty of perjury.
What is their strategy here? Seriously.
I do.
Please have a seat. Remove your masks, please, and then state your full name and spell it.
Travis Melland, Melland.
All right. There's a court reporter taking down everything that is being said in the courtroom. Yes or no, and start shaking your head, right? No, or wait until the question's finished before you answer, so 2 people are not speaking at the same time. If an objection is made, stop talking. Don't answer it unless I tell you to, okay? And if you don't understand a question, of course, let the lawyer know, all right? Counsel?
Mr. Mellon, could you please state your occupation for the record?
I'm a forensic
Or
scientist
larceny.
for the Bureau of Criminal Apprehension
How long have you worked for the Bureau of Criminal Apprehension Crime Lab?
for approximately 6 years now.
Could you discuss your current duties with the crime lab?
Sure, my current duties are to compare ammunition components found at a scene to each other or to a firearm if it was recovered.
And how many years have you been doing that sort of work in the firearms lab?
I've been with the firearms lab for about 5 years now.
Okay.
So we have the ballistic guy to confirm
Could you
the bullet
discuss your
from Kinbot
education and
killed him,
training to conduct such comparative analysis?
as
Yes,
opposed
first
to all
I
the other bullets.
earned my Bachelor of Science in Forensic Biochemistry back in 2014. Once hired at the BCA in the Firearms Laboratory, we go through a year-long extensive training module in which we learn about the different makes and models of firearms, their history, how they operate, and then also with ammunition components and how they interact with those different firearms. And then we go through and hundreds of different ammunition components and gain that cognitive ability.
So he gets 10,000
what
more
constitutes
times
an
in training like
identification
Tim Potter
versus
got in our
elimination from a firearm.
Yep.
Okay. And as part of the BCA's yearly evaluation process, are you evaluated regularly every year to verify your proficiency in this sort of work?
Yes, we go through annual proficiency tests in the firearms lab.
And have you testified in court as an expert before?
Yes, I have.
Okay. I'd like to talk generally about the background underlying firearms examinations. When an individual loads a semi-automatic firearm with ammunition, do you have a name for that type of ammunition, for a live round of ammunition?
Oh, yeah, a live round would be considered a cartridge.
Okay. What are the components? What are the component parts of a cartridge?
So a cartridge is comprised of a projectile, commonly a bullet, with a propellant or the gunpowder inside, and an ignition source, which would be the primer end of the cartridge, all housed within a metal casing.
Okay. And the casing being the fourth, right?
Casing is the fourth part, correct.
All right. Now, when the gun fires, what happens to the component parts of the cartridge?
So when a semi-automatic firearm is discharged, the primer portion, which contains the ignition source of the cartridge, is struck by the firing pin. It creates an impression on that
In a Glock, a
cartridge
striker.
case, and then creates an exponential amount of gas and pressure This allows the bullet to then travel down the barrel and out the muzzle of the firearm, picking up rifling characteristics from that firearm, as well as pressing against the breech face or the rear end of the firearm as well, before it is then ejected from the firearm.
Okay. When you conduct a firearms comparison, what items or components are you typically examining and comparing as part of your work?
Typically, we are looking at cartridge cases and bullets.
Okay. How does the examination of discharged cartridge casings and fired bullets enable you to draw conclusions about the use of specific firearms?
So when a firearm is discharged and those components interact with that firearm, it picks up markings from that firearm that we can use and look at under a comparative microscope to make an identification or elimination or some conclusion.
Okay. Can you explain to the jury what class characteristics and individual characteristics are?
Yes. So class characteristics are those that are predetermined by the manufacturer. For example, these include the caliber or the size of ammunition that the firearm takes, the size of the rifling or the grooves cut inside the barrel, the directionality of the rifling of the barrel, along with the firing pin shape, the shape of the aperture in which the firing pin goes through on the firearm, and as well as the finishing of the breech face that the cartridge case will press up against as well. If any one of these class characteristics differ, we can eliminate those components from being fired from that particular firearm. Individual characteristics are incidental to the manufacturing process and are more of the microscopic detail that are created through the manufacturing process, but also through the use, abuse, wear, and tear of the firearm itself.
Okay. And in terms of individual characteristics then, does comparing these enable you to draw conclusions about when a specific firearm was used?
Correct. We use individual characteristics for our conclusions.
Okay. I want to zero in just on discharged cartridge casings. I think you've talked about where specific markings are left on these cartridges when they're fired and ejected. Because of those marks left on the discharged cartridge casings, that's how you can compare and identify when they're ejected from a particular firearm?
That's correct.
Okay. And you can compare two discharged cartridge casings, which are fired from different guns?
Yes, we could.
Okay. And that's using your sort of comparison microscope?
That's correct.
Okay. Now, let's say you only recover a single discharged cartridge casing and a single firearm. Are you able to somehow evaluate whether the discharged cartridge casing was fired from the gun?
Yes, we are.
Okay. Could you explain to the jury how that's
thrown
done?
at him?
So we evaluate the firearm for those class characteristics. If all the class characteristics are in line with what we're seeing on our evidence cartridge case, then we can move on to test firing that firearm. And then we collect cartridge cases that we know of came from that firearm, as well as bullets during this process. Then we can physically compare the cartridge case known from the firearm to the evidence cartridge case collected at the scene.
Okay, so you do eventually do sort of an apples and apples comparison against discharged cartridge casings. It's just that you know the test fired one came from a particular firearm. Is that all right?
That is correct.
All right.
They are trying
Now, when you
to
conduct your work on a
as
given
possible.
case, does your work go through a verification process?
Yes, it does.
Okay. And that requires another forensic scientist to examine your work and to evaluate your conclusions?
Correct. Another examiner trained and also signed off in the same discipline will verify our conclusions.
Okay, so that's discharged cartridge casings. Now let's talk about fired bullets. If you only have a fired bullet and a particular firearm, do you have to go through a comparable test firing and recover a test fired bullet to
Can we go back
conduct
to
a
the
comparison?
taser?
Yes, similar to cartridge cases, we'll evaluate for class characteristics, and then if those are in alignment, then we go through and test fire, and we'll compare those known bullets from the firearm to the bullets if they were collected at the scene.
So sure. And this question might be just 1 + 1 is 2, but if you have a single bullet, single firearm, and a single discharged cartridge casing, you can compare all three items together, correct?
What is the objective
We
here?
only compare to a firearm. There's no
Prove
way
that
for
Kim
us to
Potter's
compare
gun is the
a
one that
particular
killed
bullet from
Dante
coming
Wright.
from a particular cartridge case.
You need the firearm for the test fired bullet and the DCC, right?
That is correct.
Okay, I want to move on to the testing you did in this case. Did you receive a request to examine evidence?
Yes, it was.
And was that request made by Agent Mike Fell?
Yes, it was.
All right. With regard to the work performed here, were you asked to retrieve certain items of evidence which had been collected and inventoried at the BCA?
Yes.
Okay. Of the items, am I correct that you obtained 3 items?
That's correct.
All right. And when you obtained those items, they were assigned a lab number?
That is correct.
Right. And you generate a report based on your work in this case, correct?
And that is correct.
All right. And those 3 items that you got were item 7, that was a single 9mm discharge cartridge casing that was collected by Melissa Lauren. Item 13, which is a Glock 7 9mm firearm, which was item number 13. And then item 31, a projectile or fired bullet, item 31. Is that correct?
That does sound correct.
Okay. So the purposes of your testimony today, we can agree that you got a single discharge cartridge case and a single bullet and then the firearm.
That's correct.
And you were asked to compare them.
That's correct.
Okay. Now, before we talk about your results, I just want to make sure that we're talking about the same items. Permission to approach the witness, Your Honor.
Stab me in the face.
Mr. Mellon, I'm showing you exhibits 199, 202, and 200. I'll show them to you each. I'm showing you exhibit 200. Would you agree that is the discharge cartridge casing?
Yes, it is.
Exhibit 202. What?
Oh, God. Lord, help us.
Oh, he said the wrong Glock. He said Glock 7, apparently.
Item
Well, they're easy to
201.
confuse.
You recognize this as the fired bullet?
Yes,
I didn't even catch it because I'm losing my patience.
And then exhibit 199. Exhibit criminal item number 13. You recognize this as the firearm?
Yes, I do.
Do you recognize this is my heart-shaped box?
Who in the jury is actually still paying attention to this?
I think the jury
Were you able to
literally
compare
died
the discharge
earlier.
cartridge casing to the firearm?
Yes, I was.
Did you follow the same method and procedure that you discussed a few minutes ago?
Yes, I did.
And what was your result?
I concluded that the fired cartridge case and the bullet covering the scene were fired by the firearm in this.
Oh, whoa!
I'm sorry,
Now
that
we
might have
know
went beyond
Kim
my
Potter
question. I
killed
just
him.
asked about the discharge
Now
cartridge
we
casing.
know.
Did you also make a similar conclusion about the fired bullet?
My apologies. Yes, I did.
Okay. So in the end, your findings are that that firearm fired the DCC and fired the fired bullet in this case.
That's correct.
Now,
You have
I
further
have a couple
questions
additional
beyond
questions
that?
about the firearm. Did you conduct an examination of the firearm as to its functionality?
Yes, I did.
We need to know if
And
it
did you
works.
confirm that it was
Pretty sure
functional?
we know it works.
Yes, I did.
As part of your examination, were you able to examine an aspect of the firearm called trigger pull?
Yes, I was.
What is trigger pull?
In short, the trigger pull is the force necessary to pull the trigger or fire the gun.
All right. There's a phrase some laymen use, dropping the hammer. Have you heard of this phrase?
Yeah, more commonly with revolvers. but
Okay.
yes,
Well, that's what we're talking about. How much weight does it take to fire the gun?
that's correct.
Can you tell? Can you measure how that is? How much weight that takes?
Yes, we can.
Could you describe for the jury how
5.5
that's done?
pounds.
So we have
We
a,
have a
Like a
fat
police
guy
gun.
stuck on
static
it.
weight apparatus in which
Police gun, they might have
we
put a
can
heavier
hang,
trigger in it.
known weights and poundages and hang that off of the trigger of a firearm.
I guess they'll compare it to the
We
trigger weight of the
measure to a
taser.
point
Another
of which
factor, right?
we can
that
lift
you
up
should have known was
on the
different.
firearm and not have the trigger get depressed consistently, and then also keep adding weight until we're consistently getting the trigger to depress, and we create a range of what that trigger pull would be.
It's
Now, is there a
amazing.
typical range for force required to pull the
If you
the
add
trigger
weight
of
to people,
any-
you can
any
get them to
firearm?
depress
Typical
too.
range?
Yes, in my experience, anywhere between 3 and 9 pounds is fairly average.
Okay, so in this case, were you able to measure the trigger pull of Exhibit 199?
Yes, I was.
Right. And what were the results there?
5.5.
It was approximately 5.5 to 6
Whoa!
I know my
So
Glock,
within the normal
baby.
range.
That is correct.
Okay, no further questions, Chairman.
Mr.
You didn't
Cross?
testify as to what the trigger pull of the taser was?
Thank you, Your Honor.
All of that, you didn't ask what the taser's trigger. Probably because it's a 5.5 pound taser
Yeah,
trigger.
I bet.
Does anybody know what the Taser 7 trigger pull weight is? Maybe look it up.
Okay, members of the jury, we're going to we're going to stop early today. Okay,
Oh,
We're gonna
really?
start up at
Whoa,
9 o'clock.
an hour early.
Right. I want to assure you that we're still on schedule.
The judge is ready for nap time.
All
following
right.
all of
So
that
have a
testimony.
great evening.
Jeez, like I got a 4 o'clock meet. I gotta get out of here.
Trying to find the Taser trigger pull weight.
I feel like she should be holding a riding crop when she gives those instructions to the witnesses. You know, if somebody objects, stop talking immediately. Quack.
No kidding. Uh, 4.2 pounds.
For the Taser 7?
Okay, counsel,
Yep.
please be seated.
Indistinguishable,
Yep.
especially under stress.
All right. The state filed 2 motions. I'm wondering whether the defense wishes to put in a written motion or just do oral argument on them. Okay. All right. Let's start up at 9 o'clock. I'll review the state's motions tonight, and maybe we can discuss them tomorrow. Okay? Is there anything else we need to put on the record?
On the record, no, but the state does wish to be heard in chambers with regard to an issue.
Right now?
Yes, Your Honor.
Okay. Come on back.
What's doubly great about that is the prior 2 models had lighter trigger pulls, 2 and 3 pounds, respectively. So the prior 2 Taser models had 2 and 3 pound triggers. This one is a 4.2 pound trigger. And he testified that 3 to 9 pounds was a standard sort of range.
Interesting.
For trigger pull.
Yeah, even a Glock trigger, it can be anywhere between 4.5 to 6.5 pounds. I mean, there's quite a bit of variance. 5.5 is really just the average. So it would be a Taser trigger of 4-something pounds on the trigger would be indistinguishable really from a Glock.
There's no way any human could have known.
No.
If you're not looking at the Glock, there's no way. You went to in that stress, in that situation, once you pull out the wrong weapon, he was done.
No, and the decision, she'd already made the decision. She was going to press the trigger. She thought it was a taser, right?
Right.
So when she's shouting taser, 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 the next absolute thing that's going to happen is she's going to depress that trigger.
Yeah, there's no way you're pulling. Well, I'm going to only pull 4 pounds because this is a Taser. I don't want to pull a full 5.5 on a Glock.
and she knows the other cops are going to let him go, right? They're going to jump back. So if she doesn't tase him, he's careening out of there in the car. So she has to press the trigger. So she does and gets the bang instead of the zap.
How many times did she fire?
Once.
Oh, wow.
1 pull. They did get testimony that they're trained to fire at least twice.
Wow.
Yeah.
But it's just, this is.
I mean, 9mm, like all handguns, they suck in terms of stopping power. A lot of people get shot, and the first thing they say is, I can't believe you shot me. I mean, this guy took a decisive hit, so he was done for with that 1 round, but that's unusual. That's not the routine.
Yeah. And the travel of this bullet was serendipitous, right? Through both lungs and the heart. He happened to be turned in a way that it would actually go through all of those major critical organs. I mean, you lose 1 lung and you need medical care very quickly. You lose 2 lungs and you need medical care immediately or you're dead. I mean, you have to have some sort of assistance right away. You lose 2 lungs and a heart. You're not only unable to breathe, all the blood that you could have had is pumping out through holes in the organ that would pump them.
Right.
So,
I mean, if all he had was a lung injury, penetrating lung injury, you get a chest seal on it. you'll probably make it. I mean, once they get you to the ER, you're almost guaranteed to survive. Survival rate for handgun victims is about 80%, so it's pretty high. For people who are shot once, is 80%. If you're shot a bunch of times, then it goes down to 0 pretty quick. Both lungs, that's trickier. But if you get chest seals on both of them, you might make it to the ER. But the heart injury is just there's no coming back from that.
Yeah, I mean, if you bust through the heart, you're gonna be bleeding out in a matter of a minute to a minute and a half tops.
Yep.
It's sitting there trying to pump blood, and instead of pumping it into your body and up towards your brain, it's pumping it out into your chest cavity. So, but yet again, a completely almost pointless day for the state. This stuff could have been, you combine this with the first day of testimony and you have a day and a half, and then the defense could have a day, and you could be done with this trial.
When are they expecting to wrap?
Before Christmas Eve is the nebulous result.
The judge keeps saying we're on schedule. I'm like, whose schedule?
What?
Seriously, what is the schedule? Because they're
What is
dragging
the?
this
It's not
out.
like there's anything to be adduced. Like, I don't even understand.
By Christmas is 2 more weeks. I mean, it's all of this week, and
And
most
a
of
good
next
chunk of
week.
next week. Yeah.
We
No,
know.
Go ahead.
We knew what happened the day she killed him. Like, this is not like. It's not like in Colorado Rittenhouse, you have all these confusing different events and lead ups and stuff like that. I mean, here, I guess you have the lead up also, but the whole thing was like, what, 10, 15 minutes before he was killed? It's like, I don't understand why there's so much. This whole thing, prosecution and defense should have been done in 3 days.
I think the defense is looking to be done basically immediately. I think they've got probably an hour to 2 hours of questioning of Kim Potter at most. Probably less. I don't think they want to spend a ton of time questioning her. They want to get to her training and experience, maybe her experience with those other officers, her experience as a field training officer, maybe as a subordinate to Major Johnson or whatever. And then they want to get right into the facts and talk about how she was scared for her fellow officers that they just established that she really cares about a whole lot. And then they want to, get done with it. They don't need to belabor the point. I mean, I think cross on her is going to be significantly longer. They'll keep her up there for a couple hours. But other than that, I mean, the defense will bring a use of force expert, but the state's already called the other witnesses there. Other than we had 2 BCA witnesses today with a combined, I think, 2 hours of testimony for the sole purpose of determining that Kim Potter shot this guy and that his blood is the blood in the car.
Yeah.
I really do not get the state's strategy here because they're just dragging this out. And I feel like it's making the jury even more and more disinterested. I know it's making me disinterested. I was fighting yawns at the end.
Yeah, I've been fighting yawns most of the day.
Yeah. I mean, but maybe it's not a legal strategy. Maybe it's just a political strategy. For political reasons, they feel compelled to bring the prosecution despite a lack of legal merit. And this is what happens when you are arguing a manslaughter case without legal merit.
Yeah, I mean, what else do you do? That's the other question is, what else would they be doing during this time? They have to bring whatever case that they can for their ethical obligation. And the case that they can bring is one that is a bog standard prosecution for a whodunit murder case. But we have to show that she did it. We have to prove that we know she did it, as if she's denying that. And rather than focus on the events. And we saw a little bit of this in Rittenhouse too, where it's like, you're proving the death. We know that we know Rittenhouse's bullet killed these guys. No one thinks someone else shot Rosenbaum or Huber. But that is
this is what I don't really understand, and what I think is so aggravating, I think, to laypersons about our judicial system is like, we all seeing as that we all know the facts. I think it's pretty much indisputed that she meant to use her taser and had pulled out the wrong weapon and ended up killing him. So it's almost like, is that guilty? Is it not? When someone pulls out, there's a mistake of fact. Are you guilty? Do you go to prison for that or not? It's really that simple. And it shouldn't even really be that much of a jury decision. That feels like something that the law should just provide. Okay, when we know someone made mistake X, there's no disputing it. And that the result was, A. So now the question is, what are the legal ramifications of that? It's almost like you don't need a jury. It's like, what is that? Is that something you go to prison for, or is it something you don't go to prison for?
Like, I think you have a fact question on whether or not a mistake was made. I think you have a fact question on whether or not the mistake was reasonable and then reckless. So I can see a jury limited to these issues, but I mean, the question of did she shoot him? We know. Was there an injury? Yeah, sure, we know. The injury that is subsequent to the stop and the shoot is irrelevant to the question of whether or not she was justified in shooting him. And it is only prejudicial. It only serves for the jury to say, oh, she caused a whole bunch of damage here. But that him driving away and running into someone is not actually foreseeable in a particular culpability sort of standpoint.
Well, they've made suggestions that they do want to make that argument, right? That you don't shoot someone who's in position to control a vehicle, because then the vehicle could roll away and become a missile, and therefore any injuries or damage that results was foreseeable, and therefore creating that risk is reckless on her part. And the defense is argued back by saying, hey, was that car moving when she shot him? And the answer is no. But clearly he got it moving after he was shot. So,
yep.
But at the moment she made the decision to shoot him, was the car in gear? And it would appear the answer is no.
I think they were... I'm sorry, Nick. I was going to say, I've been thinking this whole time that if they were serious about trying to prove that the mistake she made was reckless and unreasonable, why don't they have a witness of another female police officer with kind of the same amount of experience as her talking about being in that type of situation if they've had to fire their taser? And can you tell the difference? And in that situation, is it kind of something, I guess, from your training, you know automatically which one you're grabbing? Can that type of mistake be reasonable in that situation?
That's a really interesting thing you just said, Lacey, which I wonder if the factors you mentioned should be under the law relevant, and whether they are relevant under the law. You specifically referenced another female and officer, and you also referenced the level of experience, as opposed to generic police officer. How would they react in that scenario? And I think that's an interesting question to sort of discuss philosophically. Should there be a distinction based on the intersectionality of the police officer as to whether or not there's reasonableness in the conduct? Because I would assume not. And I was surprised you mentioned it, which is what made me call attention to it and ask, like, should we be having different yardsticks? Do you guys think that's a more appropriate yardstick than just a standard police officer reasonableness? And if so, is that something the law generally recognizes as a legitimate distinction?
I think once tools come into it, it doesn't really matter. I mean, once you're using a taser or a gun, they basically work the same in everyone's hands. If we were talking some kind of hand-to-hand combat and you had a small female officer compared to a large male officer, I think then you get different outcomes because they each have different capabilities. But the taser doesn't work differently in a man's hand than in a woman's hand. So I wouldn't expect to see much variance there. And frankly, I don't think there's a real question on reasonableness. I think her action was per se unreasonable. But that only gets you to negligence. That doesn't get you to criminal culpability. For me, the question is, did she deliberately ignore a known risk of death or serious bodily injury? And I don't see that on these facts. I see negligence, but I don't see her. For example, if she had, contrary to training and policy, placed the taser and the gun right next to each other on their duty belt, knowing that created a risk of confusing the two items and then pulled the wrong one, then I would say, well, she knows doing that is creating a risk of pulling the wrong weapon, and therefore she ignored that risk, and that begins to look a lot like recklessness to me. But that's not what happened here. Whatever her brain was doing, she clearly believed she had a taser in her hand. She didn't know she was creating a deadly force risk, so she didn't ignore that risk.
That's actually interesting, because not only did she not do that, she took the least risky by training option, which is the non-dominant hand in a straight draw, because they said that cross draws often lead to misdraws. So for the conscious disregard of the risk, she did everything she possibly could to mitigate the risk. She has it on a non-dominant hand. She has it on a straight draw, so you're not using the same arm to draw the taser. She knows that that can produce an accidental draw and discharge. And so she has not created the risk. She has followed the training. We even have testimony from Officer Lucky, who used to use cross draw and has, even at the time of the incident, was using cross draw with his taser facing backwards. And he has since swapped to straight draw because it is a safer and more appropriate thing. So not only does she not seem conscious of the risk, but she seems to have consciously taken steps to eliminate the risk as much as possible. So I don't know how you get to the recklessness element. I don't know how you do it. And we're spending a lot of time trying to figure out everything other than that critical question.
Right. Unless, again, the recklessness was her choosing to use any weapon on somebody who was operating a motor vehicle.
Right. Right. Which, if they can actually get that, that would matter. We haven't really seen too much on that. We got a hint of it today.
But it's weird, right? Because that recklessness you'd think would only be the basis for culpability for the car crash.
Right, which would not be a manslaughter charge.
Right. Not for it's the bullet that killed him.
Right.
But if the reckless act is actually attached to him being able to operate the vehicle then in some impaired fashion, then it's the crash property damage, I guess. But
if the car is not in motion, I don't understand how her shooting him is responsibility for the car crash.
Right. And it appears it was not in motion. That's the testimony we have.
But I mean, at least it's a fact question. At least you can say this is a question of fact for the jury. Was the car in motion at the time she pulled the trigger? We can elicit testimony that says yes, no. We can put a video out there. You can break it down into whatever frame you want and say that he hadn't had time to put it into drive yet. You could sync up. I mean, I don't know that they're going to do this, but you could sync up the video from the dash cam and show when it goes from drive through reverse and into, or from park through reverse and into drive. You can actually measure that out. And
then
say,
to the extent the car was in gear, the offsetting argument there for the defense is, well, the two other cops are half in the vehicle.
Yep.
Right. If he's actually able to operate the vehicle in that moment, their lives are in danger. And this policy against shooting someone in a car because they might injure somebody down the road, that doesn't take precedence over officers getting killed now.
No. Yeah, I would think that changes everything. When you have these officers' lives in jeopardy, I really think that changes the whole balance of the equation here dramatically.
And that's why the state was trying to work so hard today with those BS slow down video and the still photographs to suggest that the officers were not, in fact, in the car. But I think it hardly matters because they're in the car until she shouts taser, taser, taser. And when she shouts taser, 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 she's committed to pulling that trigger. That has to be the next step. That's why you're shouting those words.
Yeah. And it's the question of what her perception is at the time. Is she supposed to know frame perfect when they leave the vehicle versus when she pulls the trigger? I mean, there's no way.
It's just what she reasonably perceives.
Right. There's no, she looks at her fellow officers in the vehicle. She says, taser, taser, taser. I've got to pull this trigger to herself on the second part. And then, whether they're out of the vehicle or not, she's waiting a reasonable amount of time for them to remove themselves from the body so that she can fire the taser. And it's really quick after that. She says, I'll tase you. She draws the gun somewhere in there. And then she says, taser, 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 pop. It's like a second and a half tops. It's very, very fast. So yeah, it's what a mess.
I mean, I'm sure there must be trained to pull the trigger on the taser the moment they see the other officers release the suspect, right? You don't want to wait longer than that. You don't want to go sooner than that because you don't want to shock your fellow officers.
Right.
But the moment they see the other officers release the suspect, you would press the trigger. That would be the indicator to discharge the weapon.
Yep. Okay. Eugene says, so exhibit 167777216 clearly shows the accused has 7 hands, was armed with 49 Glocks, shot 343 bullets into 2,401 innocent people who didn't do nothing. Conclusion, She's a witch. Yeah.
Can we
I
have a
think that's
composite
pretty-
video of that, please?
Yes. We were going to now composite all of the videos from all of the dash cams at different times and play them together at the same time. So please mind the timestamps on each of the different videos in the composite while you're watching. That would be very important for us. By the way, how subtle was that? That there was the 1 second delay between her body cam and Officer Johnson and the camera on Officer Johnson. So the composite video that they showed wasn't accurate. They didn't belabor it, but I'm curious if they're going to raise it on their closing argument and say, and by the way, they showed you evidence that was not even appropriately synced up, or if they're going to raise it in a motion. They can certainly raise a motion today to have an instruction to exclude that evidence, or they'd probably make a motion for a mistrial, but I think they'd make the motion to exclude the evidence in the alternative and expect that might be what they get, to say that composite video was garbage and was slowed down. It was off by a second.
Did you email them that it was off by a second?
No, they came up with that one.
Okay.
I just emailed them the slowed down aspect of it, and I might follow up after the stream just to make sure they got it. But that was that one was crazy. Like the whole idea that they would play slowed down video in the court and not represent it as slowed down is a mess. Caligula Love says, "Wow, Kim Potter shot Dante Wright in the car. This is absolutely revelatory." Blanton's Finest says, "I hunt moose, and that is the exact shot you want to make. Heart and 1/both lungs. It will drop 1,000-pound moose in place." Mike the Dad Crosby says, "Shocking. The state proved Dante died and that Potter's gun fired the bullet. String her up." Mike Doherty says, "Continued witnesses to keep showing blood." Yeah, I think that's part of it. And again, it's these couple ideas: cumulative evidence on the body, on the blood. But then the other thing is just show them so much evidence that they think there must be something wrong here because the state is showing me so many different things.
It can't be an acquittal, right? Not with all these days of evidence.
Yeah, it's just, they have so much against her. Something she did has to be wrong. I'm not quite sure what.
Where there's smoke, there's fire.
Mithrin Emmer says, "Only about 20% of the testimony today was relevant to the matter in controversy, and at least 50% of that testimony could have been stipulated to, since Officer Potter is not denying she pulled the trigger." Yeah, but they're not going to allow a stipulation.
Right.
I
People need to understand stipulation doesn't happen just because it makes sense. The parties have to agree to stipulate, and the state for whatever reason, they want to go through all of this.
Yeah. Virtual Loner says, "Did the officers spend as much time practicing the draw of their tasers as they do their gun?" No.
Well, they don't practice either. So,
oh yeah, they may not do draw and fire on their range time.
Is it normal for them to pull the gun and taser out when they unholster at the end of the night, or they just leave them all holstered? Is that what's normal? Because I'm wondering, they were talking about the different weights of the gun and the taser, and I was wondering whether this is something that she's regularly holding each of them in her hands on a daily basis.
She's supposed to spark test the taser every day, bigot. So if you would have listened, you would have known that she.
I walked in late, and I didn't understand what the point of this. You guys said that was highly significant. I didn't even really understand what's the point of whether or not the taser was functional. Why is that highly relevant?
Well, I think the taser has to come out to be charged. I think most of the cops I know, the gun would stay in the holster, but the taser has to come out to go in. But I don't know if you need to charge it once a month or whatever.
Well, if the taser's not charged and she says taser and she's supposed to know it's not charged, by not charging that, and by not charging her taser, she may have created an unreasonable risk. And then if she knows
a month later, they were testing it and it still had a 78% charge. So it's not like an iPhone where you got to charge it up every night or it's dead. It appears to hold the charge for a long time because it's not doing anything most of the time, right?
Right.
What was the spark test? Is it just making sure that the battery is fully charged?
There's some way
they're not actually regularly firing.
No, because those prongs come out from some sort of propellant. So there's something they can do where it basically arcs between the two prongs as they're in close proximity. I don't know the actual like physics of the test, but it's called a spark test or an arc test. So since the two prongs are sitting there next to each other, there's a very little amount of distance needed to make an actual link between them to show an electric charge. And so they must pull the thing out, get a zzz, and then that's good. But
some tasers also have what they call a press to stun functionality, where you don't need to shoot the probes. It just sparks contacts on the front, and you can press it into somebody's body. And if you're not pressing it against somebody and you do that function, you just get the sparks at the front. So the unit's energized and delivering juice, at least to the front of the unit.
Is that the F7 model, the 2X model, or the 431 model?
Yes, all of them. All of them.
Oh, wow.
All the models. So finishing up that chat about drawing each one. If you spend more time practicing drawing your gun, then it would be more automatic than drawing the taser. Whatever they spend more time drawing, I don't know, but they almost certainly spend much more time firing in range practice their gun than they do a taser. I mean, I think that's fair.
I think it's not a bad strategy of defense to really focus on this is all the state's fault. Because they could have bought tasers which held one of those phasers from Star Trek where you just sort of hold it like that instead of a trigger thing. There's a lot of, if you want to make sure that this mistake doesn't happen, well, get a taser that fires completely different, holds completely differently. Yeah. This is something which is
look like a lightsaber.
Yeah, I mean, I'm just saying I'm sure there's a lot of different ways you can form a taser, which is not going to look like a gun. And you can, it's easily carryable, easily transportable, can be holstered, but that when you pull it out, it basically in your hand feels nothing at all like a gun. In which case, as opposed to this thing, it's like, well, it feels nothing like a gun because this one weighs 4.5, this one weighs 2.7 pounds, and that one weighs 1.9 pounds. So obviously, anyone who holds them is going to know they're different. I mean, I'm just saying that the whole grip is complete. One is like this, and the other you're holding like that. That's two totally different things. No one ever make a mistake. You point it back at the state. This is the state's fault. They were cheap or they were incompetent in choosing this type of taser, and that's what is leading officers to invent and inevitably make a mistake. And it happened that it was Kim Potter who made the mistake. I would be finger pointing like anything.
I mean, I'm looking at the Taser website now. They have all kinds of promotional photos here, and every one of the promotional photos I see, the user is holding the Taser in their right hand, just like you would a pistol in your dominant hand.
That's why they're designed that way. I mean, they're designed to look like a pistol, to work like a pistol, and it's the reason that the pistol is designed the way it is. It's highly effective and very simple and intuitive, right? The pistol is an extension of your arm. If you hold your arm out, you know exactly where that bullet's going. It's going directly in line with your arm unless you do something weird. Same thing with the taser. And it's the reason the pistol grip has not changed in, I don't know, 200 years now? Longer? Since they had the little hand, what are they called? Arquebus or musket or whatever. The flintlock pistols. You have one? Yeah, of course you do.
Here we go.
Of course you have a flintlock. Yeah.
Is that has the powder goes on top? Do you have one of those where you light the powder, you light it like in the 17th century?
Is that a flintlock or is that a fuse lit pistol?
It's better.
It's got two.
He's got both.
Nice.
Wow. No, they're real. They're flintlocks. I wouldn't want to shoot them.
Alec.
They're way too old.
It looks really cool, Alec.
Hey, Nick, I'm about to have to get off. I got to get some stuff prepared for court. But I wanted to say thank y'all for letting me be on here. I've enjoyed the conversation and getting caught up on the case.
Great. Nice meeting you,
Lacey.
Nice
See you around. Peace. There's a reason that the Taser company designs it the same way. Because if you have like a flat grip for it and you have to press a button on top, it's awkward. It's different. It's not intuitive, right? Your hand naturally sits like this. It doesn't sit like this. The funny thing, and I think the really crafty thing that was crafty for lawyers, but might not matter to the jury at all unless they explain it really well. When he asked the guy, did you ask the Taser company why they designed it with that pistol, with the grip that's like a pistol? And he said, no, in your investigation about why this accidental discharge happened and whether or not the cop was recklessness or negligent. You didn't ask why they designed it that way, because the answer is TASER has a really good reason for doing that, and it's because they found it to be the most effective way. He should have had that answer. He should have just called and asked, or referenced the manual, or referenced, a speech, a TED talk that some TASER engineer gave somewhere. That information is out there, and he didn't do it. And I think that was, I don't know that they played enough on it or paid enough attention to it, but that is crafty lawyering in a legal sense. I don't know that it'll play out in the.
And I agree with you. And they're probably the reasons really to not have a taser like that is it's if you're holding it in your hand like that, it's much more difficult for a suspect to grab it away from you. It's sort of locked into your fingers. Your fingers can sort of grip into it the way they would in a pistol, as opposed to if you're holding it the way, those old style phasers. I'm not talking about the gun phasers, but the phasers on Star Trek where you could just sort of like, I know what you mean. that those are probably easier for a suspect to grab away from you and potentially turn a situation on its head. So that would probably be the most likely reason they have it like that. But seeing as how he didn't answer the question, I think that the doorway has been open for the defense to basically say, this is on the state. They should have gotten a different kind of phase, a different type of taser to avoid this type of confusion. Where a cop under a highly stressful situation is trying to save another officer's life, might end up grabbing for the wrong thing and not have a chance to realize it because it feels pretty much exactly the same.
Yeah, I mean, part of the argument has got to be, listen, we know that this is occasionally going to happen. Human beings are imperfect. The devices are similarly shaped. We try to take reasonable steps to prevent it from happening, but we know there's no guarantees it's not going to happen. It's in the, especially human beings are imperfect in a violent confrontation with a suspect they're trying to arrest, where other officers are at risk, other innocent people are at risk. Decisions are being made under high stress very rapidly. This is just, life isn't perfect and shit happens. And sometimes if we're going to equip our cops with tasers, sometimes this is going to happen. And the answer to that dilemma is under a public policy analysis is, you compensate the people injured or the survivors of the people injured. I mean, that's what negligence law is for.
Yes.
As opposed to criminal law. Yeah.
Right.
The question is not to clarify at least my position for the chat, and I assume the panelist position as well. The question is not, did she do a bad thing and is she responsible? The answer to both those questions is yes, she did a bad thing and she is responsible. But the question at criminal trial is she criminally liable for what she did? And here, I don't think so. I mean, I think she's civilly liable. She definitely made a mistake that caused the death of an individual. And if you or I did that, we would be civilly liable as well. But a mistake is often a mistake, not a mistake of law, like, oh, I didn't understand this was illegal, but a mistake of fact that leads to an accident is often a defense to criminal liability. It's not unusual for that to happen. It's not even unusual for things like that to not get charged out. And that's because for criminal prosecutions, in almost all charges, you need something called the mens rea. You have to have the criminal mindset or criminal intent, the intent to do a bad. And if you don't have an intent to do bad and a bad thing happens, then it should be civilly liable. You can always raise the question of whether or not that criminal intent is there. You can try and prove it, and that's what they should be trying to do here. But if it's not there, you're not criminally liable in this type of case. Only a few cases, strict liability on like statutory rape charge or something like that. But outside of that, you need criminal intent. Sorry, Joe.
And it's okay. I didn't want to cut you off. The philosophical basis for that is think about, why do we send people to prison? We send people to prison to keep the population safe, to punish them because they're trying to harm people. Those are the two primary, to rehabilitate them.
Right. They're intentional bad actors.
Yeah. None of those factors apply to a situation where a person makes a mistake like Kim Potter made. It's not like you're trying to teach her a lesson. Don't do this again. It's not like we want to try and say, that the victims or the victim's family is not going to feel a sense of satisfaction, like, oh, at least we got to put her away, because it's like, really, that's like petty. That's like a petty type of thing when you know that she had, if we come to believe, which I certainly do, I think most people do, that there was never a desire on her part to cause any kind of lasting harm to the victim. So that's why I think that it makes sense to say this is not where you're talking criminal liability, but civil liability.
No, I expect when she testifies, she'll say she was actually trying to save his life. Avoid him from being engaged in a high-speed chase by police.
Right.
Plenty of people die doing that.
Yep. That she was trying to save the life, protect the lives of him or everyone in the situation, her fellow officers,
the passenger, the other officers, everybody.
I know from my training and experience, the best way to deal with someone who is about to flee is to neutralize the flight as soon as possible, and resolve it. No, you're fine. Go ahead.
The difference between this and, let's say, an Alec Baldwin situation is because there's a difference between negligence and recklessness, where you have an opportunity to review the situation before you walk out there and engage in it. It's as opposed to what did you do in that instantaneous moment? How did you react in that instantaneous moment versus, the mistake that was made by Alex Baldwin was not in the flash of the second of when he pulled the trigger. The mistake that was made by him was pure recklessness in the moments leading up to when he actually pulled the trigger.
Well, he knew he was pointing a gun at someone.
Yes. That's the critical difference.
He knew he was pointing a gun, and he knew he had not checked to make sure there was no ammo in that gun.
Right.
That's the distinguishing feature here. She believed she was pointing a taser.
Right. I mean, that's how it goes from negligence to recklessness. And recklessness is something that should be culpable because you want to discourage people from being reckless.
Right.
You can't discourage people from being negligent.
Intentionally ignoring a known risk.
If Kim Potter had pulled out her gun to threaten Dante Wright and said, "Oh, I've got this gun, I'll shoot you," and accidentally discharged, that's reckless.
That's reckless.
If she had pulled out her gun and thought it was unloaded and said, I'll just threaten this guy with my unloaded firearm, and then pulled the trigger and it was actually loaded and a round went off, that's recklessness, because pointing a gun at someone creates the danger of deadly force being used. Pointing a taser does not. Pointing a taser has the potential to invoke or to become deadly under certain circumstances that you would have to show that she knew ahead of time. Like if she knew that the guy had a pacemaker, that the guy, was particularly susceptible to tasing. I don't know what that would even look like. That would be some issue where she knew and created the circumstance. None of that's present here. None of that's present in 99% of taser pulls. Right. Typically they're saying, I'm going to neutralize this incident in a less than lethal way, or most of them probably think in a non-lethal way, because that's the reality of the overwhelming discharge of tasers is non-lethal. Even if there's a potential for
the
death.
normal operation of a taser, it does not kill anybody. It's like they kill people like tires blow out on cars. Can it happen? Of course it can happen, but it's not the normal state of a tire. We don't expect that to happen when we operate our motor vehicle, and we don't expect a taser to kill someone when we tase someone with it.
Yep, exactly. Well, gentlemen, it's been a long day. Not as long as it could have been. I'm going to take the opportunity to read a bunch of super chats that I haven't gotten to. But I wanted to give you guys the opportunity to head out if you had other things to do, which I'm sure you guys do, but you're also welcome to stay. So I'll give you guys the last words before I jump into super chats.
I'll stay for the super chats just to see if anything interesting comes up.
Sure.
I'm going to encourage you all to sign up for Law of Self-Defense, because that man there, he knows his stuff, and he will help protect you from eventually facing what Kim Potter may be facing, or keep you best prepared to handle that type of situation. So make sure that you check out Law of Self-Defense. And I actually found recently, when I was looking through analysis, that like 20 to 30% of people who watch streams like this are not even subbed to the owner of the channel, which is astonishing to me. So if you haven't yet subbed up to Nick Rekieta, what the heck does he have to do? Right? What does he have to do? Sub up to the man, take care of him, because his product that he puts out there is something that the rest of us in the industry are desperately trying to emulate. So he's the master. And I'm out.
Buddy.
I'm good logic.
Take care, Joe.
Later, buddy.
Take care.
With that, guys, of course, all the panelists who appeared today are in the description, even if their appearance was brief. I believe, did I put Viva in? Oh, I didn't. Let me put Viva in. You can check all of them out now. I also added the Beard and Harris YouTube channel where Carrie and Lacey make appearances. Make sure to check everybody out. And thank you guys so much for watching. I'm going to jump right into these super chats. Here we go. Tampa guy says, Jesus wept. Are most trials so pedantic / repetitive? Not this bad.
No,
not this bad. I mean, they are slow and plodding, but usually the overwhelming majority of trials, neither side wants to be at trial. Like at the end of the day, the defense would have rather had this thing dismissed and the prosecution would have rather had it pled out. I mean, and that's why so many cases plea. They don't want to be at trial. They don't want to spend 2, 3, 4 weeks sitting there going over these facts that everybody knows happened. They don't want to do that. So no, usually they're much more focused and they're a little bit more hasty, I would say.
I mean, this kind of tedium is not normally the dominant characteristic of a trial. There's always little portions that are tedious. There's technical things that have to be taken care of, but normally you see even if it's just a gradual progress towards some endpoint, and we just most of this trial you don't see anything like that.
Vlad Dracul says, how do we get these prosecutors disbarred? You're not going to get them disbarred over this. I mean, you can go against the attorney general or their local district attorneys in an election and hope that they make better hiring decisions. But
it's almost impossible to get a lawyer disbarred. I mean, unless he starts messing with client money, that could get him disbarred. But
I think Avenatti is still barred. I mean,
could that be?
I think they're trying to, I mean, I think it's pending and inevitable, but I think at the moment he's still a barred attorney, if I'm not mistaken. I don't remember if they had resolved his thing. Let me check. Avenatti.
Let's see. He's been ineligible to practice in California since May 4th, 2020.
Okay, so
and then of course he was convicted of a bunch of charges in New York, but I think he was barred in California.
Yeah, let's see. Let's see. Is he? Yeah, he's been convicted, but it takes. I mean, disbarment is different than conviction. Let's see if we have it here on here. State bar proceeding in California. He's been on interim suspension after conviction since May 4th. So he's still actually technically barred, but he has a suspension on his license at the current point. And Michael Avenatti did the deed that you're talking about. I mean, he messed with client money. He tried to extort an opposing party, things like that. Very, very crazy stuff. It's really hard to get people disbarred. Long story short, it does happen, but it is hard. Mr. Tibbs says, Nick, in regards to Judge Chu, there's no statutory limits on her cuteness, but there is still some fish sauce in her tuna town. Stop it. Russell Hall says, how much soy can you pack into one courtroom? Always more. Justin P, thank you. Titan Tech 90 says, cause of death in this trial is boredom. I'm waiting for any relevant evidence or testimony. Are they hoping the jury just thinks they have a case? Hunter Congress says, I feel like if the prosecution could, they would disassemble the gun and car and talk about each individual part. We might actually see that with the gun, frankly, once they get the expert up there on training. Murderbit says, now I get why attorneys drink so much. Project Done Poorly says, this reminds me of South Park's Red Dragon episode. Do you see now? Do you see? President-elect Four Doors More Horse says, Prosecutor Coomer says, please reply to my request for feet pics. That was to the blonde witness earlier. GR People says, Nick, you should do a holiday whiskey show where you talk about your favorites, great gift ideas, or New Year's bar suggestions. Oh, wait, that's a good idea. Snuggle Struggle says, someone please tell the state prosecutor, dude, how running your morning spank session through your hair is not a good look. Gross. Broly Power Maximum says, while defendant literally pays for irrelevance. Groves Russell says, at 4K, ask Mindset about his anime waifu body pillow. James Ligon says, Governor Jesse Ventura appointed the mighty Judge Regina Chu. Christopher Shaver says, as a tech expert in a CP case, had to explain to a judge how to find CP on the internet. Ooh, very uncomfortable. Mandalore Wise says, so I can eat a single tortoise, but not multiple in Florida. Good to know. Deathwish says, this is for Andrew Bronca, my second favorite lob tuber. Nate Dog says, hello, Ricada Law and everyone. I'm from Wisconsin. I think y'all are amazing, and I'm learning a lot from you guys. Thanks for the videos. Hey, you're welcome. Jaded Custom says, I'll cross state lines and donate my copy. Crits Cake says, deep fake as Santa Claus for Binger. Nick. Barry Soituro says, allegedly. Jack Sparrow says, so you said if people show up at your office, you will hand them a book. If I drive to Castle Rock, do you have books? I would pay for it, but don't want to hop on the 470 for nothing.
Yeah, sorry. This time I'm too busy to be handing out books now. Maybe after the holidays, if you want to come by.
So if you want that free no shipping book, you got to wait till after Christmas.
It's so much easier just to order it so we can mail it to you. Trust me. Driving around.
Automata says Miranda asked Binger if he could appeal FFS. Yeah, well, I'll probably get to that tonight. Warren Heyman says, does the judge eat raw man noodles for lunch? Asking for a friend's. Great job to all. Nate Dogg says Binger is a male stripper now. You didn't hear he got fired from Wisconsin. That's not true.
No.
Chaos Schley says, are the prosecutors using this kind of questioning / witness calling to drag out the trial and make it as financially painful to defendants as possible? Yes.
That's probably a bonus. Yep.
Yeah. Arson NV says, forensic scientist Lauren is behaving like Bicep Boy while she's testifying. That's with the head doing this number.
Right.
Gonfall says that blood stain on the seat came from when I farted, had a shaving accident this morning. Our ball says the scale was for measuring his meal prep. He was a bodybuilder.
Like
Elisha. Yeah, he goes to Arby's or whatever and throws the roast beef on the scale. Make sure. I only want a quarter pound. Alicia Cromie says, Mark Richards gave a podcast interview on law and legitimacy that I highly recommend. During the interview, Richards talked about Nick texting him during the trial. I didn't text Mark Richards during the trial. Maybe he thought I did. That'd be interesting. Michael Milano says, maybe they'll stop just calling random witnesses because there are repercussions. Britt Cormeyer says, totally wrong, Rackets. We all know that scale is for baking. Bear in the Woods says Dante was only going back to the car to weigh his options. Tyler Wales says, I would love to see the defense ask if the $50 was recovered. Oh, that'd be a good question. He got $50 to go get a car wash and and gas, and we don't know that he ever made it. So was the $50 on him? Chris West says, but they don't regard the drugs. It'll be in the back of their minds. Gunner says 4 doors, less traffic stops. Neo Ritter says the movie SWAT is all due to a broken taillight. Also, on a serious note, please think about supporting the West Kentucky Tornado Relief Fund, WKY Relief, all one word there. That was crazy, man. You see those tornadoes just rip through the eastern half of the U.S. Very, very messy. Not applicable says cause of death. He fought through the police. Kay Vegdal says, I'm not sure, but Andrew may enjoy ice fishing on Ness Lake and dinner at O'Neill's. Well, he's welcome to. Have you ever done ice fishing?
It sounds horrible. I hate the cold.
There are 2 ways to do ice fishing, one of which is terrible and the other which is brilliant. So the first way is you're like out there on the ice, or you're in some like stupid tent standing on ice with a hole, and you're just sitting there and all bundled up like a moron.
That's what I had in mind.
Yep, that's awful. The other way is to have a very nice insulated ice house with satellite TV, a heater. You drill a hole a little bit down the ice, but not all the way, and then you put all the whiskey in that hole.
Okay.
It's beautiful, and then you have food. That's great.
That sounds
wonderful.
like fun.
You don't even care if you catch fish. You Are Wrong says, I feel like this will discourage cops from going for their taser and go straight for the gun. Yes. Yeah, they're already thinking that right now, regardless of whether or not she's even guilty. And if she's guilty, I would throw my taser in a lake. Why even carry it? Two Truth for Liberty says, don't ask any questions without knowing the answer. Question, trained to fire once for taser and twice for firearm. Use excessive force when only one shot is needed. Yeah, no, 2 shots in quick succession is probably not going to be excessive force. 2 shots in any reasonable amount of time. where you start to get unreasonable is like that motorized wheelchair shooting, where that 9th shot comes a significant amount of time after the 8th shot and after the person would be presumably incapacitated already. But
yeah, so usually it's either when it's obvious someone's already done and you keep shooting them, or if there's a pause in the action and then you start shooting again. The successive shots after the pause will get you.
Right. The question is always, as you would say, I think, at the time you're pulling the trigger, each pull, are you in danger at that moment? So pop, that's a quarter second or whatever. You're still in danger as that's like, you can't even process the fact that the danger might be neutralized by the time you're doing that second trigger pull. Whereas pop is significantly different. You have time to reassess if the person falls down, if they're still running at you, those types of things. But of course, it's all going to be fact specific in each situation. There's no bright line rule on this. There's just what is reasonable, and that changes. Brad Hobbs says, show tunes this morning. I'm vindicated. You go, Nick. Hey, thank you. Whale Ears says, you're aware that Mr. Wright and one of the Spider-Mans are black and that Doc Ock and Kim Potter are white? No further questions, Your Honor. Thomas Stein says, just want to say happy birthday to both of you. The 16th is also my birthday. Hey, awesome. And my older sister's. Wow. What happened 9 months before that? Been enjoying listening to you at work, bro. Thanks, buddy. Really appreciate that. I asked that because at my grandfather's 80th birthday, my dad and his siblings were figuring out what major event was about 9 months before each of their births. Like one of them, my grandpa was deploying to Korea, and then 9 months later, baby's born and stuff like that. So Dex Luther says, you have to be a tier 3 simp for law of self-defense. That's right. Platinum level only, baby. How many levels do you have?
Just 2. It's a basic membership is, I think, $10 a month. And then the platinum one is like $50 a month.
There you go. So wait, so if you're a $50 a month member,
you get all the other stuff too.
Yeah, but you mentioned that you get some priority treatment on consulting. Is that?
Yeah, you get all the priority. So we drop everything if you're involved in a use of force event, and we don't charge you for the consult.
Wow.
So,
and you mentioned before that that consult can easily run $10 plus $1,000.
Yep. And part of that is because these cases are extremely fact specific. Tiny changes in fact completely change the legal outcome. So we have to look at everything and just look at the evidence in this case. All these exhibits, all these photographs, all these recordings and videos and interviews, and we read every word of that. Watch every second of every video, usually more than once, and it's enormously time consumptive.
Yeah, and in this case, they're introducing evidence in the 200 range, but they tried to add a couple new the screenshots, the individual frames from the video, and if you notice, those are in the 400 range evidence. That's only evidence or exhibits that they've marked for trial. There's probably another 100 to 200 potential exhibits at least that they have not marked, like the scale, for example. The scale was not marked as evidence for trial, but the scale was obviously in a BCA report. So somewhere in a disclosure form, that scale in a center console of a car is listed. They went through all of that stuff. It takes a ton of work and a ton of time, and it has to be done by a trained, learned professional. You can't just hire somebody minimum wage to go through and find all the important stuff because they don't know what's legally relevant. So
I wish.
It's crazy.
Unfortunately, they just don't know what they're looking for or what the significance of anything is.
Yeah,
so.
You can't outsource that type of work. That's the problem. Mike Doherty says, happy birthday to you both. My wife shares your birthday, Nick. Hey, cool. Lots of birthday friends. Gunnar says, as Lemoyne says, what is your con slut fee? Never mind that. That's a weird attorney down in Texas. Allison S says, Ricada Law, are you going to be covering Austin Harif case? Werewolf man in Florida who ate that guy's face. I may look into it. I wasn't aware of it. Russell Hall says, how much chance does Assange have, in your opinion? I mean, Assange is a prisoner of the state for crimes against the state. And he's been in solitary confinement for like 7-8 years. Is he even conscious anymore? Cognizant of what's going on around him? I think he's done, unfortunately for him. Whatever your opinion of Assange is, the state is out to get him, and that's not a position you want to be in. Principled Potato says, Mr. Recato is fueled by liquor and hate. No need to sleep. Monique says, can Andrew explain the differences between platinum memberships with state DVD and without? Little confused. Thanks so much for awesome job, guys. You kind of did. Was there anything more?
I mean, sometimes we'll run an offer for the platinum membership and throw some additional stuff in, some courses and things like that as bonuses.
Sure.
But I got to be honest, folks, I don't follow that on a day-to-day basis. So I don't know what the current offers are. I would just tell you to go to the website, lawselfdefense.com/platinum to learn about that. And whatever we're offering will be there.
There you go. Nathan C says, Andrew, do you have a DVD for self-defense in DC? Looking at your advanced class and live in Northern Virginia. Thanks.
I don't think we do, unfortunately. I have taught in DC, so we have the materials for DVD, but I don't believe I've recorded it. If it's not on the pull-down list, we don't have it.
Julie T says, yesterday was my 50th birthday. Happy birthday to all the birthday folks. Happy birthday, Julie. Thank you. Thank you. Rain432 says, Nick doesn't have subscribers per se. They're more like evil minions of the Bar of Darkness. B.A. Krim says, I forgot. Are we on cross or direct? I don't know when you asked this, but I'm guessing we were on direct, but that the direct exam also forgot that they were on direct. Eugene says, who's Miles Morales? I know about an iteration of a Spider-Man and Ultimate Comic series, but that's Kilometers Morales. Very good. James Ligon says, it might be better to let the criminals kill me than go through the trial process and lose everything I've ever worked for due to legal fees. Lulz. Yeah, that's the thing. I think if you asked anyone in prison who didn't sell their house because they wanted to afford their lawyer, if they would have rather sold their house, they would tell you, yeah, I wish I would have sold my house.
Yep.
Better to start over free than be in prison.
I mean, the truth is there are not many things that are worse than being in prison. I mean, being dead is one of them. Having your wife or kids die is one of them. But after you get past that, it becomes difficult to think of things that are worse than going to prison. So most of the time, you should not be getting into physical conflicts and firing guns at people.
Yeah. And remember that these prison sentences that we're talking about tend to span a decade or more.
Yeah.
When you're talking about use of force that approaches deadly at all. Anything
especially with a gun. I
Yeah.
mean, firearm sentencing enhancements are the norm.
Yep. Jacob says, so is the state trying to bankrupt the defense by having days of useless testimony? I don't think they're trying to bankrupt them. They're mostly trying to flood the jury with information. But the bonus is that, yeah, it does put strain on the defense. Absolutely. Ryan Alexander says, Mr. Bronco, would CCW Safe cover a convicted felon in the state of Texas? Under state law, we're allowed to have a gun in the home after 5 years of the completion of our sentence. I'll answer for you because I know the answer. I don't know what CCW Safe would particularly cover in a particular state. You have to look into that for yourself. You just know that they're the one that you like the most based on what they offer. So
yeah, you have to read their terms and conditions. I don't memorize those things. If you're asking me if I would work on your case, the answer is yes. I don't care who you are or what you did. You may not want me to work on your case. Because what you get from me is an expert report. And if what you did does not look to me like self-defense, that's what my report is going to say. So most of the time we tell clients in that position, we tell them that up front, that it doesn't look like self-defense to us. And naturally they don't want to pay us to produce a report that says that. But personally, I think everyone's entitled to a criminal defense. I don't really care what you did.
If you want an opinion on what they would cover in that particular instance, because I know there's a distinction between what Texas will allow and what the federal law on firearms might allow. And if there's a Second Amendment question there that hasn't been resolved, perhaps you need to contact them and say, will you do this? Because I think that the language is they won't cover you for illegally having a firearm or something like that. And if that's the case, you need to cover them and contact them and ask them if they would cover you if you're in that situation. And I would suggest get it in writing, maybe even get an additional rider on your policy if you actually do that. That'd be kind of typical insurance practice, especially if you're represented by someone in the state who is competent to represent you on insurance matters. 4low716 says, so I just went to buy CCW safe, but can't in New York. Why? New York doesn't allow them to sell there.
Right.
Short answer. Hiker John says they are drawing this out to punish her financially in case she's acquitted, so everyone knows how much it will cost, so people plea bargain. Jacob says this trial would be better with nighttime drunk Bronca. Nate Casper says this prosecutor looks like Clark Duke from Sex Drive. Silo 101 says Kim Potter yelling "I'll tase ya" is simply amazing. Charles Argo number 2 says, what if he put the car in reverse? The open doors would strike the cops. Yes, the cops are in danger in this, and that's going to likely be part of the argument of the defense, is that whether he goes forward or backwards, they're in danger. David Delsberger, thank you for the donation. Same with R. Bailey. Bone says, isn't what Agent Peterson observes in the video after the fact irrelevant? All that matters is if Officer Potter thought Officer Johnson and Lucky were in danger. Yes.
Right.
Charles Argo says, what if the car was reversed? We just got that one. Tima says, could the officer have been in fear of being drugged backwards by the open door if the car was put in reverse? Yes. SoCal Gunner says, would be awesome to get a... Now, the only mitigating factor is there is a cop car right behind his car, but that probably doesn't
matter.
Doesn't
People
negate the
violently
fear.
escaping in a vehicle routinely crash into police cars
Right.
and all kinds of other stuff. They don't care.
Yeah. So Tima says, could the officer... Oh, wait. SoCal Gunner says, would be awesome to get a reaction breakdown from y'all of the latest video Brandon Herrera just uploaded of Alec Baldwin's negligent discharge, guns and comedy combined. I'll check it out. Not on this show, but I'll check
I don't
it
know.
out.
What is it? Brandon Herrera? Is that
Yeah,
a YouTube
Brandon
channel,
Herrera.
or-
Yeah, the AK guy, Brandon Herrera on YouTube. He's got like 1.5 million subscribers. I think if you look up the AK guy, you'll find him.
Okay, I see it here. All right,
Yeah.
I'll check that out.
He was watching a lot of our Rittenhouse
Whoops.
coverage, so seems like a very cool dude. JJJMMM says, so in 2 of 2 trials lately, prosecutor has violated constitutional rights and played games with evidence. Is this actually abnormal or more the norm? And straight towards that second one. Well, at least let me say this. I would say prosecutors routinely violate what I would consider to be a constitutional right. But whether or not the court fully agrees that they're constitutional rights, I think they give them more leeway than I would.
Yeah, I mean, sometimes it's an ambiguous question, right? Depending on the law and the facts. And of course, the prosecutor's in it to win, and they'll take whatever advantage they can, usually within a scope of what they perceive as ethical behavior. Maybe I disagree where those boundaries are, but usually it's a matter of degree. It's only in these really politically charged cases where you see what I would call just plainly egregious conduct that's well beyond any boundaries or reason.
Yeah, typically they don't have any. They're not on camera. If they win or lose a case, doesn't affect their salary for the most part, unless it's a big, high-profile case. Then their career motivations become very relevant. But on the daily, prosecutors are just trying to do their jobs, and they may make a mistake or they may slip up here and there. But most of the time, and like you said, they're going to take an advantage when they can get it. They are attorneys after all, and they're representing the state as a client. But if they're not out there to flagrantly violate rights, unless they have typically some motivation. So, next says, Bobbert says the door is open. He could be dragged by the door if Dante backs up. He's in the car by that definition. Darren Haviland says, looks like Viva was tased. Get a haircut, dude. Snuggle Struggle says, state prosecutor to jury. Notice just how much money the state has wasted attempting to manufacture guilt upon Potter. Your tax dollars are burning. Johnny Stovall says, Your Honor, we object to this video. Basis of lag. Bogey 34 says, don't forget to send hard covers to Kenosha DA office. Zachary Saunders says, is it possible that the defense allowed the video to be played slowly in the sidebar? Or is this something you would never allow as a defense lawyer? Yes, it's possible to correct. I wouldn't allow it personally. But we don't know what happened at sidebar. They may have objected to it and gotten overruled. Don't know. But if they didn't object to it, I hope they see the message.
The judge's rulings are weird sometimes too. They'll come back from sidebar and she'll say, the defense objection is overruled, but what the state then presents is clearly different than what they had been trying to prevent. So I think it's really, sustained in part, overruled in part.
Yeah.
She gave some direction to the state. You got to narrow this or change that or do something.
Or sometimes the defense may be offering an objection of where they fear the state will go with the next question.
Right.
You say, if they go down this line of questioning, they're going to get into this place that is not appropriate and uncomfortable for us. So we'll object now. And then when they go to sidebar, they say, hey, judge, we're just really concerned that the way they answer this next question will be this. And then that's when the judge can say something like, yeah, state, what are you doing here? Okay, let's rephrase your question in this way to be clear about where we're going. And that could be the answer. I Hate Yankee says, hey, Nick, have you ever considered doing a show on homeschooling with Tom Woods? He might make a good guest. No, because I've never heard of him, but I'm not opposed. Q Revere says 20 minutes behind at 2x speed. Her voice was normal. Can't believe I just texted Gray to tell him it was slowed down. God bless this channel. And DDG. So you texted Earl Grey. Do you have him on in your little book? That's amazing. Thomas Casenza says video was manipulated because her shouts of taser was slowed down, but her screaming I shot him was normal speed. I actually think the shot him was still slow too. Dropping Popcorn says, whatever happened to the criminal being responsible for things that happened while they were in the act of committing a crime? So you're talking about, so Dante Wright's guilty of felony murder of himself, I think is the kind of idea there. Yeah, but just because a criminal is committing a crime doesn't mean that an officer is licensed to shoot them and kill them. Right? Like if someone is stealing a candy bar from a Walmart, a cop shouldn't be able to shoot them most of the time. Should Walmart be able to shoot them? That's a different question to me, but a cop shouldn't be able to just shoot a shoplifter or someone who's trespassing. They need more. Whatever your opinion is, they do under this thing. So just the fact that they're committing a crime means that they're responsible for themselves getting killed doesn't really jive. Scott Campbell, thanks for the donation. Todd Baker says, I bought CCW Safe after Bronco was on Timcast. You get incredible value for $450 a year. Peace of mind knowing you have your back in a defense situation. JK the Slacker says, Your Honor, if you play this video backwards, it's the music video of Nirvana's Smells Like Teen Spirit. Rhino says, can you explain what 4 Doors More Whores? Serious question. I do not get the joke. That was the name of Kyle Rittenhouse's TikTok account. It was 4 Doors More Whores. So it's just been kind of a running
Just trying to
joke.
be famous, bro.
Just trying to be famous. So that's where it comes from. It's mostly inside, but it's just a funny 17-year-old TikTok name, right? Like you'd expect that from a 17-year-old boy. Did you see he liked an image of questionable virtue on Twitter? And you know that Twitter likes are public.
No, I didn't.
Yeah, he liked a booby picture on Twitter. Good job, Kyle.
18-year-old boy likes boobs, huh?
Yeah, it's a shocking revelation. People are freaking out about it. They're like, oh, how dare he? It's like, I mean, not advisable for sure, but at the same time, it's 18 years old. Go for it. Just a Nobody says, during Rittenhouse, the drone video was shown to the jury at 50% speed. What took 4 to 5 seconds to the pointing of the gun was at 50% speed. In real time, it only took 2 to 2.5 seconds. Yeah, at least in that trial, they stipulated that the speed was 50%. Zek says, if states are forced to recognize marriage license, then they should be forced to recognize other state concealed carry licenses as well. I 100% agree. But I also think there just shouldn't need to be a license to carry. And I don't see why there would be a license. We don't have a license for you to speak. Whatever restrictions they may put on speech are not done through licensure.
All this stuff, the concealed carry licensing, the gun background checks, it's nothing but bullshit, people. Because, I mean, when I worked as a diesel mechanic, we'd have in Harlem, New York, we'd have cars come in the lot a couple times a week selling guns out of car trunks. I mean, that's where bad guys get their guns. They're stolen from homes, or they don't do background checks because they wouldn't pass the background check, obviously, but they still have guns, right? So they're getting them from someplace. They don't have licenses because they don't need licenses.
Yep, absolutely. It's crazy. The amount of times you find guns and gun crime being unlawfully possessed versus lawfully possessed is wildly disproportionate. Okay, Scott Campbell says, how much for a self-defense online class with a tieless Bronca?
I don't
Just
think I'd
shoot
make it,
him.
man. The class is like 8 hours as it is. So
Saberjet says, I'll stand in for you. It's no problem. I'll sit there and drink for 8 straight hours while you teach the class. Saberjet says, is it true that if you get into a self-defense situation, the police will take your weapon as evidence and not return it at the end of the case?
almost certainly that'll happen. I mean, if you've shot somebody, yeah,
Yeah.
they're gonna take the evidence.
Yeah, and whether or not you get it back depends on if you're found not guilty, you can certainly petition the state to get it back if they haven't already destroyed it. But a lot of
Right.
times,
I would not count on getting it back.
Yeah.
It happens. I mean, Zimmerman got his gun back, but I wouldn't
Yeah.
count on it.
A lot of times they'll get destroyed, sometimes auctioned or whatever, but you're plan on it being gone. And here's the silly thing. You can spend $600 to go buy the exact same gun, or you can spend maybe more than that suing the state to get your gun back. And you're not going to win fees on it.
Right.
But your lawyer's going to have to draft up a motion. It's going to have to spend time either getting consent from the prosecution or fighting them on a motion hearing. It's probably cheaper to just buy another gun, in all honesty.
Yeah, I mean, I'd ask for it back, and maybe they'll give it back. Who knows? But
Yeah.
if they say no, or they make it complicated, for another $550, $600, you buy another Glock. So
Yeah, exactly. Gunblade Knight says, saw on Fox 9, apparently the taser gun mix-up is somewhat common. Yeah. Also, my friend says that refusing the field test for DUI is a misdemeanor in Minnesota. I don't believe so. I'd have to check. But like I always say, you got to check with your individual states. I don't do DUI practice, and I don't give legal advice over YouTube. But my general advice is to people is to check with their states, but then to the extent that you're able to, refuse things that would incriminate you. But I think the refusal to comply with a test is not the field breathalyzer, but rather the intoxilizer that happens at the station. If you refuse to comply with that test, it is basically the same as a misdemeanor DUI with one aggravating factor. So, and that's still either a misdemeanor or gross misdemeanor. 2 aggravating factors raises it to felony. So, I think that's the statute. QGG639 says, if one borrows money from one's 401k and loses, does one have to pay it back with interest while one sits in prison for life? You never really have to pay back your 401k. You just won't get the benefit of having it later. That's how that ends up going. So, no is the answer. Kinda X122 says, shout out to Joe. Good Logic, who was on Sitch and Adams stream last night. Nick, get off your ass and work out a show with them. We've talked. It's all timing. It's all timing. BA Krim says this case is a prime reason why training needs to be increased for less lethal instructions to include hand-to-hand training and use of force training. Train more with firearms opposed to LLI. Tortheo says, between Bay and New Lady, I want to be a cop now. Dex Deadly says, 1 stars have nothing to do with the book. # reported. Tiki71 says, I think they're saying they reported the 1-star reviews. Tiki71 says, check your Twitter DMs. You have new evening logo screen. I think you and your crew are going to love it. Also, all I ask, throw a subscribe my way. Cheers. I will check. Tiki71. Carmela Picone says, I get why the prosecutor wastes taxpayers' time and money, but why does the judge also allow it? P.S. Got your book from my dad as Christmas gift, Bronca.
Thank you.
The judge allows it because if there's any even tenuous link to relevancy, the judge is probably going to let it in unless it's prejudicial higher than the probative value. I mean, that's the rule of evidence. So even though it's a waste of time, they're going to give them a lot of leeway. They don't want they don't want accusations of prejudice. They don't want to be overturned if the state, if they declare a mistrial or something and the state appeals. They don't want that. So, Jesus. There's another baby in my house screaming loud enough for me to hear it through all of my layers of protection. Russell Dong says, if the pictures weren't allowed to be submitted, then how is pause video different? It isn't.
Yep.
Pancake Turd says BCA blonde found plant material, but I found wife material. Derper says, what is the defense approach going to be with Potter's testimony? Humanize, humanize, humanize. I made a mistake. I feel really bad about it. I can't believe it. I've trained on this. I know other officers that have done the same thing. Fortunately, they didn't, no one got shot when they did it or whatever. Those types of things.
It was all the best of intentions. I was in fear for the lives of my fellow officers. I didn't want Dante to be engaged in a high-speed pursuit. This was the best way of neutralizing that. I genuinely thought I had the taser in my hand. Blah, blah, blah.
That was the worst day of my life, and every day afterwards I've regretted it and felt bad. I pray for his family. I wish to apologize to his family. If I could, I would apologize to them. I haven't been able to because of trial. Anything where she gets to come across as very human, very sympathetic. And I think, again, that I've been saying this for a couple days now, is I think that's the strategy of the defense, is that she probably has sitting at a desk in general, being a union steward or a union rep or whatever, this lady probably has a pretty clean reputation. They're not afraid of what character evidence is going to come out. And they're very comfortable putting her record of service of 26 years up against this one incident and saying, this was just awful. And I wish for the world that it could have been the other way. Yeah. Daniel Harp says in soft mommy judge voice, now don't get brazen with me. Music and Fiction says, as Judge Tiger Mom, don't make me turn this court around. Isn't she just somnically sweet? Oh gosh, you guys need to stop. New dislike button says, Ayo, why is Vector from Despicable Me working as a state's attorney? I suppose the shenanigans make sense now. Scott Campbell says, who does one have to binger to get one's lame joke read? How much for Bronca's online self-defense course? No die. Scott Campbell, I do the $20 plus super chats first to preserve as much of the show flow as possible, and I do the rest later. So 200 Watt Studio says, good to see the Amazons here. Hi, Carrie and Lacey. David A. Hamilton says, we need drunk Bronca moderating right now. Steve C. says, I hope the ladies were properly prepped for the chat. William Barnes says, objection. Defense has not entered Raid Shadow Legends into evidence as the best MOBA game. The objection is overruled. I was paid $10 to send this. UNSC forward onto Dawn says, UK viewer here. Great coverage, guys. Shame about the chat. Seriously, you guys, go take a cold shower. OB Clutch says, Kim Potter actually never pulled the trigger. The gun just went off. Sackett, welcome to paralegal status. Michael Hickson says, is it sometimes better to not object because the judge gets petty? Situational, in my opinion. I mean, they clearly, and again, very experienced, very competent defense team, felt it necessary to keep objecting today to show that what was going on was improper to not only the judge, but the jury. And I mean, the jury is going to sit there and there's a risk that they'll go, oh, this is annoying or whatever. But if they haven't been objecting to a whole lot of stuff and then suddenly they fire off 9 objections in a row and the judge is ruling with them a lot of the times, the jury might be thinking, okay. And it also is just distracting from what's actually being said. That's another thing too. M. David Welch, thank you for the donations. Joshua W., you too. Z. Michael Gelke says, if the jury dies of boredom, it's a mistrial, not an acquittal. That's a win for me, quoting the prosecutor. Stug says, what is your name? What is your job? What is your favorite color? No further questions, Your Honor. Kyle Bogue says, yes, nice Monty Python reference there. Kyle Bogue says, I'll bet Larson's dates last about 15 minutes before the chick is completely bored out of her mind and texts her friends to call and fake an emergency. Fisk the Lomback says, if the taser ain't yellow, you're a dead fellow. Lil Binger says, how can the prosecutor look simultaneously like the child and the molester? Appalachian Drone Flight says, if this friggin' trial suddenly has friggin' sharks with friggin' laser beams, I will finally be amused. Lobster Minion says, more gun safety with a taser than Binger exhibited with a rifle. Dursex says, I think state is attempting to insinuate that Potter could not have accidentally selected the wrong weapon based on how released, i.e. thumb break versus index finger muscle memory makes this irrelevant or relevant. There's 2 R's. I don't know if that's supposed to be irrelevant or relevant with a stutter. Bryant McCracken says, was Taser straight draw? Yes. During shooting, she has papers in her left. Wonder if training covered that. She defaulted to using unused hand. Yeah, we've talked about that a little bit. Irie says, is that Leslie Nope from Parks and Rec? Oh, Carrie. She kind of does look like her. Leslie Knopp. What's her face? Tor Theo says, don't let them take the Hobbit to Isengard. Acquit. Michael Milano. Oh, rude. Michael Milano says the jury just keeps glancing at their Lord and Savior Earl Grey, praying for him to object his way to their salvation. Timothy Reaper says, how much legal weight does the judge's insistence on one-word objections hold? Could it cause problems for the defense? It hasn't. She's been saying one-word objections for the past 2 days of trial. They're going to just keep doing it until she actually says, if you do it again, I'll sanction you or something. But, I mean, there's not like a legal rule for one-word objections. The judge can't say, I'm going to point to Rule 307. You have to do one-word objections. She just prefers one-word objections and would like to hear all the arguments on the sidebar. So that's her preference, and she can try and enforce it. The Adam Project says defense should go, what's in the box for cross-examination? Have someone grab item in box and guess which it is, Taser, Glock, or banana. Adam Trap says cops only put their hands on darker things. Automata says, with the dude's beard, I didn't notice his lapel pin. Yeah, that's not the first time I saw that lapel pin. The other guy had the other BCA guy with the bow tie had the same lapel pin. So might be from the BCA. Stephen Carpenter says, aren't they actually proving the defense's case? Potter did not notice the difference immediately, so accident. The state is not claiming intentional. I mean, the state is claiming intentional force in manslaughter 1. The question is whether that's the taser itself or both. Fist of Lomback says, as long as Alec Baldwin isn't one of the jurors. Philip Dobson says, fine tactile recognition and motor skills is one of the first things to go during a high-stress event. Also, that taser with that shallow beaver tail could cause the hand to block the yellow. Crystal Clear says 17-round mag with the +1 in the chamber. The weight of the firearm is only representative of post-shot fired and not relevant to judgments made in the moment at question. Just going back to the taser, I'm just shocked that the taser is not entirely yellow or entirely magenta or something like that. There's no reason to have a black grip or a black top part on that taser. The previous models were yellow through the entire grip. Why'd they change it? B.A. Krim says, here comes the lawsuits against Taser. Should never have a similar grip to a gun. Taser will probably be named in this lawsuit, in the civil one. Matt Hutchinson says the jury can obviously hear them talking during sidebars. So why are they talking on headsets? Just so the cameras can't hear? I don't know that the jury can actually hear them, honestly. Kyle Wells says she pulled the right taser, not the right taser. Crusader says between Paul Eng, Earl Grey T, Chauvin's lawyer, and Nick, it seems like Minnesota defense lawyers are just built different. Just built annoying, I think. Sharp-eyed Watcher says Ricada uses Binger's FLIR video to show Rosenbaum start chasing Rittenhouse while he's carrying the fire extinguisher. Rittenhouse not guilty, 100%. Fed Up With Your Crap says, side note, SCOTUS just rejected the New York religious exemption vax mandate. What's the difference between an emergency bid and an actual lawsuit? I have no idea what the Supreme Court just did there. I haven't read it, so couldn't tell you. Kim Campbell says, will anybody cover Billy Joyner's case? I don't know who that is. Dursek says, Nick, please ask Andrew to make his book available for retail at gun stores and ranges.
We've tried that in the past. It doesn't work. People who go to gun stores don't buy books there.
Yeah, if you could buy a $30 book, why wouldn't you just buy another box of ammo?
Yeah. I mean, you know, I think most gun owners aren't really interested in reading, or we'd be selling 10 times as many books. But
Alan Rees, welcome to Paralegal. Kyle Bogue and Mike Doherty, welcome to Super Lawyer Status. And Neil Conway, welcome to Lawyer Status. Thank you. Alan Rees says, what did the two pretty Amazon ladies think of Kyle Rittenhouse's court case? I think they're probably in a similar boat to most of us. Cat Whisperer says, I may be wrong, but didn't she spend 20 years as a dispatcher or something and decided to become a police officer not too long ago? She was a police officer for 26 years. The amount of time she spent in the field is seems to be not much and is in some gray area right now. I don't know the answer to it. Joseph Berger says, now, officer, during the course of your investigation, did you have anything to eat? Hot dog. The state now calls Sal the hot dog vendor. George Michael says, WTF is the point of any of the stuff the state is presenting. Wacko Guy Watch says, negligence was grabbing the taser. Recklessness was aiming at eye level, not seeing and still shooting it. One, I don't know that she aims at eye level. The gun seems to be at chest level or waist level from the body cam. Second, that might be recklessness if the jury determines that she did in fact see the gun and was conscious of it. And the jury may do that. The jury can find recklessness in those facts. The question is, will they? Don't know. Flamethrower says, test the prosecutor's DNA to see if he's reptilian. Streaky says, this is a problem with lawyers billing by the hour. To be clear, the state attorneys aren't billing by the hour. They're salaried employees. They get paid the same if this trial takes a day versus if it takes a year. Automata says, Nick wants to say he's a master of DNA collection. True. Chain Breaking Sage says, ribonucleic acid or DNA. Oh, okay. Gotcha. Caligula says, another news, water is wet, yawn. Mirage says, is it entirely possible that the defense is letting this Jeremy Renner lookalike proceed with this because it's pissing off the jury as much as us? I think most of the time they're just not. I mean, he's doing okay. It's just in particular areas or lines of questioning where he gets out there. Avahine says DNA was present, semen all over the crime scene. There's always semen at the crime scene. Nick, you're such a noob. Do you even practice law, bruh? Arball says, and then let's move on from this witness. My God. A Bear in the Woods says, drinking game. Drink every time the state calls an irrelevant witness. Please don't. Please drink responsibly. Jide says, it might be worth asking the jury to think of every time an employer ever gave them training that amounted to a box ticking exercise and then imagining their actions could have lethal consequences. Yeah, I think they're going to probably downplay the nature of the training in closing argument. That's most likely going to happen. UNSC forward under Dawn says, maybe the strategy is to bore the jury into submission. Arball says, closing argument, the deceased drove a Buick, which clearly shows terrible decision-making skills. I end my argument. Dursex says, Nick, does this open the door for defense to inquire about Wright's toxicology? Yes, and they did. Marijuana. Mirage says, is a prospective juror allowed to say and ask, I've seen Rittenhouse and Potter. Will this prosecutor do the same bullshit in this trial? Well, I mean, jurors could ask that, sure. Hossip says, I think the state is trying to sabotage the government from the inside. They're wasting the time of as many BCA agents as they can. Avexine says, the first guy testified there are 100 BCA employees, so we only have 85 witnesses left. Streaky says, I'd be so angry if I were on the jury and not willing to do the prosecution favors for this. If you have an actual case, make it. Two Golden Baby says the prosecution is lucky that I'm not on the jury. I say not guilty based on the wasted hours of my life that I can never get back. Rick Van Luvender says, how does this incorrect collar size affect the ability or credibility in the eyes of the jury? Michael Hickson says, does Cartridge Boy look like chubby Chris Pratt? Gunner says, is your board examination board certified? Stephen Cannon says, are these witnesses being paid as experts? No. The BCA witnesses are not going to be paid as experts, I don't think. Corrections 101 says, I had a great discharge last night. I'm bored says they retrieved a Glock 7. It's a porcelain gun that doesn't show up on airport x-rays and costs more than you make in a month. Quote John McClane. Jim Leverett says, meanwhile, all these irrelevant witnesses are costing Kim Potter $1 zillion a minute. This in itself seems like prosecutorial misconduct. B.A. Krim says they are using all this to say she should have known the difference between the two, and that makes her guilty. Correct. Judas Goat Barbecue says, breaking news, defendant's taser used on Potter trial to prevent death by boredom. Some spectators in the courtroom were not so lucky. Film at 11. Wrestler Sound says, do prosecutors just think that juries are so stupid that the juries demand to hear about DNA in order to convict ever since OJ and Jurassic Park? DK says, done by Christmas, the judgment BCA witnesses. Dan Richards says, is this a joke on the ADA? The other ADAs didn't tell Kim, tell him Kim has admitted to firing the bullet. He's trying to prove something not in dispute. Molon Labe says the firearm lab tech barely had more specialized ballistic testimony than a standard hunter and firearm safety booklet. Jonas Wheel the fourth says, so if she recognized the trigger pull for the Glock was too much, was she supposed to reholster the Glock and then grab the taser? Gonfall says, how are you going through this hell? Same way you are, Gonfall. Jeffrey Grajic says the trigger pull has no bearing until after the trigger is pulled, and by then, who cares? Damage has been done. Chain Breaking Sage says the only thing they're proving right now is that the government spends a lot of money. You're on here. We paid all these people to point out the obvious. Oh, Your Honor. We paid all these people to point out the obvious. Arball says Lacey looks like Harry Potter's sister, and I'm here for it. Hashtag simping. Britt Cormeyer says 4 days of testimony that could have been accomplished in a day and a half if they stuck to the facts and key witnesses and not every cop that ever walked down the street that day. Yes. Brandon Lesko says, I stand corrected. Her old taser model was probably way more yellow than the new model. Also, with the straight draw, you don't see much, if any, yellow on what's visible to you. Correct. And her Officer Lucky, you can see her old model. Officer Lucky has it in his holster, all yellow, whole thing. Nabor says this panel is in 30 minutes has spent more time discussing the actual taser gun incident than the prosecution has in 4 days. Scott Fitzpatrick says if Wright pulls the car in reverse and all officers are in jeopardy. Blue-Eyed Roof Curry in the base says media insisted cop lady was racist. Evidence when. Jason Rivera, thanks for donation. Robin Sage says, call me a simp. I want to be Lacey's next ex-husband, a cutie and smart. Chief of Beef says, you are a simp. Chief of Beef says, do attorneys ever close with how much the opposition wasted the jury's time? Sometimes. Yeah. They say we wasted.
They did it on opening.
Yeah,
we're got up there in opening and said, I don't know why the state just talked for an hour, but I won't take half that much time.
Scott Shook says, spark test. You remove the cartridge with the probes and fire the taser where it sparks. Bishop Craig says, firearm taser draw ratio in training about 500 to 1. So you draw your firearm 500 times for every one time you draw your taser in training, according to this person. Danette, where are we? We're almost done. What do you think of Kim Potter's taser looked like before the one she was issued 2 weeks prior to the shooting? I'm curious what she's used to. Solid yellow. Boomer Wow says, I wonder how many cops almost pull their gun and then fix themselves because they had time to think. She had like 5 seconds. Jason Revere says, the main reason an officer announces taser before firing is to prevent sympathetic gunfire from another cop who thinks that it was a gunshot. You won't get shocked unless you're touching between the probes. Reagan Virostek says, if the jury will have a taser in the deliberation room minus the battery, should the defense ask for weight equivalent to the battery to be added? Maybe.
Sure.
Maybe it'll have a battery that's discharged. Who knows? Distro 32 says Officer Potter saved Dante Wright from a life of crime in prison. Bladed Cloud says, in my city, we had a lawyer who allegedly dealt in prostitution and drugs, and I believe he was arrested and disbarred. Risuno Kairu says, speaking of pointing guns, when will the prosecution sweep the jury with their pistol? Schwizzy Nut says, the sum of prosecution in 3 words or less. Waste of time. Soul Fiend says, well, clearly he didn't get the interior clean. Did you see the state of it? Liren says, happy birthday. Hey, thank you. Humi says, I'm disappointed. Defense did not ask if the taser was in stealth mode, in which case no flashlight or targeting laser. Oh yeah, I guess that would have been the person to ask. Yeah. Todd L. Cole says, taser policy that was read said should test before each shift. Is should a requirement? Well, we would know if the investigator in charge of investigating whether or not she did something improper would have investigated by asking what the common policy is in Brooklyn Center, but he didn't. Callum Lane says that tweet Kyle liked was a Photoshop troll, by the way. Didn't actually happen. I'm not so sure. I thought I knew someone who checked, but maybe not. Silo 101 says 4 doors, more whores is because he has a 4-door truck. Lady Mondgarin says, why did / does the media keep saying Kyle's a member of the Proud Boys? Is there any evidence of this? No. And if
Nope.
he is he a member or just affiliated? I don't think Kyle Rittenhouse sat getting punched in the face while naming 10 cereals, 10 brands of cereals, or committed to not masturbating. So I'm pretty sure he's probably not a member of the Proud Boys, but maybe he is. I don't know. But the only evidence was that he was at a bar where some other Proud Boys were also at a bar at the same time, and they spoke briefly. No indication that he knew who they were or that he has any affiliation beyond that. Zygenfuss, thank you for the donation. He also says, for an idea of the offhand mental invert, write your name backwards with your non-dominant hand, and black handle is tactical and sells better. Cameron Nelson says, seems like Binger will be the standard for every prosecutor pun going forward, and I'm okay with that. Carry out the ridicule whenever deserved. And finally, Kirill Ragazin, thank you for the donation. Let me just double check that there's nothing else on Odyssey. Correct. We are good. All right. That's the show. Andrew.
All right, Nick,
anything you
thanks
wanna
for having
say?
me on again. I appreciate it.
Absolutely. Anything you want to say before we peace out of here?
Sure. We got free books, lawselfdefense.com/free book. We got hardcover books, lawselfdefense.com/get hard. And we have our January 8th full day, Saturday, January 8th, Law Self-Defense Advanced class. That's at lawselfdefense.com/advanced. Come one, come all.
Well, there you go, guys. Thank you so much, Andrew. Thanks for hanging out with me today. It makes
My
it
pleasure.
way more fun with another person. And guys, tomorrow, 9:00, I'll be back. See you guys then.
Take care,
Peace.
guys.
Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes madder, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed, to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Loverock. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter, as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed, to make the law what we have now. Oh, the guests are all planet folks, from Dundee to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter, as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the